Here. All right. It's almost the end of the month. Chaos reigns, ladies and gentlemen. Chaos doth reign. And as we welcome the Towel friends over on the YouTube, again, my name is Grant Smith Ellis. It is so good to see you today. You know what that means. Roll the intro.
Hold on. Wait a second. That's it.
That's it?
Yeah, that's the melody to Funky Town.
You heard the little towel. That's it. There's a melody to Funky Town. Look at me. I'm a little towel. I'm a professional towel. I have my suit on. We are going to do social consumption regulations today. And I'm going to be a little towel. Now, that may mean I want to go on a little towel soliloquy. I don't know. You can't just channel a muse. I was actually reading last night about Noah, the guy who built the ark. And I was reading about his sons, Shem and Ham, although I thought the second son's name was Sham, not Ham. But either way, the point is, I was reading about Noah last night, as one is wont to do when they're thinking about the sort of larger historical framework upon which human beings doth merely paint their canvases with their respective lives. And I was thinking to myself, James Joyce has this very interesting way of explicating Hegel and Vico's historical form. Now, debate all you want about whether, advances in modern society reflect an emergence from a Rousseauian utopia or a Hobbesian state of omnia contra omnes, the war of all against all. We can set that aside. When thinking about the historical form, Hegel nailed it, okay? Whatever you think about the state of nature, thesis plus antithesis equals synthesis, okay? That is the historical form. You can analyze everything in human history based on that form. So I'm kind of learning about Sham and Shem and Noah, and I'm thinking a little bit about the Finnegan's Wake, and then I'm thinking about yesterday's developments in the Aiden TurtleBoy Kearney case, all right? And I'm thinking kind of about how the overarching mosaic fits together here, because I think it's impossible to understand the nuance of all this in a simple soundbite. And that's what I think kind of betrays the latent vacuity of the modern public arena and modern journalism in particular. People really strive for getting attention, like short attention span hits. And that undermines the pursuit of cogent public policy, the integrity of our representative form of government, and the justice system. So, yesterday, when the Norfolk County District Attorney's Office announced that they were dropping the null processing, is the formal term, 2 charges against Aiden Kearney involving Lindsay Gattani, my mind just it started bringing together all these disparate tracks, and the historical mosaic that is being painted is one of such insidious rot throughout Norfolk County, and that circle of people surrounding the DA and Brian Tully and Kate Peter and Jen McCabe became so insidious that we saw, in my opinion, the Norfolk DA, who is recused from the TurtleBoy cases, instead of complying with a court order by Judge Doolin on September 25th, 2025, to appoint a special prosecutor or bring on the Attorney General to the Lindsay Gattani cases involving Aiden Kearney, just null-pros them. And it makes you wonder, folks, is the reason that null-pros happened because some of the things that Brian Tully did during the investigation of Aiden Kearney, in particular on April 24th, 2024, by releasing an unredacted production of Lindsay Gattani's cell phone extraction, with only messages from Brian Tully to Lindsay and from Kate Peter to Lindsay removed. Is that why the charges were dropped? And if so, was Michael Morrissey, who had Brian Tully as the head of that unit assigned, the state police unit assigned to the Norfolk DA for however many years, is Michael Morrissey in a position to make an independent judgment while he is recused as to whether these cases should move forward? That's what this is about. The rot is so pervasive. These cases, the investigation of Aidan Kearney and Karen Reed, whatever you think of the merits, it was so corrupted. I'm talking about the WI, witness intimidation cases, starting fall of 2023, maybe a little bit earlier. It was so corrupted by the involvement of Kate Peter, a former colleague of Aidan Kearney, by Brian Tolley, and others. For multiple reasons, folks. For multiple reasons. That these cases were never going to be able to go to trial. We talked about this before on this stream. I'm not a lawyer. This is not legal advice. But when you think about it, the exclusionary rule, that's the punishment when state actors, like police or private eyes working for police, do bad things in the context of an investigation, like mishandle evidence, delete evidence, otherwise, okay, engage in ex parte communication, engage in favoritism, whatever it may be. Okay? It's disturbing. It is simply disturbing that we've gotten to a point where there are no checks and balances on that kind of behavior. Michael Morrissey should not have been able to make the decision as to whether or not these cases should move forward. There are no systemic checks and balances to ward off those kinds of conflicts of interest because of the wide scope of prosecutorial discretion. I have done a very lay towel study of the various statutes in Massachusetts, okay, around the country, related to special prosecutors. There's 40 states out of 50 that have some kind of enumerated process for the appointment of special prosecutors. I'm going to guess most of this relates to the post-Watergate era, all right, because of the Saturday Night Massacre when Richard Nixon fired Archibald Cox. Now, that didn't work out for Nixon because Leon Jaworski came in, even though Jaworski was a Texan who Nixon thought was going to be more favorable to him. Jaworski came in and just rained hell down on all of them, all right? The replacement special prosecutor in whatever it was, 73 through Nixon's resignation on August 8th, I think, 74. Anyway, the point is, so Richard Nixon discharges, of course we're going back to Watergate. Towell loves learning about Watergate. Richard Nixon discharges, and you really have to understand this to understand what a special prosecutor is and why this term on the federal and state level started to come up to begin with. Now, I'm pretty sure it actually goes back to the Teapot Dome scandal in 1921. It might actually go back to the Credit Mobilier scandal of the, 1880s or something. That was a very interesting scandal. But I think it really started in Teapot Dome under Coolidge, I want to say. There was some shenanigans that went on there in, the entire administration. So this whole idea of a special prosecutor really emerges onto the historical scene after Watergate, all right? Because Nixon discharges Archie Cox. Archie Cox was like a Boston Brahmin, like a really vociferous, Kennedy Democrat. And you got to understand, the Kennedy Democrats in particular hated Nixon because they blamed Nixon for Johnson and other right-wing elements of the Democrats basically taking Kennedy out. So Nixon was hated. He was hated by the Kennedy loyalists in his own administration and then also elsewhere. And Archie Cox was a Boston Brahmin liberal establishment Kennedy Democrat who was tearing apart Richard Nixon's administration by going after G. Gordon Liddy and E. Howard Hunt and the rest of the Watergate burglars and got what was his name? John Dean, to cooperate with the Senate committee led by Senator Irving in the summer of 73. So anyway, after the Irving committee hearings, the summer of judgment hearings in 73, you get the Saturday Night Massacre. And I think it was in October of 73. And Richard Nixon fires Archie Cox because Archie Cox is investigating Nixon and he's going to enforce the subpoenas to get the Watergate tape showing Nixon knew about the break into the DNC. They actually broke into the Chilean embassy as well and some other stuff, but it was all very covert CIA stuff, and I don't want to go into that right now. Anyway, my point is, so that's the origination of the special prosecutor kind of concept on the historical scene on the federal level. Post-Watergate, you get all these kind of reform hearings. You get the Church Committee hearing in 75. You get like the special prosecutor statute on the federal level. And what they basically, now mind you, I don't want to go too into this, but after, I want to say like the 90s, after Ken Starr or something, maybe after Bush, they reformed on the federal level the special prosecutor statute to have less independence. Or I think more what it was like the special prosecutor statute that existed after Watergate, like sunset in 99 or something, 1999, and they just never extended it. So then it became like a different form of a special prosecutor statute that's a little different than the model that was established post-Watergate. All of this is very important to understand because we're crescendoing up here to what I think is the fundamental problem and what this decision yesterday to null pros these cases really reflects. So anyway, the special prosecutor statute, as we know it today, it doesn't exist in Massachusetts, okay? It exists as a federal CFR. I was just reading about the Code of Federal Regulations related to special prosecutors the other day. I want to say it's like 106 something. I don't remember offhand. Anyway, so you get that, and you get the special prosecutor statute on the federal level. Then you get 40 states who, between 1973 and today, implement some form of a special prosecutor statute. Now, what are we really talking about here? Well, we're talking about when the DA, like a local district attorney, has a conflict of interest or is ordered off a case, they no longer can prosecute. They have to bring in a special prosecutor. Well, do you know what happens in Massachusetts under, I think, I don't remember the exact statute. I think it's 230A and 230D. But anyway, the DA retains complete control, even if they're recused. They can basically they're in charge of the special prosecutor that they appoint because of their own recusal. That is not what it's like in most states, okay? Most states have a codification, a structure for what happens when you need to appoint a special prosecutor or when the court orders it. Here's why states do this. Okay, so prosecutors have a lot of latitude under prosecutorial discretion to make decisions. Two things can butt up against that discretion. One, constitutional separation of powers, like the legislature telling prosecutors they can't do certain things, or the court's inherent power of what's called law and equity. Well, the law is written by the legislature. The court's inherent equitable power comes up in this context because a court, and I've seen this before, a court can, on its own volition, reject a prosecutor's decision to dismiss charges or something and then appoint a special prosecutor. Now, to avoid this sort of ad hoc hodgepodge structure where judges by fiat are appointing special prosecutors, 40 states, according to my research, have adopted some kind of special prosecutor framework for when this structure kicks in. It's not just the discretion of the DA or the court intervening on its own accord and appointing a prosecutor. That's a little chaotic. And it leaves a lot of room for interpretation. You don't want that, in my opinion. What you want is a statutory codification saying what has to happen when there's a conflict of interest that results in recusal, all right, of the DA. So there's the majority rule, which is 25 states, and then the minority rule, which is 15 states. I think the majority rule is embodied by Connecticut. They're like a statute in Connecticut and an executive order 110223, I'm pretty sure, in New York, okay? Now, the minority rule is embodied by, I want to say Hawaii, and then one other jurisdiction I don't remember. Now, the bifurcation in this structure on the state level is a lot of them take inspiration from the Watergate-era reforms to the federal special prosecutor statute. But what we're looking at here is more, how did they interpolate that federal structure in line with constitutional protections under the 14th Amendment related to due process and balance of powers under the Constitution to create a legitimate or constitutional framework for the structure of a special prosecutor appointment process. Now, what I think a lot of these states miss, some of them did a good job, some of them did a bad job. A lot of them were very ideological with how they went about doing this. You could see a lot of the reforms to the special prosecutor process on the state level came about after 2014. So it was a very politically charged climate that narrowed in on specific issues, in my opinion, and missed the forest through the trees, all right? But that's, and what I mean by that is it attempted, these the first batch of special prosecutor statutes happened post-Watergate. Those are the best. Then you had like another round of it post-2014 that was very ideological and mostly just driven by hatred of cops. That was not very good. But those are the two kind of eras of special prosecutor reform in terms of how the concept functions on the state level. That's my understanding of the history. Okay, but both of those eras miss something really, really fundamental, which is you don't necessarily reform the special prosecutor process because of executive overreach in a silo. You don't necessarily reform the special prosecutor process because of police misconduct in a silo. You have to understand the amalgamated, overlapping, concentric social circles of influence which permeate and facilitate the structure of the justice system in order to reform it. Now, what do I mean by that? What I mean by that is a prosecution as a concept involves a litany of different actors. And I mean, then there's going to be the actual district attorney's offices, okay? Now, here's the insight about this. If you're going to have a recusal statute or a special prosecutor statute, you must think about the intermesh networks and how soft power dynamics function in the judicial system, in particular within the larger governmental apparatus, the appointment process, who knows who, how small the bar is, how this sort of system functions, who's worked in what office for how long, how the different courts, the probate court and family court and the criminal court and the civil court and the land court, and how all these different offices interact, okay, across counties, sometimes so horizontally across counties, vertically across agencies, how it intermeshes with different federal apparatuses. You have to understand this all because what you're trying to do is check and balance not just specific examples of misconduct, but the entire web of potential misconduct that could undermine impartial prosecutorial discretion. Now, you don't write a statute that says we need impartial, independent prosecutorial discretion. No, you write a statute that kind of intentionally wards off the behavior that undermines impartiality, okay? And so that's why I think reform to this is so important, because bringing it all back, just last week in Dedham District Court, we saw the Norfolk County District Attorney's Office involving a case where Kate Peter is a named criminal defendant in a felony charge. Kate Peter, the private investigator who knows Brian Tully and Jen McCabe. All right, we saw Kate Peter. We saw the Norfolk DA in a case where there was a special prosecutor, okay, for months, go to a judge, and I'll play you the clip, and say, Judge, we'd like to have these charges dropped. And the judge said, wait a minute, wasn't your office previously assigning this to a special prosecutor? Why are you here today? Why are you trying to sign this green sheet or a plea agreement? And the ADA said, I don't really know, I'm not sure. And judge rejected it, okay? So here's what I mean by that. When the Norfolk DA, in light of a glaring conflict of interest, tried to ignore that in a case where there was a special prosecutor in order to make a plea deal with Kate Peter, a judge intervened in Dedham District Court and said, no, you cannot do that. Now, we get a situation where when we're in Norfolk Superior Court, to avoid having to go before Judge Krupp on December 5th and explain why or what steps were taken to find a special prosecutor or to ask the AG to appear, instead of dealing with any of that, instead of having to answer to a judge like happened in the Kate Peter case in Dedham District Court, the lack of statutory framework addressing special prosecutor appointments allowed Michael Morrissey, a recused DA, to personally just drop the charges, despite the fact that Morrissey and Tully, his longtime head of his detailed state police unit that investigates for him, despite the fact that they had the biggest interest in covering up the leak of Lindsay Gattani's phone extraction, which happened in the context of this very investigation. You cannot have a prosecutor who's recused, who has a glaring conflict of interest, who has an incentive to cover up what Tully did in the context of these criminal cases, making the call without any court supervision, without any legislative check and balance as to letting these charges get dropped. It's an egregious violation of the principles that undergird our justice system. It's a disgrace to our democratic system, whatever you may feel about the underlying facts at issue in the case. The procedural injustice wrought upon that woman Lindsay Gattani entirely unnecessarily because of Brian Tully and Michael Morrissey's conflict of interest disgraces the Commonwealth of Massachusetts. It's a scar on the face of our courts. It's a scar on the face of justice. It will leave a legacy of agony and harm that will litter this ungodly battlefield with the unheard screams of innocence for decades to come. It will cause generational trauma, and the people who did it don't even care, because they can go to bed tonight. It's nonsense. It is wrong. And it fundamentally comes down to an abuse of the process. I don't care if you support TurtleBoy or don't support TurtleBoy. I don't care if you support Karen Reed, don't support Karen Reed. What's at issue here is the system itself. And if you've been crying out for years that this county is corrupt, that these people are corrupt, then now's the time to speak up. Now, I see some of you doing it. I see some of you staring down the fact that this, whatever you may think of the underlying merits of these charges, this is the kind of corruption. A recused DA making the decision to drop these charges despite a glaring conflict of interest and potentially to protect Brian Tully rather than seek justice is the very thing that people have said has rotted Norfolk County from the inside out over the past 2 years. My name is Grant Smith Ellis, and that's how I really feel. And we'll watch that hearing from Dedham District Court, and we'll watch why I think, oh, hello, Irene, it's good to see you, and we'll watch why I think, in particular, Michael Morrissey didn't want to have to go before Judge Krupp in December, because he would have been told, and his office would have been told, no, Michael Morrissey. No, you cannot make decisions when you have this kind of conflict. You are not a towel. All right. This was the statement from Lindsay Gattani. Then we're going to watch the video from Dedham District Court. All right. So this was the statement released yesterday from Lindsay Gattani. Yes, yesterday, after the decision came down. And if you haven't read the news articles, Boston Globe, Boston Herald, Mass Live, every single written publication, Yahoo, Lindsay's statement and Lindsay's words are in there, so you can take a look at those articles as well. But let's just read the statement itself, okay? So this is from Lindsay Gattani. On September 25th, 2025, Judge Doolin from Norfolk Superior Court was assured that a new special prosecutor or someone from the Attorney General's Office of Massachusetts would appear on Lindsay Gattani's cases, she said at the December 5th, 2025 court appearance before Judge Krupp. When I, Lindsay Gattani, found out today that instead of complying with the court's order, the recused Norfolk County District Attorney, Michael Morrissey, made his own decision to simply drop the charges, I was incensed. While investigating these very cases, demoted, love it, Massachusetts State Police Lieutenant Brian Tully intentionally released an unredacted copy of Lindsay Gattani's cell phone extraction covering 15 years of protected material, attorney-client, and of protected medical, attorney-client, and personal information. Demonstrating Tully's intentional conduct, only messages from Tully to Lindsay and from Tully's private investigator, Kate Peter, were removed before the unredacted extraction was turned over and eventually made public for the entire world to see. At the time Tully obtained my phone extraction, I was promised by the Norfolk County District Attorney's Office that my phone extraction would be redacted to protect my privacy, dignity, and safety before the extraction was produced in discovery pursuant to Rule 14. Michael Morrissey, due to his direct relationship with Brian Tully, was in no position to make this decision. As a result, I, Lindsay Gattani, am calling for an independent investigation by the Attorney General's Office to determine what, if any, efforts were made to comply with the court's order before these charges were dropped. The special prosecutor process in Massachusetts is fundamentally broken, and today's decision is a battle cry for reform. Hear, hear. Hear, hear. So that was the statement from Lindsay Gattani. Yep, he's definitely not a towel, Irene. Morrissey is not a towel. But yes, I want to watch this hearing from Dedham District Court, all right, last week. Let's just watch the hearing in full. I got it up on my... do I have the whole thing? Yeah, I think I got it up on my towel channel. You know, I think I actually have it up on my towel YouTube. Very rarely do we get to watch a towel video on towel YouTube, but I think I think I have this one, so give me a second. If you're just tuning in, my name's Grant Smith-Ellis. We are talking about the astounding developments, ladies and gentlemen, overnight related to the Aiden TurtleBoy Kearney cases, including a very weird series of developments where the Norfolk DA, Michael Morrissey, despite being recused, made a decision that has...
Did you know your retainers can cause filling?
I'm playing a video on my own channel and it has ads. But, you know, I have my ad blocker off on YouTube. I like to support my fellow creators. Sorry, that was an ad playing. But yes, if you're just tuning in, a very astounding decision by the recused Michael Morrissey to drop charges involving Aiden Kearney. I say astounding because Michael Morrissey has so many contacts, and we're going to come to find out. It came out overnight. Kate Peter, the woman in this video, who Michael Morrissey tried to sign a plea deal with his office just last week, we're going to find out this woman had Michael Morrissey's personal cell phone number, ladies and gentlemen. All right, so let's take a look at this. Give me 1 second. All right, let's take a look. All right, so this is exclusive towel footage, okay? I am a towel, and that is me behind the camera. And you're going to hear me asking Kate Peter why she was involved in the leak of Lindsay Gattani's cell phone extraction. Kate just kind of yells things at me. And then I compliment her by saying she doesn't look like Shrek. You know, I'm a friendly towel. I try to be nice, you know. I'm just a little towel. All right, let's listen. Have you considered that you're a towel? Oh, all right, come on now. All right, let's go. Miss Peter, why did you and Brian Tully release Lindsay Gattani's unredacted cell phone extraction? You have so much to say online and so little to say in person. Well, at least you don't look like Shrek today. That's a positive, right? We're trying to be nice. God bless America. Kate Peter released that phone extraction and you're so cowardly you won't even admit to it. You don't represent victims, you hurt them to help your friends. It's shameful. And that's why I use blocks instead of addressing it. Listen, you want to be cowardly, I'll say it to your face. Just did. We'll see who has the last laugh.
Yes, Your Honor. Speaking to the defense counsel, it seems that the previous special prosecutor was the Plymouth County prosecutor. He was on works in Plymouth County. I understand that he and defense counsel had previously worked out a recommendation. I'm asking for a second call to speak with my supervisor to see whether or not my office will be adopting that recommendation as well. That is correct.
Okay, we'll give it a second call.
Thank you.
Further comment, have a seat.
Okay, before we get to the agreed upon resolution, I have a few questions, and I'm going to start with the Commonwealth.
Yes, Your Honor.
This case has never been before me, so I don't know the whole history, but it is my understanding that this case was assigned to a special prosecutor out of the Norfolk County District Attorney's Office. Is that correct? And is that because there was a conflict?
Well, this was just a hearing something else. So yes, Your Honor, this is
And so it was assigned to an ADA out of your office for a conflict of interest.
yes, Your Honor.
And is the conflict gone?
No, I'm not quite sure, Your Honor, to be perfectly honest. This is a situation where, it's not also always necessary that there is a conflict. It could just be an appearance of conflict as to why cases get special prosecutors. To be perfectly honest.
Now tell me, is Kate Peter directly speaking to the DA for a year or more? Is that an appearance of conflict or a conflict? You know, I am not a subject matter expert. I am not a lawyer. I'm a towel. But, you know, the word conflict seems to have, or conflict of interest, seems to have a lexical definition. Now, we can go into Black's Law Dictionary and debate the semantics, but I think if we use the reasonably prudent person standard, if we think about statutory construction and what the word conflict of interest may mean, is having a year or more of direct conversations with a PI who's handling evidence and working with your lead investigator directly, and who knows Jen McCabe, who's a witness in 2 major high-profile cases your office is prosecuting, is talking to that person on an ex parte basis routinely as a DA in line with the rules of professional conduct 3.8 in particular, and furthermore, is it a conflict? Now, you could argue, all right, I don't know whether it's about 3.8 violation, that's not really the point, but is it a conflict? When the woman is charged with a felony, Kate Peter is charged with a felony in Morrissey's jurisdiction, and he's got his ADA up there being like, it could just be an appearance. I don't know, Your Honor. I looked up at the sun one day, and then I looked down, and I couldn't see. It could just be an appearance of me being blind. Oh, goodness, God help America.
I wasn't party to the decision assigning this to a special prosecutor, so that's not something that I, at this point, can answer.
So at this point, if I just want to make sure I'm hearing what you're saying correctly, you're not sure whether the Norfolk County District Attorney's Office has a conflict.
That's right, Your Honor. I'm not sure.
And yet you're going to fill out a green sheet.
Yes, Your Honor.
But there may be a conflict of interest.
Your Honor, if I can, Your Honor, the reason being at least is that this is a situation where this is the recommendation that was made by the previous special prosecutor, and so that's the reason why the Commonwealth is putting it forward. But Your Honor, this is something you think could benefit from a third date, but that's
If my concern is if the Norfolk County District Attorney's Office has a conflict of interest, I understand that there may be a reason why the parties are needing to resolve the case, but if a prosecutor who is not in your office has been answering on the case and unfortunately is unavailable today, that doesn't get rid of the conflict of interest. That's my concern. And at this point, what I'm hearing from you is the conflict still exists, as far as you know.
right.
And is there anything you'd like to say about behavior?
I've spoken to the Michael Conley on this, and we found out the special prosecutor left it on the DA's office. And Michael Conley is familiar with the similar case that he's serving to court. Disclosed our same
With your client or somebody else?
Same charge. So that means
with a special prosecutor.
A special prosecutor. So we always have we were going to disclose this consistent with the Stowe District Court. So when I reached out to A.D. Conley, he did not believe that there was a potential conflict to resolve this at this stage. So I believe my brother also had to check with their office.
My concern is if your office felt that there was a conflict of interest and assigned it to a prosecutor outside of your office, even if this was the recommendation of a special prosecutor, I have concerns about your office then doing, even though it doesn't require a colloquy or an admission of any sort, I don't see how it's still not a conflict today. So, and I'm not hearing that you two can tell me for some reason that there is no longer a conflict. So with that, I'm not going to accept the green sheet if I'm concerned about the conflict of interest.
Now, do you see the point that I was trying to make earlier? When the Norfolk DA had to go up in front of a judge in Dedham District Court involving Kate Peter, right? And Kate Peter's also involved in the Aidan Kearney case and the investigations of Karen Reed. Okay, she's in the discovery. When the Norfolk DA to go into Dedham District Court after the special prosecutor on Kate Peter's felony cases resigned or left the Plymouth DA, The Norfolk DA was forced by this judge to not be able to submit the plea agreement. Now, I was pointing out earlier, the remit, the scope of prosecutorial discretion is wide. There is a lot of latitude to make decisions like that. You know who the one check and balance is on the prosecutor? The judge. If you go up to a judge and say, Judge, I'm giving you this plea agreement, most of the time the judge is going to sign it in deference to prosecutorial discretion. The rarest thing you can possibly imagine is a judge intervening. Okay, all the judges know each other. A judge intervening and saying, you have such a pervasive potential conflict here on a case I don't even know, but I know you have a conflict. I know because you had a special prosecutor. You're trying to now submit this plea. I'm going to say no. That is the only, it is incredibly rare, but it is the only check and balance on prosecutorial discretion, barring like an extraordinary investigation by a higher ranking judicial authority like the ethics office or the federal government, okay, or the state legislature or the auditor. It's very rare though that you get a check and balance on prosecutorial discretion, just how the legal system works. I'll tell you right now that what that judge just did in Dedham District Court involving the Kate Peter felony cases by rejecting Michael Morrissey's proposed plea deal and not letting his office submit the green sheet, not accepting the submitted, signed green sheet, we're going to find out. Judge keeps it but won't accept it, is the only check and balance. And how much do you want to bet Judge Krupp in Norfolk Superior Court would have done the same thing to Michael Morrissey? If Michael Morrissey sent an ADA in there on December 5th and said, you know, Your Honor, we couldn't find anyone, so we're just dropping it, how much you want to bet Judge Krupp would have exercised his extraordinary equitable powers and just said, are you kidding me? No, I'm ordering you to appoint someone. The court's going to do it on its own accord if you won't. So instead, to short circuit, this is why I feel this is such a threat. I hope people understand. To short circuit a repeat of what happened in Dedham District Court, I think the Norfolk DA abused prosecutorial discretion and dismissed these charges against Aidan Kearney, because I don't think Judge Krupp would have let him do it. That is a serious problem, okay? That is such a serious issue. It's hard to even put into words how concerned I am by that, okay? Because that is an end run around the court. Judge Krupp, I don't know how this works, okay? This is an extraordinary situation. Yes, Irene, the two charges involving Lindsay, which were, in my opinion, the grand jury indicted because of recordings, apparently. There was two recordings submitted to the grand jury, one where Aidan recorded Lindsay and there was no indication she knew, another that was supposedly with her consent, same recording but with her consent. The question was going to be, was one of them edited, like to insert her consent? There was going to be all this stuff, but there was evidence that the grand jury used as the basis for an indictment, okay? That's just what happened. And that had to do with the December 23rd, 2023 incident related to an ongoing grand jury that Lindsay was being subpoenaed to testify in front of, involving Karen Reed and Aidan Kearney. And that situation also caused a falling out between Aidan and Karen, apparently, because Karen told Aidan not to go to Lindsay's apartment that night. He did anyway, and Karen and Aidan are now in kind of some battle because of apparently a recording of Karen and Aidan talking that went around. It's been a lot, okay? But this is my fundamental point. I think Michael Morrissey tried to short-circuit judicial oversight of the Lindsay Gattani and Aidan Kearney cases, which is why I say, whatever you may think about the merits, I think the way this was done, the way the charges were dropped, was specifically to avoid a repeat of what happened in Dedham District Court last week, which you just saw, where the Norfolk DA was not allowed to drop the charges against Kate Peter with a plea deal because of a conflict. So to avoid that happening, no processing this after 2 years, no processing it under the auspices of you can't find a special prosecutor. Did they even try? Did anyone even reach out to the Attorney General's office? Did anyone reach out to any other prosecutor's offices? Was Judge Krupp going to ask those questions? Did the Norfolk DA not want to answer them? That is why this is a systemic threat to the integrity of the system. It's corruption to its core, and it's at the expense of the judicial system and the judges that we all put so much trust in. They can't even exercise their authority when prosecutorial discretion on a case where there was a special prosecutor, or where Michael Morrissey is recused, gets dropped before it can get in front of Judge Krupp. It is gratuitous. It's wrong. It's an injustice. And we'll listen to the end of this hearing where you can see the judge does not let this get dropped. And then we'll get ready to watch some Julio Fulio coverage. Then the CCC's hearing starts at 10. But my word, folks, I am an incredulous towel. Our republic, this form of government, the Commonwealth of Massachusetts, is at stake. And we can't let it happen. If this is happening in these high-profile cases, imagine what's happening to people who are voiceless and with no political influence or social media presence. Oh, ladies and gentlemen, they say that there's a Michelangelo on every street corner in Rome, and how many Einsteins have died a pauper's grave after working their lives in a field. But I'll tell you, the reality is how much we sanctimoniously pontificate about injustice, while the true injustice happens every single day of those intolerable, immoral decisions. Those intolerable, immoral decisions over and over and over and over again. They don't become the exception to the beautiful rule of law in this democracy. They become the rule of law. And that is what we have. It's pernicious. It's insidious. It drives good people away from law enforcement and from being prosecutors, and it drives bad people into the profession who look at it the opportunity to hide behind the artificial veneer of benevolence in the public sphere to harm the most vulnerable. I will not stand for it. I will give everything I have for safety, country, God, and family in that order, and this is a threat to all of them. It's a threat to every one of us, and it is a threat to what makes this country great. And if any one of us stays silent for any reason in the face of this egregious abuse of the justice system, then we are inviting that kind of behavior to ripple outwards and infect every organ of this beautiful democracy that I love so dearly. I say this not from a place of bias. I call it like I see it, right down the middle. But I can't stand to watch this go on any longer. It's abhorrent. It's a disgrace. And it's occurring under our very noses. We must talk about it. We must talk about it cogently. We must set aside our polemical biases. We must look at the facts and draw conclusions and do what is right, not for us in this moment, but for the future generations who will come to inherit the consequences of our decisions now. And some of that is the very foundational pillars of the system that not only do we benefit from today, but which we have a duty to pass on for the better to future generations, and we're not doing that right now. It makes me very upset. I told you I was going to go on a towel soliloquy. I told you. It's bigger than any one person. It's bigger than any one situation. It is a threat to what keeps us all safe. It's a threat to something that we all can believe in, that we've all built, that was handed down to us by our forefathers, and which, by God, unless some commie tries to stop us, we are going to hand down to our next generation. And anybody who's not on board with that, anybody who's more interested in advancing their personal monetary wealth or social connections or influence in the public sphere at the expense of that system, you've caused this. You've brought us to this point through all your inside baseball and wheeling and dealing. You've brought the calamitous reckoning That is whatever those racist text messages are on Michael Proctor's phone. That is whatever the cover-up of Sandra Birchmore's murder is going to lead to. That is whatever the collateral political fallout from this egregious abuse of the of prosecutorial discretion to drop these charges to cover up Brian Tully leaking Lindsay Gattani's cell phone extraction. Whatever you may think of that, there's a larger reckoning at play here, which is that these are just mountain peaks. Think of this as an iceberg. We are seeing the peaks of the iceberg, okay? They're coming up, okay? But what lie underneath is even worse. I have said time and time again, I don't know why this is continuing to go on, because clearly we are staring down the largest public corruption investigation in the history of the United States. I saw what came out yesterday about how Commissioner Cox was briefed by the Public Integrity Unit of the DOJ in February of 2024 about Kelly Dever. The only implication from that is that somebody, probably Cox, went to Kelly Dever and there was a conversation had. And listen, I'll say it over and over and over again. I don't think anyone acted weird on the night of January 28th into the morning of January 29th in the people who were at Fairview because of what happened to John O'Keefe. I keep saying this. People are missing the forest of the trees. I think they just had interesting social lives. Quotes around that. Okay? We've talked about the Air Force, professions with high rates of death, communal families. We don't need to go down that road again. So tell me, Brian Higgins, who's really good friends with Kenny Berkowitz, may he rest in peace. Okay? I'm not slandering him here in the sense I'm not trying to hurt his legacy. Just want to put the facts into context. Higgins, who's really good friends with Berkowitz, goes to the Canton Police Department to move his vehicle at 2 in the morning, whatever. Kelly Dever, who was working 24 hours or 16 hours in a row that day, she'd worked from 12 a.m. the previous morning, and she was still working at 4 or 5 a.m. the next day. All right, so she goes home around 4, I think. But anyway, so she is in the Canton Police Station. What this is all about is not, I don't think, anything to do with John O'Keefe or Karen Reed. Okay, I want to be very clear. Karen's car is not at that Sally Port for hours and hours and hours. It doesn't even get there till later in the day. Hours and hours later. This is early morning, okay? The police have not even been called. Karen has not even gone to Jen McCabe's house, okay? This, before she goes back to Meadows Ave where John lived, to go back to Fairview to find John, okay? Around 6. This is 2 in the morning or something. There's a period of time where Higgins and the chief of the Canton Police went into some area and Devers was watching the cameras, and I think she saw some shit. All right, now I'm not trying to be a little towel. I'm trying to be a little towel. All right, but I'm just telling you. Wait, hold on 1 second. So I'm sorry, there's so much going on. My point about all of this, though, is this is insidious, all right? You had all of these different players involved here, and I think the common thread is that there was something to this larger picture. Actually, let me pick up I'm going to play my own speech. Hold on. Oh, right, yeah. So I think what happened was you got to think about this in the political context, okay? I know this is a lot to take in, but just try to think about this. When President Trump got elected in November of 2024, Josh Levy, the former liberal DOJ head in Boston, and Rachel Rollins definitely fell out of favor, okay? And then new U.S. Attorney Leah Foley comes in. She's a Republican. Look at what President Trump has been doing. I really like President Trump, so I'm a big fan of this. But look at what he's been doing. I'm not going to use... There's specific U.S. attorneys who are looking into this stuff. But the point is, look at what they're doing. They are looking into what's called the weaponization of the DOJ under President Biden. Okay, what was one of the prime examples of that? Okay, Josh Levy and Rachel Rollins. Okay, they didn't like cops. Rachel Rollins hated cops. Okay, and that was what driving a lot of the anti-Morrissey sentiment by the feds, I think, along with the Birchmore cover-up. But then I think you also have to think of the wider picture of, like, Boston City Hall, okay? Like, Mayor Wu's running unelected, okay? I don't think President Trump likes Mayor Wu. Anybody in that orbit, any Democratic official in Massachusetts who was doing bad things, like, I think that's what they're going to go after. Okay, who's a perfect target if you've got him, like, interfering, even if Devers did nothing wrong? Even if all Devers did was see, like, Higgins and Berkowitz, like, playing Monopoly or whatever the kids call it these days, okay? Whatever the hell was going on, all right? Even if that was all that she saw and they just didn't want them to get embarrassed, you cannot tell her to not talk about it. That's obstruction. If there's a federal investigation and you tell her, Devers, if Cox tells Devers, don't say to the FBI what Higgins and Berkowitz were doing. Just forget you saw them. It doesn't matter that Higgins and Berkowitz weren't doing anything wrong per se. It could just be embarrassing. But that alone is obstruction. You cannot do that. And you can bang that Democratic official on obstruction for that. And look at what they're doing. Look at how the DOJ is trying to hold accountable Democrats in one-party controlled states that were unaccountable. Everybody getting the picture? All right, I'm not trying to be overly gratuitous here. But are you seeing where this is going? Wow. Oh, and I'm just hearing breaking news, ladies and gentlemen. Kate Peter has picked up additional felony witness intimidation charges, ladies and gentlemen. Her next court appearance is on November 12th. She was charged in September at the end of the month. I'm hearing this was first reported by Will the Glarer. The case number, I'll try to get that for you. It looks like it was filed 9/17/2025. It is Commonwealth v. Catherine Peter. It is an open felony case for witness intimidation. So that is another case for witness intimidation now involving Kate Peter. It seems this might be down in Attleboro. All right, so there's something going on. Again, more felony charges are now being reported having been filed against Kate Peter outside of the jurisdiction of Norfolk County. So I don't know how many cases that makes now, but another felony. Kate Peter apparently facing another felony now, ladies and gentlemen. This is just racking up over and over and over. This is becoming very, very interesting, folks. What is going on in the orbit of these cases? How can anyone be expected to decipher this when we have no independent checks and balances? It's worse than trying to audit the legislature. Whatever you think of the constitutionality of trying to audit the legislature, I'm not a judge, I'm not a lawyer, I'm not going to make that call. Whatever you think about it, I like the auditor, all right? This is almost as difficult as trying to do that, trying to understand this situation with all these overlapping ties, and the Norfolk DA and the PI Kate Peter and Marty Kraft and Michael Proctor and Jen McCabe and Brian Tully and Sandra Birchmore and John Fanning and Matthew Farwell and Billy Farwell and Robert Devine and Nick Garino and oh my god. And that's just the primary investigatory players in this chaos, okay? Then you have all the online kind of ops in their orbit. The people working for the PI firms, pretending to work for PI firms, scamming people by pretending to work they work for PI firms, using 40 different fake accounts. This was, hands down, the most ridiculous example of an internet forum run amok in the justice system I have ever seen in my entire life. Let me just tell you right now, what we saw with this case was basically as if a bunch of people on whatever those old forums were, whatever they were, if they all got together, right, and they decided that they were going to troll people by being involved in the justice system, okay? And the way that they troll is not like boomers troll, okay, where they just say things at each other. They have all these networks of fake accounts, and they're somewhat digitally savvy, and they somewhat understand psychological profiling and intelligence tactics, but on an amateur sort of hobbyist level. And then they weaponize them against targets who can't defend themselves because they like to punch down. All right? And that's where this all came from fundamentally. It's so disturbing how we got to this point, okay, where the justice system, I'm not saying the judges, I don't think the judges necessarily love this at all. It's very political. The judges are appointed by the governor and the governor's council and all of this, okay? It's a very political process, but I don't think a lot of the judges love it. I've never talked to them about it, and if I did, I wouldn't tell you, but I don't think a lot of the judges love it, okay? The vibe I get is they see this system kind of being abused, prosecutorial discretion. They see a lot of like tit for tat. They've always seen it, okay? That's part and parcel, but like normally you see that. Let me give you an example. So say you have like somebody like selling drugs. We're using an example of where a judge might see something wrong but be like, whatever. So just hypothetically, all right, you got a guy. What's a good way to use? What's a good example of this? Let's use Kylo. Okay, so Kylo v. U.S. is a case about like infrared technology. So in a situation where the police like go to somebody's home, okay, and let's say like they have a screen door, okay, they don't have a hard door, like the door's open, it's ajar, and there's a screen door that the police can see through. Say the police are wearing X-ray vision goggles, okay? Somebody invented them. You can see through walls with them. The police walk up to the house. They have X-ray vision goggles on, and they look through the open screen door, and they see a brick of cocaine and people snorting cocaine and selling cocaine and scales and drugs and guns, okay? They look through the door with the X-ray vision glasses on, but they see through the screen. In a situation like that, the court is probably willing to be like, okay, under Kylo, you can't really use sense-enhancing technology to obtain evidence like that without a warrant. You can't just seize stuff because you use X-ray glasses. But the court in that situation would be willing to entertain, I'm not a lawyer, this is not legal advice, the argument that, listen, that cop, whether he had the X-ray vision glasses on or not, could look through the screen door and could see the drugs in plain sight, and it's perfectly valid under Horton, for California v. Horton, for the drugs to be seized because it's in plain sight. The officer was legally permitted to be outside the door looking into the door, and it's an immediately apparent indicator of criminal activity that there's drugs on the table and guns and scales, okay? That is kind of when the judge is willing to be more forgiving of police misconduct. You got a drug dealer, you charge them, you got the evidence, the drug dealer is in court, you know he was there with the cocaine, right? And now he wants it suppressed because the cop technically did something illegal in terms of the Fourth Amendment, but really, was it illegal? Probably not, all right? Like, yes, it was illegal, but, like, was it illegal because the door could be seen through with regular eyes? No, it wasn't. That's an example where judges will be forgiving, even when you have a situation where police did something they shouldn't have done. That's not the case with this. I don't get the vibe, being in a lot of courtrooms, that judges love this. They're not as willing to overlook a situation where even if you get a quote-unquote defendant, get them in court, and have evidence against them, they are not going to look favorably if you have a conflict as a DA. That's what I've noticed is the distinction. So there is this kind of like, especially in liberal states, and this is not passing judgment, although I wish we'd be a little stricter, just right down the middle, calling it right down the middle. In liberal states, there is this deference to police misconduct, okay? Like, in the sense that they'll let the perp go on bail, but they'll also not really punish the cop for the misconduct. It's like a middle-of-the-road approach. It sounds like middle of the road, but it's actually quite liberal. It's like, let both of them just do whatever they want. Let the police do whatever they want, and then don't hold it against the guy. And now, the most interesting part of that, though, is when you have a situation with conflicts of interest, judges start to recoil. Why? Not only based on principle, but also because I think they look at it as a fundamental threat to their equitable powers. And what you have to understand about the emergence of like courts of law and equity, so you really got to look to like 1934 or 37 or whatever it is. Before 1934 or 1937, we had two different court systems. You had courts of law and courts of equity. Now, I'm not going to get into the details. For our purposes, just know, like, they used to be two different things. Like, if you were seeking something based on a law, like an enforcement action based on a law, you went to a court of, like a court of law, the legal powers of, you sought the legal powers of the court. It was its own court. If you wanted something that was more like an extraordinary writ that was developed through common law but didn't have a firm statutory foundation, I'm not doing a good job explaining this. I'm speaking very broadly. You went to a court of equity. Okay, courts of equity. I think it originally had to do with like land versus non-land, but this got way more convoluted over time. But the point is, it got so convoluted they merged them both. So after 1934, you have courts of law and equity. And the reason why I think judges are more permissive of police misconduct in some cases, but why they're concerned about conflicts of interest is police misconduct doesn't really encroach on judicial autonomy. And you've got to think of the balance of powers in the Constitution, the separation of powers, okay? You have judicial branch, you have executive branch, and then you have the legislative branch. The legislative branch writes the laws, the executive branch enforces the laws. So State House in Massachusetts, then the governor and all the state police and the police, etc., are the executive. And then the judiciary interprets the laws and plays referee. What I mean by that is the judiciary calls balls and strikes on whether a act passed by the legislature and enforced by the governor is constitutional. They're the final say. So the post-Marbury v. Madison, which is when courts started to assert this constitutional power within the trifurcated, tripartite system of checks and balances in the American federal system, they're very protective. Courts are very protective of their arena. One of the arenas that's technically within their jurisdiction, but which looks like it's in the prosecutors, is prosecutorial discretion. If prosecutors do things that the legislature thinks means the court's ability to be an impartial arbiter of justice are impeded, the legislature won't just take power from the prosecutor. They'll, in essence, carve off a piece of the judiciary's pie and take discretion from the judge by writing a statute that the judge is bound, unless it's unconstitutional, to enforce. Do you see what I'm saying? So the judges would prefer there not be a statute on specific things about their own power. That's my opinion. So when you're dealing with police misconduct, that's not really an issue of judicial power. That's more like the police. Reform the police if you have a problem with it. When you're dealing with conflicts of interest and whether a prosecutor's exercise of discretion is appropriate, if the court doesn't, either can't oversee it, like because of what happened with the null pros of the Gattani and Kearney cases before it could go before Judge Krupp as to assignment of a new special prosecutor or the AG, that can lead the legislature to, although they're really concerned about prosecutorial misconduct, strip power from the judiciary. Okay? That is what the judges don't want. That's what I think the concern is. So, what about when, Clerk Jim says, what about when prosecutors don't disclose it? Yeah, so Clerk Jim, I have written a special prosecutor reform law. You can take a look at it on my Twitter. It's a proposal right now. And I am strongly suggesting that Massachusetts codify procedures for exactly what you're talking about. Define a conflict of interest. Define a special prosecutor's independence. Define how the appointment process works. Define the appropriation of the budget through the legislature. Define what happens if the AG has a conflict. Define what happens if the governor has a conflict. Create a structure. Now, I think I did it, I'm just my opinion, I'm not a lawyer, I'm a towel. But I think I did it in a way, as you can understand, I have a very deep, intimate knowledge of American constitutional history. Like, I just do. For some reason, I just remember it. And although it's hard for me some days, the way I designed this statute, you can find the proposal on my Twitter, the way it designed it is to give a lot of judicial deference. It doesn't really take deference from the court. What it does is it allows the court to preemptively avoid situations where there's abuses of prosecutorial discretion. All right, it takes away the ability for a special prosecutor to bring indictments. It makes them do it at a public probable cause hearing, whether felony or misdemeanor. You don't have a right to an indictment, I believe, in Massachusetts. You do in the federal system, though. But anyway, and then it also forces the special prosecutor to disclose conflicts of interest before appointment with any witness, law enforcement, etc., or their family members, subject to a misdemeanor for an intentional misrepresentation or withholding about conflict, or a fine of $10,000 enforced by the Attorney General if it was an unintentional misrepresentation. Same rules apply to the Special Investigatory Unit, consisting of between 3 and 10 people that I proposed that would assist with the special prosecutions under the statute. It's completely independent, subject to the same sworn declarations under my proposed Section 28D of the law. And then same thing for victims, witness advocates. Pam Friedman, one of the people involved in the Lindsay Catani and Aidan Kearney case, I think she had worked with Brian Tully for 20 years. She was deeply conflicted. So there's a section of the statute that addresses conflicts for victims, witness advocates. And then 28E and F provide redundancies if the appointing authority of the independent prosecutor, the governor initially, and or the attorney general, like I think the AG does an initial screening of an allegation of conflict of interest, which has to come from either the DA pursuant to rule like 1.1, 1.8, or 3.8 of the Rules of Professional Conduct, or from a court order, or from a party to the case who, after a showing of standing and a filing of a $50 fee with a Superior Court judge, gets an order from that judge that they have the ability, based on reasonable facts, to bring an allegation of a conflict of interest. The Attorney General does an investigation within 60 days or so. They have to turn over a recommendation to the governor, who then has to appoint a special prosecutor. If the Attorney General or the governor or both are recused, there's a structure built in to send it up to the SJC, who then deals with appointments. And there's a lot of public hearings built into this structure, and I think it's a really good bill. So I encourage people to support it. That, again, is Towell's Special Prosecutor Reform Bill. Now, let's watch the end of this hearing. If you're just missing it, we have, of course, breaking news that Kate Peter has picked up more felony charges, ladies and gentlemen. She has another hearing, and she has the follow-up hearing in Dedham. After the conclusion of this hearing, you'll hear she has a short date for these felony charges. Now, new felony charges against Kate Peter as well. Oh, goodness, ladies and gentlemen. Buckle up your hats. I guess people don't buckle their hats. Maybe if you have a shoe buckle on your hat like a pilgrim. Oh, goodness, I'm a little towel. All right, Grant, focus. All right, at 10 o'clock, we're going to do the CCC social consumption hearing. Until then, we're going to keep talking about how Kate Peter is not a towel.
I think your client does want to talk to you, so.
I understand, Judge, and I understand if you're not comfortable with that, but, like I said.
Well, it's not so much that I'm not comfortable. I just think if there's a conflict, unless there's something that has changed so there no longer is a conflict.
Your Honor, I would say that if we could get a short date, then the next day we'll have my office will have a response to whether there's a conflict or otherwise we'll get the prosecutor.
Okay.
So again, as I said, my conversations with the office didn't believe it was, and that's why they were not waiting for the special prosecutor aware of the disposition.
So the conflict went away?
They're not aware that they weren't. ADA comment going to be done today, but something came up, and that's and I'm sure he'd be able to explain it to you.
Okay.
That was communicated to me, and I'm sure I'm able to check with the office. Okay.
Despite the fact that we do currently not have dates, I don't want to, put this out for too long. We'll find a date to squeeze you in.
How far out of the date can make this work?
I mean, if it's something that is going to be resolved, I hate to bring it out too far. So if there are dates, even though, technically they're closed, I think we can manage to get you in.
And also something was a 2 p.m. call for
Wednesday, the 29th, she was on.
The 29th of October. We can make that work, right? Okay, so 2 p.m. the 29th of October.
All right, Ms. Peter, your case is going to be continued to October 29th, 2025 at 2 p.m. for status hearing. You're all set with us today.
Should I hold that?
So once it's been turned in, it could court.
All set.
Miss Peter, you regret those ex parte communications with the Norfolk DA now? Just came back to bite you. You and Brian Tully released Lindsay's cell phone extraction in violation of law, under color of law. God bless the United States of America. Ma'am, do not discriminate based on medical cannabis usage. I wrote that law. Blow me another kiss. Come on. I'm beautiful. Ma'am, don't use the Canton salute. Yep, there. Kim Fair went from blowing me a kiss to the Canton salute. My name is Grant Smith Ellis. Thanks very much for being with me. I had a lot to say, ladies and gentlemen. Yes, indeed, I had a lot to say this morning, and if you just tuned in, the breaking news is that Kate Peta has picked up another felony charge, ladies and gentlemen. Kate Peter has picked up another felony charge. So what we're going to do is let's, what do I want to do here? Yeah, let's take a look at the Julio Fulio trial until 10 o'clock. All right, Tao's not feeling that great. I did a lot of yelling, and thank you all very much who tuned in.
Every time we do a story,
It's an ad. As I mentioned, by the way, whether on my channel or otherwise, consider turning your ad blocker off to help support creators on YouTube, no matter what channel you're watching. I promise you, we all appreciate it. I even turned my ad blocker off. By the way, I don't run an ad blocker because I hate ads. I run an ad blocker because I don't trust ads, okay? So I'll let some sites run ads, but not a lot. All right, so we are going to pick up with testimony. It just started in the Julio Fulio trial, okay? So I'm going to go ahead. And I think we're going to end, I think it starts with the prosecution. It might be, yeah, it's the prosecution up on questioning. And we are going to begin right now. So let me get this up on the screen for you. My name's Grant Smith Ellis. As I mentioned, this is the Julio Fulio trial. We're going to watch until 10 o'clock. Then we're over for social consumption coverage on the Massachusetts CCC. If you're wondering what's coming, things have gotten a little out of hand with open-air markets in Massachusetts for adult and medical use cannabis. It's about time that it got regulated, and it's about to be regulated. So we're going to learn all about that today. We're going to learn about the disproportionate area of impact report from Dr. Julie Johnson, the Commission's esteemed head of research, which is going to be formally approved after 4 years, despite the fact that it's been peer-reviewed, publicly accessible, and relied upon as the gold standard in other jurisdictions for a number of years. So yes, 30 minutes of Julio Fulio coverage. If you've been following this trial, it is very interesting. A lot of opinions out there about whether, because now it's a little hard to really do this justice, but there are a lot of people that lost their lives in the fight. It was a gang war between Julio Fulio, who was involved with a gang called KTA, and Young Ian Ace, who was involved with a gang called ATK. Right? Now, these folks, the prosecutor during opening statement explained how these different gangs also had musicians as part of them. Okay. And they would make videos mocking each other after their respective gang members would be killed. So one guy would order the hit of another guy, okay, and then he would get all the details and he'd make a song like saying all the details about the killing under the auspices of like First Amendment art. Now, is it art? Yeah, but like if you know the code, they're saying like, I killed your friend, here's what it was like, here's what his last moments were like, and by the way, like I smoked his dead body. Like they say that too. I'm not saying they actually smoke him, but they'll like be like, yeah, like I'm smoking on your boy because like the guy's dead. That refers to like when pack like bags of weed go out on the street in honor of the guy who died, they buy it. Now, it technically means you're smoking on his ashes, but they'll buy the memorial pack and smoke it. And be like, he's dead, I'm smoking on his ashes. I'm not, endorsing this, I have to explain it, otherwise the insults won't make sense. So it hides behind the veneer, this sort of rap battle of, you know, it looks like artistic expression. It doesn't really seem like they're saying, I murdered your friend and I'm bragging about it, but they did. They do. They openly say it in their songs. We're talking, but they have enough plausible deniability where they can say, oh, it's artistic expression. It's not Eminem. Let me be clear. It is not Eminem having these weird, like, his version of it, like, was not admitting to murder. He was, like, having violent fantasies and making art about it. That was pushing it. I didn't like that either. Like that song Kim, like some of the stuff Eminem did was way over the line. He's a good artist, but some of the stuff was way over the line. It wasn't real, but it was way over the line. This, they make music videos about real people who got killed. They are basically saying, especially Foolio and Ace, like, I killed your boy, what are you going to do about it? It's crazy. Foolio had a song called List of Dead Ops that just listed 30 murders where he clearly ordered, and he was just like, oh yeah. The beginning of the video is him reenacting one of the hits. All right? And eventually Foolio got killed by members of the ATK gang. This is the first trial. There's a woman on trial for Foolio's murder. Her name is Alicia Andrews. So we're going to take a look at day 2 of the Foolio murder trial. And then, as I mentioned, at 10 o'clock, we're going to switch over to the Massachusetts CCC. There's a lot going on. I don't know how it is possible that our justice system is just one cacophonous crescendo of chaos after another. But nonetheless, we're going to take a look, just pop in to take a look at the Foolio trial. This is Alicia Andrews on trial for the conspiracy to murder Foolio with automatic weapons. Law and Crime has the pool feed, so that's what we're going to watch. And then, as I mentioned, 10 a.m. Eastern, we're turning over to the Massachusetts CCC. Those of you who want to see social consumption get enacted, this begins the process. I'm not saying it's going to be overnight, but it's possible by Christmas you will see enforced, at least in existence, social consumption regulations. Does that mean you're going to see social consumption lounges overnight? No. Does that mean that it's going to happen immediately? No. But once the regulatory framework's in place, there you go. We're up and running. So yes, you'll get some of your social consumption lounges in different communities that will permit it. But really what it means is no more of these damn open air markets under the auspices of a gray area. The people were really starting to abuse it. I saw people who own companies in the regulated market posting on social media holding pounds, illegal quantities of Cali-Pack. You want to bet it was being sold in the Boston Common and nobody felt like enforcing it? It's time for some CCC enforcement, and it's time to watch the Foolio trial. I'll see you all at 10 o'clock when we turn over to the CCC. My name's Grant Smith Ellis. Thanks so much for being with me today on Little Town.
Jury. All right, and you probably know what I'm going to ask you. So while we were on our evening recess, did anybody watch, listen, read any news accounts or social media posts about anything related to this case? No. Did you discuss this case with anybody? No. Did you do any independent investigation or research on your own about this case? No. Okay, very good. Thank you. We're ready to proceed. State, call your next witness.
State calls Audra Agramante.
Yes.
I live in Lake Worth.
And back in June of 2024, were you visiting Tampa, Florida?
Yes.
Why were you visiting Tampa?
Because we were moving our daughter into the USF dorm. She was starting college for the first time.
Now I'm going to ask you specifically about the early mornings of June 23rd of 2024. But before I do that, you said you were moving in your daughter who was going to the University of South Florida. Is that correct?
Correct.
Who did you come with?
I came with my husband and my daughter's boyfriend, and of course my daughter.
And what was your daughter's boyfriend's name?
Braden Smith.
And your husband?
Nestor Agramonte.
Okay. And where were you staying at when you came to Tampa that weekend?
The Home Suites across the street from USF campus.
Okay. Do you remember what floor you were on?
Second floor.
And what was your room number?
230, I believe.
Now I'm going to go to the early morning hours of June 23rd, 2024. Did anything unusual happen that night, or I should say in the early morning hours of June 23rd of 2024?
Yes, yeah, for sure. So I was woken up by some popping sounds. My daughter's boyfriend, Mr. Smith, he threw me down to the ground and shielded me, and I was realizing these were gunshots I was hearing. My husband got up on the other side of the bed. He was closest to the window and looked at the window and saw a bullet hole through the window and yelled at us to get down. So we were all very scared and just stayed down until the bullet stopped.
Okay. What happened after the gunfire stopped?
We reached for our phones. We called 911. We called the hotel lobby, and I called USF campus security because I was really nervous about my daughter being there.
Okay. So who was in the hotel room that night?
Myself, my husband, and Braden Smith.
Where was your daughter at?
She was in the dorm at USF.
So going back to when you...
I have some more breaking news on Towel News Network, ladies and gentlemen. Per reporting on social media from Shams Chanaria, Miami Heat guard Terry Roger was arrested early Thursday morning as part of an FBI sports betting gambling probe, sources tell ESPN. The Eastern District of New York prosecutors and FBI Director Kash Patel will hold a press conference at 10 a.m. to announce arrests from investigation. Ladies and gentlemen, we may well take this 10 a.m. presser and let the CCC meeting, I can always do it on DVR. There's a lot going on. I am your Towel News Network. I'm so great to have you with me. Rolling coverage as chaos reigns all around the world today, ladies and gentlemen. My name is Grant Smith Ellis. We're going to go back to the Julio Fulio trial. I'll break in with more breaking news updates as I learn them. And thank you very much, as always, for flying Towel Airlines. Don't forget to wear a towel.
You said you woke up. So were you sleeping at the time when all of this occurred?
Yes, ma'am.
How many gunshots did you think you heard?
Oh my gosh, there were so many, and it was so fast.
Breaking news, ladies and gentlemen. Portland Trail Blazers coach Chauncey Billups has been arrested by the FBI for alleged illegal gambling, sources tell ESPN. Oh goodness, the NBA is falling. Ladies and gentlemen, the National Basketball Association is falling. Multiple active coaches and players arrested by the FBI. 10 a.m. press conference incoming. I will take it live. I'm a little towel. Oh goodness, folks. Oh goodness, what a day. The NBA is falling. I repeat, the NBA is falling. Yes, there have been massive arrests. Breaking news just now, ladies and gentlemen. There have been massive arrests across the National Basketball Association on this Thursday morning. A 10 a.m. Press conference is expected, which we will take live from the Eastern District of New York, along with FBI Director Kash Patel. Ladies and gentlemen, multiple active NBA players and coaches arrested by the FBI in federal raids on Thursday morning. Just 20 minutes from now, we will get the full press conference with FBI Director Kash Patel. My name is Grant Smith Ellis. Back to the Julio Fulio trial. Thank you for flying Air Towel.
I don't know, maybe 30, 40 at least. It was just rapid. Bum, 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 bum.
When you got up, did you also look to see where the bullet had come in through the room?
Yes, yeah. So we went over to the window, saw it came through. There were some bullet fragments on top of the, it's like the air conditioning vent, and it was on top of that.
At some point, did you make contact with officers from the Tampa Police Department?
Yes.
Did you provide an interview to an officer with the Tampa Police Department?
Yes.
Did crime scene come and process the room?
Yes.
How long were you in your room before you would say law enforcement was able to get to that room to process it?
You mean from the time of the shooting to when he came in?
Yes, ma'am.
It was a few hours.
I'm going to ask you about some photographs. Have I previously shown you photographs?
Yes.
I'm going to show you what's been marked for identification, States Exhibit 19A through G. No, E, I apologize, 19A through E. Do you recognize all of these photographs?
Yes, I do.
Judge, I think I misordered them. I just want to make sure how many they are before I introduce them. It's actually A through G.
A through G?
Yes.
Okay.
At this time, we would introduce the evidence 19A through G.
Any objection?
No, Judge.
They'll be admitted.
So, Ms. Agramonte, I'm going to ask you to look at this. Is this a photograph of the door leading to your hotel room that night?
Yes.
And then what is this a photograph of?
That's the inside of our room.
And that is 19B for the record. I'm going to ask you about 19C, again, another room, but a close-up.
Yes.
And where were you, and what bed was you and your husband in?
We were on the bed closest to the window.
This one right here?
Yes, that's correct.
And then your daughter's boyfriend, Mr. Smith, was he in the other bed at the time when all
Yes,
this
he
happened?
was.
I'm going to show you States Exhibit 19D. Can you tell us what's in this photograph?
Yeah, that's our window where the bullet came through.
And that's what you saw after you were able to turn on the lights and look, is that correct?
Yes, that's correct.
I'm going to show you a close-up. I'm going to go to 19F. You said that there were some items or some kind of particles on the AC unit. Is this the AC unit that you're referring to in 19D?
Yes, ma'am.
Show you a close-up of that. 19F, is this what you're referring to?
Yes.
Okay. And is this also some broken glass up here in the top of the photograph?
Yes.
And then E, is that a close-up of the bullet hole that was on your... Did you come to Tampa to bring your daughter in?
We rented a minivan so we would have room for all of our stuff.
And when you were leaving at that point, let me ask you this, when did you leave from that hotel in Tampa?
We tried to leave maybe around 11:30, but the police officer said, they had to check all the vehicles first. Once they said they had been checked, we were going to leave, and then when we got in the car, we saw that there were bullet holes in our car.
And
Breaking per ESPN, the major raid of the NBA and active players for gambling by the FBI involved organized crime. Ladies and gentlemen, we may have just had a breakthrough moment in American sporting culture. Organized crime may have infiltrated the NBA for the purposes of betting. Multiple active players and coaches, at least Miami Heat guard Terry Rozier and Portland Trailblazers head coach Chauncey Billups, have been arrested, ladies and gentlemen, by the FBI this morning. 10 a.m. press conference incoming. All right, my name is Grant Smith Ellis. We got a lot going on. We got the Julio Fulio trial down in Florida. Up in Massachusetts, we're going to watch the 10 a.m. Massachusetts CCC hearing. But before any of that, at 10 a.m., we are going to take live FBI Director Kash Patel speaking with prosecutors from the Eastern District of New York in a major press conference. The FBI, ladies and gentlemen, has taken down an organized crime-sponsored gambling ring within the NBA, the National Basketball Association. Multiple, one head coach, one player active, arrested in early morning raids on Thursday. My name is Grant Smith Ellis. Per ESPN, ladies and gentlemen, the NBA has been infiltrated, and the FBI has started to raid members, active players, and coaches, both of whom are former Celtics, ladies and gentlemen. Oh no! Is this a repeat of the Boston College point-shaving scandal of 1984? Is someone writing the new Casino movie right now? Ladies and gentlemen, I'll tell you right now, or Goodfellas, I'll tell you right now, that the movie Goodfellas is the reason why we cannot bet on college sports teams in Massachusetts to this day. You can't go into Edmund's dorm in Boston College and bribe the basketball players with money to make them point shave. And apparently someone was doing that with multiple former Celtics players in the NBA, Terry Rozier and Chauncey Billups, current Miami Heat guard Rozier, and current Trailblazers head coach Chauncey Billups, in federal custody, ladies and gentlemen. And I repeat, in just 14 minutes, ladies and gentlemen, in just 14 minutes, we will take the press conference live. Director Kash Patel speaking live with prosecutors from the Eastern District of New York. My name is Grant Smith Ellis. I tell you, ladies and gentlemen, this is the biggest sports scandal in American history. I would say this is bigger than Terry Moldea's investigations into the NFL in the 80s. This is bigger than Pete Rose getting caught on betting on baseball. This is bigger than the steroid scandal. My word, ladies and gentlemen, the FBI has raided multiple NBA coaches and players. I should say at least one NBA coach and one NBA player. Both former Boston Celtics, I should say, and the reports are that the raids relate to organized crime and illegal gambling, ladies and gentlemen. Organized crime is apparently not gone, although I think any of us paying close enough attention to the criminal justice system already knew that. Organized crime is here. It is influencing the NBA, and multiple prime-time, well-known players have been, multiple former players, one active player and one former player who's now a coach, have been arrested by the FBI. Just a few minutes now until the press conference. Back to the Julio trial in Florida.
Was it a rental vehicle, did you say?
Yes, it was.
This time we'd introduce into evidence States Exhibit 16A through R.
Any objection?
No objection.
Admitted.
Can you tell us what is in 16A?
That's the minivan that we rented.
You said that there were bullet holes, is that correct?
Yes.
Where were the first bullet holes that you noticed?
We first noticed it in the passenger seat. As Braden Smith got in, he noticed there were holes in there through the back and the front. And then as I was climbing in, I noticed there was a hole in the back of my seat too, which is the front passenger side.
I'm going to show you some of the seats. I'm going to show you 16M. Do you see these holes in the seat?
Yes.
And then 16N is a close-up of that.
Yes.
Was there, I think you mentioned there was also a hole in the license plate, is that correct?
Yeah, that's correct. That's where we believe it entered through, and it actually went through the hand cart that we had, like to bring all of our stuff in. So it went through that and then through the two seats.
I'm going to show you. Can you point out for us in 16B where exactly the hole is?
Sure. Physically or just?
You can get up and show.
Okay. So it's the, it was in the queue, and it's over on the side of the queue.
I'm going to show close 16D. Can you point it out for us?
Sure. It's right here. Side of the queue.
I'm going to show you. And you said that there was a hand cart, is that correct, that was inside of the van?
Yes, that's correct.
16J, is that what is being viewed there?
Yes.
Okay, I also want to show you a close-up of the back of that seat in 16K. Can you show where the damage was that wasn't there before the shooting?
Sure, it was in the back of the seat right here.
And I'm going to show you a close-up of the hand cart. 16I. Is this what you noticed when you first got into the minivan?
Yes.
Your Honor, at this time, we would pass the witness.
Cross-examination? Okay, thank you. May this witness be excused?
Yes, Your Honor.
All right, thank you, ma'am. You're free to go. All right, state, and who's your next witness?
The state is calling Blasini.
I'm sorry, what's the name of the witness?
Blasini, I believe. Miguel Blasini.
Okay, officer.
Officer, I apologize.
Okay.
Stand and raise your right hand, face the clerk, please. I do.
Please state your full name for the record.
Officer Miguel Blasini Francesi, but I go by Officer Blasini.
Where do you work?
I work for the Tampa Police Department,
How long have you worked for the Tampa Police Department?
just shy of 8 years.
Were you working on June 23rd of 2024?
Yes.
Did you respond to the home to suites located at 11606 McKinley Drive?
Yes.
Why did you respond to that location?
There was an active investigation of a shooting at that morning when I arrived to work.
What time did you arrive there?
At approximately 5:55 in the morning.
Were there other law enforcement officers already on scene at that location when you arrived?
Yes.
What county is that hotel located in?
It's located in the Hillsborough County area.
Was perimeter tape already set up when you arrived?
Yes, it was.
What were you tasked to do when you first got there?
Upon arrival, they asked myself and other squad members to try to collect surveillance video from the local hotels. And at that point, I made my way to the Holiday Inn hotel, which is in the same vicinity of the other hotels in that area.
When a homicide occurs, is the case eventually assigned to a homicide detective in the homicide unit of the Tampa Police Department?
Yes, it is.
When you were assisting and made contact with the hotel manager, did you say what hotel was it?
It was at the Holiday Inn hotel.
And where is the Holiday Inn placed in reference to the home to suites?
It's right next door. If you were to go to the intersection of Fowler and McKinley, there's a collection of 3 hotels in that area. Holiday Inn kind of sits in the middle next to the home, which is on the corner of 40th, McKinley and Fowler.
Did the hotel manager of the Holiday Inn, did he give you access to their video surveillance system?
He did. He actually assisted by operating the surveillance video and just going hour by hour, minute at my request.
Were you physically viewing that video footage as he was going through it?
Yes, I was.
Did you see anything of note or relevance to this particular investigation while he was viewing?
Yes. So the first thing that I noticed was a dark color vehicle cross the path of the camera of the Holiday Inn. It looked of a dark color vehicle. There was a second camera by the main entrance of the Holiday, which looks to the east, and at approximately 0:49 hours, there was a plume of smoke coming from another dark vehicle. Not long after that, there was 2 males seen from the direction of a smoke plume running into the hotel.
Okay. Did you make any observations of those 2 males as they were running into the hotel?
One male was a heavy-set male. The other one was thin. Both males. I'm reading my report, sir.
Okay, well, you can't do that, so you have to testify from your memory, and if you need to look at your report to refresh your recollection, you just need to let us know, or let Ms. Doherty know, You just need then to look at the report, refresh your recollection. When it's refreshed, then you can continue testifying.
Yes, Your Honor, my apologies. This was well over a year ago, so. There were two males that ran into the hotel. One was a heavy-set black male. The other one was a thin black male that ran into the hotel, the
What-
Holiday Inn specifically.
Sorry to interrupt. What did they do after they ran into the Holiday Inn?
From what I recall, they ran past the front desk down one of the hallways and attempted to knock on one of the doors. From there, they made their way when they weren't allowed entry into that room specifically. They then made their way to the elevators, got on the elevators, and then got off, I believe, on the third floor. Once they got off the third floor, one of the two males collapsed. It looked like he had been bleeding around the upper torso of his body. And the other male hung around but kind of paced back and forth next to his friend or the person that he was with.
And you have talked about two different areas, the first level, the third floor, as well as the elevator. Is there video footage of all of those places at the Holiday Inn?
Yes.
So you're able to see the full progression of when they were fleeing into that hotel and exactly where they went and what happened with them?
I can say that I saw the two males running from a direction of a vehicle with smoke coming out of it, running into the hotel, the Holiday Inn, and obviously their movement of travel as I described.
And after you viewed that video footage, what did you do with that information?
That information was passed on to homicide detectives.
After viewing the video footage, did you do anything else in further of this investigation to assist with the homicide investigation?
We just kind of maintained the perimeter for security, and while doing so, I noticed a vehicle that was struck by a stray bullet.
And was that, I'm going to show you, it's already into evidence, States Exhibit 16B.
All right, I'm going to... Really know what? We are going to eventually watch the DOJ press conference, but it might be at lunch. Something's going on. I'm sorry. My towel senses something's wrong. I don't know what the hell's going on, but we're watching whatever the hell's about to happen at 10 a.m. So, good morning. Hello. I'm a towel. You want to watch the CCC meeting with me? I think a lot of you are tuning in right now because you're like, what the hell is going on? I share your sentiments. I have no idea what the hell is going on. I am very baffled. I'm not going to report anything right now because I refuse to believe what I just read. I don't believe it. I'm just denying that what I just read was real. I'm going to watch this with you all. I'm just not reporting this. We are going to watch this. There better be an explanation. That's all I have to say. What the hell? What the hell? What the hell? What the hell? What is going on? Listen, maybe it was a typo. I don't know. I want an answer. Maybe nothing's wrong. Maybe it was just a typo. There's got to be something going on. We're going to just watch. This meeting starts at 10 a.m. I know a lot of you aren't necessarily interested in the CCC, but let me just tell you right now, I'm a little rattled right now. What? This can't be possible. My name is Grant Smith Ellison. I refuse to believe that what I just read is possible. Okay? I'm a little towel. I've seen a lot of things in my day. I don't believe for a second that what I just read is possible. I don't. I refuse to believe it. I'm going to sit here and I'm going to watch this with you all. Because I refuse to believe what I just read. Must be a typo. What? 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 I don't know if I can do that battle again. Alright? This can't be true. There's got to be some explanation. I am not jumping to conclusions. I'm being a responsible little towel. I want an explanation. And it has to do with the CCC. I'm not saying anything until this meeting starts. I want an explanation. I want to watch the DOJ press conference. Now I can't even do that. We are going to sit together and we are going to watch this CCC meeting. We're going to sit here and we're going to watch it. I don't know what the hell's going on, and frankly, I don't care. We are just going to watch it. I am frustrated and confused. And we're going to sit here. I'm not saying anything. Listen, I've heard weirder explanations, okay? So I'm just going to sit here and we're going to watch it together. I'm not going to jump to conclusions. We're going to watch it. I'm going to watch it. You're going to watch it. We're going to be little towels. All right? Oh, dear God. They never start their meetings on time, ever. Alright, let's hope maybe if I pause my camera, it'll pick up some bandwidth. 1 second. Alright, I'm a little towel. My name is Grant Smith Ellis. I thought they would come into session if I just did that. I think the best thing to do is just wait for a response to my email. I'm a little towel. Let me check my email, actually. Okay. Never mind. I got an email back. There is no catastrophe. It was a typo. Oh, dear God. All right. Everything's fine. My word. My word. All right. We're waiting for the CCC meeting to start. Oh, goodness gracious. All right. Okay, so the presser is starting. Let's take that, actually, the NBA presser, and then we'll go to the CCC meeting when it goes live.
To the Dropbox, so you'll have access. You can then download those pictures, okay? And as to probably two of the defendants here that are getting the most media interest, Chauncey Billups and Terry Rozier, they're going to appear in federal courts in the districts where they were arrested. Terry Rozier will be appearing in federal court in Orlando, Florida, sometime this afternoon. I can't tell you precisely, but sometime around 1 or 2 o'clock. Chauncey Billups in federal court in Portland. I don't know approximately what time that would be. They will both be arraigned on their indictments. They're in separate indictments, but they'll be arraigned on their indictments here in Brooklyn at a future date. The defendants that were arrested here in our area will be arraigned across the street sometime this afternoon. I believe there's about 31 people in custody, and there will be some who will self-surrender. So that's where things stand right now. Okay, so I'm going to go get the speakers, and we'll start in a couple of minutes, okay? Anybody have any questions? Your email address? It's John, John, Marzulli, Marzulli, at usdoj.gov. Thank you. Okay, see you in a couple of minutes. Can you spell your last name again? Marzulli.
All right, so my name is Grant Smith Ellis. We are going to take this press conference 31, an astounding 31 defendants, ladies and gentlemen. 31 defendants arrested by the FBI today related to a FBI investigation centering on organized crime and the National Basketball Association. If you're just tuning in, the press conference is about to start. Chauncey Billups will be arraigned after 1 p.m. in the jurisdiction, or will be initially appear in the jurisdiction where he was arrested after 1 p.m. I think it was Portland. Chauncey Billups or Terry Rozier of the Miami Heat will be arraigned after 1 p.m. in Orlando. Both defendants who are under arrest will be brought to the Eastern District of New York for an arraignment at a future date. There are 31 defendants, ladies and gentlemen. 31 defendants. 31 defendants. I repeat, ladies and gentlemen, 31 total defendants. If you're just tuning in, the press conference involving the FBI and the NBA and organized crime and illegal gambling is about to start. This is going to be one of those things 20 years from now. This is why I was going to take the CCC meeting if there was something apoplectic happening. There is not. Everything seems to be fine based on the email I got. It's just a typo. But we are going to take this live. Okay, so we're going to watch this press conference. There isn't going to be anything like this again. All right, you're going to see this one time. I can't believe this has happened. Very rarely do you see this kind of movement by the FBI against sports leagues. They make a lot of money. The players have a lot of influence. This is a very interesting development. So this press conference is about to begin. The speakers are just walking in now. Going to turn on the closed captions. I have the volume as high as it will go. This is one of those moments. I wouldn't say it's a moment that tries men's souls, but it is certainly a moment. All right? Every now and again you get a moment. This is going to be one of those moments. If you're just tuning in, Yes, ladies and gentlemen, the FBI has raided at least 31 individuals, some of whom will be self-surrendering. I think we're about to find out that there was a very large organized crime ring that had infiltrated the NBA actively. My word. All right, my name is Grant Smith Ellis. Thank you very much for tuning in. As I mentioned, we will take coverage of the 10 a.m. Massachusetts CCC meeting once that begins. They are running a little late, but that's never normally a problem. It's like getting the tech set up, people getting in the room. They're going to go all day. All right. So the other thing is we are going to take the 10 a.m. DOJ press conference. All right. That is what I think is very important. You can see up on your screen in the EDNY, they are about to go live. All right. We have the raw pool feed provided, I think, by The Hill. So thank you to them for the pool feed. The DOJ is about to hold a press conference. At first, I thought it was just 2 NBA players. I guess those are the 2 bigger names. 31 defendants. I'm not exactly sure what we're about to find out. Is this going to be tied to the New York Mafia? Is this going to be tied to a new organized crime ring? Is it going to be transnational organized crime? I think ESPN did some great initial reporting, but if you've ever watched the DOJ press conference before, and I think a lot of people will be tuning into this, whether on Twitter or otherwise, and if you're catching my feed, I'll try to give you the best analysis that I can of what I think is about to happen. If you watch a lot of sports, you might not know how the DOJ goes about doing its press conferences. So what you're about to hear is, normally this is the result of an indictment being unsealed. So now you're going to get all the reporters scrambling to the PACER docket for the Eastern District of New York. They're going to then be clicking. There's a way, you have to know what you're doing, but you can actually look at the actual docket in real time. You have to pay 10 cents per refresh, but you can look at it in real time. You scoop the document as it comes in, okay? And as the document comes in, this is when they have the press conference. The indictment gets unsealed. The person gets arrested. Here we go. We're about to start. And then we have FBI Director Kash Patel is expected to speak. Eastern District of New York prosecutors. The NBA, for all intents and purposes, was basically raided. We're going to take this live. This is live as live can be. My name is Grant Smith Ellis. On a historic day in the United States of America, please support Towel Channel. I'm a little towel. There's the FBI Director, Kash Patel. We're about to begin. Oh, this is one of those. And they line them up. Here we go.
Good morning, everybody. My name is Joseph Nocella. I am the United States Attorney for the Eastern District of New York. I'd like to welcome you here today. In addition, we have with us today FBI Director Kash Patel, FBI Assistant Director in Charge Christopher Rea of the New York Field Office, Special Agent in Charge of the New York Field Office Leslie Bakshi's, New York Special Agent in Charge of Homeland Security Ricky Patel, Newark Special Agent in Charge of Homeland Security Michael McCarty, Police Commissioner Jessica Tisch, Chief of Detectives Joseph Kenny, and the Executive Director of the Waterfront Commission, Phoebe Sorrell. I'm now going to turn the podium over to FBI Director Kash Patel.
Good morning. Today we are here in New York to announce a historic arrest across a wide-sweeping criminal enterprise that envelops both the NBA and La Cosa Nostra. The men and women up here standing with me represent a small portion of the leadership team that brought profound justice in an era that needed it more than any. I'll just highlight some of the details in the case and the FBI work, and then you'll hear from the others. But as you now know, individuals such as Chauncey Billups, Damon Jones, and Terry Rozier were taken into custody today, former, current NBA players and coaches. What you don't know is that this is an illegal gambling operation and sports rigging operation that spanned the course of years. The FBI led a coordinated takedown across 11 states to arrest over 30 individuals today responsible for this case, which is very much ongoing. Not only did we crack into the fraud that these perpetrators committed on the grand stage of the NBA, but we also entered and executed a system of justice against La Cosa Nostra to include the Bonanno, Gambino, Genovese, and Lucchesi crime families. And you'll hear more about those details today. The charges and the arrests that were taken down across this country range from wire fraud, money laundering, extortion, robbery, illegal gambling. This FBI will leave no room for any perpetrator of crime across this country. You hear a lot about our work of defending the homeland and crushing violent crime. Well, this work is also representative of a colossal portion of the FBI's mandate to keep America safe and to keep our entertainment industry fair and secure. The men and women that are standing up here today worked tireless hours, days, months, and years. And the fraud is mind-boggling. It's not hundreds of dollars. It's not thousands of dollars. It's not tens of thousands of dollars. It's not even millions of dollars. We're talking about tens of millions of dollars in fraud and theft and robbery across a multi-year investigation. And we could not have done it without our interagency partners that are before us today. The NYPD, HSI, and teams of law enforcement officials from around the country made this day possible. It takes a team to bring this kind of justice, sweeping justice, into the halls of the United States courtrooms, where our brave United States attorney has led this prosecution. It takes courageous prosecutors to stand before you and say, we will not allow this kind of illicit activity to happen, not only at the national sporting level, but also where it hides in La Cosa Nostra. And when these two collided together, they perpetrated a fraud that is historic in terms of not just money, but the scheme and the deceit that they utilize to steal and swindle people from money, to include crypto fraud. This is an operation that showcases to you that under President Trump's administration, there is no room for any type of criminal behavior, be it on the world's largest stage or in the back rooms of tiny parlors where card games are being played. We are proud to stand here today with the men and women of the FBI and this legal team. And to the United States Attorney, I just want to thank you personally for taking the time to display the work that the media is about to hear about today in detail. As I said, it does take courageous prosecutors, but it takes a courageous United States Attorney to bring this case, because we are going to take heat for it. But we don't shy away in this administration. We don't say no. What we do is we bring the results across the finish line. We bring them to the public. We bring you accountability. And yes, they will have their day in court, and you will hear the evidence through the court system exclusively. We will not deny anyone of due process. And that's the brilliance of this system. That's the brilliance of this administration. Everyone will be held to account. So with that, I turn it over to United States Attorney Nosella. Thank you.
Thank you, Director Patel. To be clear, we're announcing today indictments in two major cases, both involving fraud. One involves sports betting, and the other involves illegal gambling, very specifically rigged poker games. The first indictment involves 6 defendants who are alleged to have participated in one of the most brazen sports corruption schemes since online sports betting became widely legalized in the United States. This scheme is an insider sports betting conspiracy that exploited confidential information about National Basketball Association athletes and teams. The second indictment involves 31 defendants alleged to have participated in a nationwide scheme to rig illegal poker games. These defendants, which include former professional athletes, used high-tech cheating technology to steal millions of dollars from victims in underground poker games that were secretly fixed. The games in the New York area were backed by the Bonanno, Gambino, and Genovese crime families of La Cosa Nostra. While the cases are separate, there are 3 overlapping defendants charged in both cases: Damon Jones, Eric Ernest, and Shane Hennon. The indictments in these cases contain only allegations, and the defendants are presumed innocent until they are proven guilty in a court of law. But my message to the defendants who've been rounded up today is this: your winning streak has ended. Your luck has run out. Violating the law is a losing proposition, and you can bet on that. First, I would like to talk about United States versus Ernest, the NBA basketball gambling case. The defendants in this case are Eric Ernest, Marvez Farley, Shane Hennon, De Niro Laster, Damon Jones, a former NBA player and coach, and Terry Rozier, a current NBA player. Other co-conspirators were previously charged for their roles in the scheme, including former NBA player Jonte Porter. Between December 2022 and March 2024, these defendants perpetrated a scheme to defraud by betting on inside, non-public information about NBA athletes and teams. The non-public information included when specific players would be sitting out future games, or when they would pull themselves out early for purported injuries or illnesses. They relied on corrupt individuals, including Jones and Rozier. They also misused information obtained through long-standing friendships that they had with NBA players and coaches. And in at least one instance, they got their information by threatening a current player, Porter, because of his pre-existing gambling debts. Defendants used this non-public information to place hundreds of thousands of dollars in fraudulent bets, mostly in the form of prop bets on individual player performance. The bets were placed through online sports books and also in person at casinos. The defendants relied on a network of straw bettors to place the maximum amount of bets to increase their potential profits. Most of these bets succeeded, and the intended losses were in the millions of dollars. The defendants then laundered their illegal winnings in various ways: peer-to-peer platforms, bank wires, and simple cash exchanges. The indictment details specific examples where the defendants profited from illegal gambling and illegal betting on various NBA games about the performance of players on, among other things, the Charlotte Hornets, the Portland Trail Blazers, the Los Angeles Lakers, and the Toronto Rangers. Each defendant in the NBA basketball gambling case has been charged with conspiracy to commit wire fraud and conspiracy to commit money laundering. Now, I would like to turn to the other case, United States versus Aiello, the rigged poker game case. Beginning as early as 2019, the defendants in this case orchestrated a scheme to use wireless cheating technology to run rigged poker games across the United States, including in the Hamptons, Las Vegas, Miami, and Manhattan. The scheme targeted victims known as, quote, fish, who were often lured to participate in these rigged games by the chance to play alongside former professional athletes who were known as, quote, face cards. The so-called face cards included the defendant Chauncey Billups, who at the time of the scheme was a former NBA player and is currently the head coach of the Portland Trail Blazers, and also Damon Jones, a former NBA player and coach. What the victims, the fish, didn't know is that everybody else at the poker game, from the dealer to the players, including the face cards, were in on the scam. Once the game was underway, the defendants fleeced the victims out of tens or hundreds of thousands of dollars per game. The defendants used a variety of very sophisticated cheating technologies, some of which were provided by other defendants in exchange for a share of the profits from the scheme. For example, they used off-the-shelf shuffling machines that had been secretly altered in order to read the cards in the deck, predict which player at the table had the best poker hand, and relay that information to an off-site operator. The off-site operator sent the information via cell phone back to a co-conspirator at the table, and that person at the table was known as the quarterback. The quarterback then signaled secretly the information he had received from others to others at the table, and together they used that information in order to win their games and to cheat the victims. Defendants used other cheating technologies such as poker chip tray analyzers, which is a poker chip tray that secretly reads cards using a hidden camera, special contact lenses or eyeglasses that could read pre-marked cards, and an X-ray table that could read cards face down on the table. What you see depicted on the screen right now is an example of the X-ray table that reveals the cards. Although they are face down on the table, they can be read because of the X-ray technology. The Mafia, specifically members and associates of the Bonanno, Gambino, and Genovese organized crime families, had pre-existing control over non-rigged, illegal poker games around New York City. As a result, they also became involved in the rigged poker games, helping to organize the games and taking a cut of the proceedings, and working to enforce the collection of debts. The defendants laundered their proceeds, including through cash exchanges, the use of multiple shell companies, and through cryptocurrency transfers. As part of the scheme, some of the defendants and their co-conspirators also committed acts of violence, including the gunpoint robbery of a person in order to obtain a rigged shuffling machine, and extortions that were perpetrated against victims in order to ensure that they repaid their gambling debts. Defendants who participated in the rigged poker scheme are charged with wire fraud conspiracy. Other defendants have been charged with crimes including illegal gambling, money laundering, Hobbs Act robbery, and extortions. This case demonstrates our office's unrelenting commitment to fighting the scourge of organized crime in whatever form it takes. I'd like to conclude my remarks by thanking the incredible hard work of our law enforcement partners, including the FBI, Homeland Security, the NYPD, and the Waterfront Commission. I also want to thank the dedicated prosecutors who built these two cases and who are standing to my right. Benjamin Weintraub, David Bourbon, Caitlin Farrell, Michael Gibaldi, Irisa Chen, and Sean Sherman. They had the assistance of paralegal specialists Liam McNett, John Schneider, Marlene Bosler. Also deserving of our thanks because of their outstanding investigative work on the NBA case are FBI special agents Russell Lantier, Dominic Mariani, Amy Giaroso, Shane Wilkins, and Supervisory Special Agent Luke Hardison. On the rigged poker game scheme, outstanding work was performed by FBI Special Agents Thomas Cribbin, Jeff Boriola, Jonathan Corona, Alexander Silverman, Amy Campanaro, and Supervisory Special Agent Michael Malahi, as well as NYPD Task Officer James McCullough, and from Homeland Security, Supervisory Special Agent Charles Freund, and from the Waterfront Commission, Detective Paul Shimborski. Finally, I want to note that the investigations in both cases are ongoing, and we encourage anyone with information about either scheme to please contact the FBI. Now I would like to turn the podium over to Special Agent in charge of the New York Field Office, I should say the Assistant Director in charge of the New York Field Office of the FBI, Christopher Rea. Chris?
All right, thank you, Joe. As always, we appreciate the partnership here. Can't do any of this without you and your team, so thank you. Also want to publicly thank the director for coming down from D.C. The director's a very busy person, and for him to come down should tell you the importance of this historic case. I'm Christopher Rea, the Assistant Director in charge of the FBI New York Field Office. Today, as you've heard, our office conducted a massive nationwide takedown from 2 indictments of 34 defendants for their alleged involvement in 2 separate illegal poker and sports betting schemes where, as you heard, the odds were rigged in their favor. Among these defendants are 13 members and associates of the Bonanno, Gambino, and Genovese crime families, to include capos and soldiers from these families. Additionally, as you heard, current and former NBA coaches and players are also implicated, to include Chauncey Billups, Damon Jones, and Terry Rozier. 3 of the named defendants are charged for their alleged roles in both schemes. This alleged illegal gambling operation hustled unwitting victims out of tens of millions of dollars and created a financial pipeline for La Cosa Nostra to help fund and facilitate their organized criminal activity. Victims were attracted to play alongside well-known professional athletes and coaches like Chauncey Billups, only to be unknowingly deceived through rigged shuffling machines. Odds in their favor, as alleged and as you just heard from the U.S. Attorney's Office. This alleged scheme wreaked havoc across the nation, exploiting the notoriety of some and the wallets of many to fund the Italian crime families here in New York. Let me be clear about this fact. The FBI, when it comes to Italian organized crime in this city, specifically the LCN and the 5 families here in New York, we are not going to permit any criminal enterprise, whether it be Italian organized crime, Asian organized crime, Eurasian organized crime. We're not going to permit any of those organized crimes, families, and organizations to operate in our city or our country, as evidenced by the 11 states that were also participating in this operation today. The FBI office here in New York remains committed to eradicating all unlawful revenue streams fueling this criminal activity. As with most cases we work, this is only the tip of the iceberg for the FBI and the U.S. Attorney's Office. Our LCN squad agents and analysts are continuing to work day and night with the Eastern District of New York to ensure members and associates of the 5 families cannot continue to wreak havoc in our communities. Today would not have been possible without the
right now. We're going back live. Give me 1 second. The feed refreshed itself. The hill has
to Homeland Security Investigations Special Agent in Charge, Ricky Patel. Of course, we do nothing in this city without the NYPD. New York City Police Department Commissioner Jesse Tisch, thank you, ma'am, for all your work and all your resources that you dedicated to this. And New York Waterfront Commissioner Phoebe Soriel for their agency's assistance and support throughout this lengthy and complex investigation. Our collective efforts ensured these subjects will face accountability, like the director said, for their alleged wrongdoings. Thank you, and I'll now turn it over to Special Agent in Charge of HSI, Ricky Patel.
Thanks, Chris. Good afternoon, everyone. My name is Ricky Patel. I'm the Special Agent in Charge for Homeland Security Investigations here in New York. This morning, hundreds of special agents and investigators with HSI, the FBI, the New York Waterfront Commission, and the NYPD descended upon the homes of individuals who for years have operated with the false sense of impunity, a false sense of incivility. In the early hours of today, across 9 states, coast to coast, dozens of defendants were arrested and will face the consequences of their alleged crimes. This was their wake-up call. With the alleged involvement of 3 La Cosa Nostra crime families, 1 NBA head coach, a Hall of Famer, no less, and former NBA players, the years of investigative work that culminated with this morning's operation seem reminiscent of a Hollywood movie. But this wasn't luck, and this wasn't theatrics. This was an evidence-driven, relentless, and unified effort among law enforcement. Through what we have dubbed Operation Royal Flush, HSI New York, along with our task force personnel from the Waterfront Commission, first uncovered this scheme more than 4 years ago. Agents and investigators dedicated countless hours and sleepless nights in identifying the criminal network, dissecting communications and patterns, and following the money with precision. We built a case, piece by piece, and what we discovered was a sprawling criminal enterprise that utilized cutting-edge technology and various methods of deception to dupe unsuspecting gamblers into paying up so that these defendants could cash out. As alleged, this sophisticated conspiracy cheated victims out of at least $7 million and placed the public and the defendants alike at risk. This case involved global reach, financial depth, and the patience to dismantle complex financial criminal enterprises from the inside out. When criminal organizations attempt to launder profits through our country, HSI connects the dots and shuts it down. To anyone who thinks intimidation, fraud, or violence will shield their profits, understand this. If you are exploiting our communities, expect HSI and all of our law enforcement partners at your door. I would like to thank all our partners here today. Obviously, the United States Attorney's Office, Eastern District of New York, the Waterfront Commission, FBI, the NYPD, and the prosecutors that will carry this forward. Today's arrests are not an endpoint. They are the start of accountability. Thank you, and I now turn it over to Police Commissioner Jessica Tisch.
Good morning. Thank you to Director Patel, Assistant Director Rhea, and U.S. Attorney Nocella. What we're announcing today is not just another takedown. It's the result of more than 2 years of coordinated investigative work by the NYPD's Joint Organized Crime Task Force and the FBI. 2 cases that exposed criminal networks led by 34 individuals who believed the rules did not apply to them. They hid behind layers of complexity, behind money, and behind influence, believing those things would shield them from accountability. The first case, Operation Nothing But Bet, exposed a gambling ring built around professional basketball, where players and associates allegedly used inside information to manipulate prop bets on major sports betting platforms. They placed wagers on unders on players to score less, rebound less, assist less, using information that was not yet public. In some instances, players altered their performance or took themselves out of game or that those bets paid out. One example occurred on March 23rd, 2020, but at the time, playing for the Hornets allegedly let others close to him know that he planned to leave the game early the supposed injury. Using that information, members of the group placed more than $200,000 in wagers on his under statistics. Rozier exited the game after just 9 minutes, and those bets paid out, generating tens of thousands of dollars in profit, where the group counted their cash. As the NBA season tips off, his career is already benched, not for injury, but for integrity. As a result of this investigation, 6 defendants, including Rozier, are now facing conspiracy to commit bank and wire fraud. In a second case, Operation Zen Diagram, investigators uncovered a long-running scheme in which members and associates of several well-known organized crime families rigged high-stakes poker games across the country. These operatives included capos and multiple soldiers from the Bonanno, Gambino, Lucchese, and Genovese crime families. Bringing full is extraordinarily rare. It reflects how deep and how far this investigation reached and the skill and the persistence it took to get here. That work uncovered a deliberate, technologically sophisticated operation designed to carry out their crimes. They used custom shuffling machines that could read the order of cards, barcoded decks, and hidden cameras built into tables and light fixtures. The organizers also enlisted well-known public figures for former and current NBA players and coaches, including Chauncey Billups, the head coach of the Portland Trailblazers, an NBA champion and a Hall of Famer, to make the games appear legitimate. Victims believed that they were sitting at a fair table. Instead, they were cheated out of millions. One victim in particular lost $1.8 million. In total, losses exceeded $7 million and continue to climb. And when people refused to pay, these defendants did what organized crime has always done. They used threats, they used intimidation, and they used violence. It's the same pattern that we have seen for decades. Traditional mob enforcement methods combined with new technology to expand the reach of their operations. Now, with the unsealing of today's indictment, 34 individuals are facing charges, including robbery, extortion, money laundering, wire fraud, bank fraud, and illegal gambling. I want to commend the outstanding work of our detectives from the Joint Organized Crime Task Force and their dedication to these cases, especially Captain Ruben Pagan, Sergeant Chris McGuire, Detective Alexander Creamer, Detective James McCullough, and of course, our Chief of Detectives, Chief Kenny. As part of these investigations, our members recovered and reviewed thousands of hours of video, conducted extensive surveillance on illegal gambling locations across the city, and executed more than 24 search warrants on electronic records that revealed the true extent of this conspiracy. Once again, the work of our detectives, together with the FBI and the U.S. Attorney's Office, closed those gaps before they could widen further. The NYPD is proud to stand with each of you today, as these cases represent the kind of partnership that defines modern law enforcement agencies, sharing intelligence, coordinating resources, and moving as one team. Thank you.
If anyone has any questions that they'd like to ask, now is the time.
I had a question about the structure of the case. Is it the investigation into one case, did that lead into the discovery of the other? Could you talk more about the link between the two?
I'm not at liberty to discuss either the background of the investigation itself or the investigation as it continues. So I'm afraid I can't really explain to you other than the fact that both cases have been unsealed today, and there was an overlap that has been discussed already with respect to certain of the defendants. Yes.
Dante Porter claimed that he had a gambling addiction. Did Rozier or Billups or Damon Jones claim the same thing at all?
With respect to any allegations or defenses that have been made by any of the defendants, they will have their opportunity to present them in court. We're not here to air those at this time or to discuss them. Yes.
You said the investigation is still ongoing. There seems to be several players referenced in the indictment.
We have at the FBI and the team here to specifically mete out justice. And look, let's not, mince words. This is the insider trading saga for the NBA. That's what this is. That's why we are going to take heat. But as the evidence comes out, as the indictments are unsealed, you will see the extensive work these men and women put in, countless hours over years, and that's how we countermand it. We will not publicly discuss the timing of when we do takedowns. I will only say that we do takedowns in a coordinated fashion with our law enforcement partners and the U.S. Attorney at the appropriate time to make sure that we ensure the integrity of the investigation, as the United States Attorney said, an investigation that is very much ongoing.
Director Patel, you said insider trading for the NBA. What are the implications of this case for other sports leagues and for the legal gambling industry in general?
Simple. If you're participating in the legal gambling industry, you got nothing to worry about. If you're participating in illegal conduct, you got everything to worry about, and this case shows it.
Did the illegal conduct cross with the legal sports betting platforms in any capacity? And if so, is that the search warrants that the police commissioner just referenced?
I'm not sure I quite understand your question. You're asking if the illegal conduct The sports books themselves are victims in this case. They themselves did not, as far as our investigation has concluded, they did not perpetrate anything unlawful.
Are you able to say which sports books or online outlets they use to make these bets?
I'm not going to respond to that at this time, but that information will be made public. Yes.
Can you identify the access point where these co-conspirators were able to recruit these, famous people to partake in the schemes?
When you say the access point,
They were able to recruit them?
I'm not sure which case you're referring to.
Both.
Well,
Rozier, how he was recruited, Damon Jones in the NBA scandal, and then Billups for the poker game.
we're not at liberty to say that at this time. That will be revealed in due course. Yes.
He was being...
What is your question, sir?
Hey, thanks for being here. You just said that the sports books themselves are the victims, at least in the indictment involving Terry Rozier and others.
They're among the victims.
Okay, but those companies make, as we all know, they make a crazy amount of money off of a lot of everyday Americans make bets and mostly lose them. Are you concerned with a jury potentially not being sympathetic in a case where the victims, as you say, are these multi-million or billion-dollar gambling companies?
Let me repeat that all of the defendants themselves are presumed innocent. We believe that at a trial, when they have the opportunity to present their defenses, if they chose, because they're not required to, we will come forward with the evidence to demonstrate their guilt. Yes.
There's been, I'm sorry.
Did the NBA cooperate with this investigation?
The answer to your question is yes, the NBA has cooperated with the investigation. Yes, sir.
There have been reason to believe there's an associated college basketball element to this. Can you confirm that, or is there another investigation or part of this investigation that will affect college basketball?
The investigations that we announced today did not involve college basketball.
Last question.
Yes.
There was an emphasis on the Italian crime presence, organized crime in New York. Can you give us a sense of the strength and status of Italian organized crime in New York right now?
No, I'm sorry. That would be a question that goes beyond what we're here to discuss today, which is these two indictments. Thank you.
Everybody.
All right, folks, my name is Grant Smith Ellis. If you missed it, the press conference has ended. That was incredible. The 4 of the 5 Italian-American mafia families on the commission, ladies and gentlemen, 4 of the 5 were just brought down in a sprawling, multi-state, multi-year federal bust, a raid, wherein multiple NBA games were manipulated via prop bets. The players were manipulating the NBA. Now, the sports books were victims. The NBA is cooperating, so it doesn't seem like this was a sports book or league-based manipulation. This was the Italian-American mafia infiltrating the NBA and manipulating prop bets. Unders, overs, when players would go out of games, how many points would be scored. Ladies and gentlemen, they stole tens of millions of dollars from the American public. And the FBI, I noticed this over the past few years, they were going in public and saying the mafia doesn't exist, the mafia doesn't exist. No, they were lulling the mafia into complacency, and they brought down 4 of the 5 families on the commission. You heard at the press conference, it's very rare to see 4 of the 5 families indicted at once. They brought down the commission, ladies and gentlemen. I don't know if we can fully appreciate in this moment the scale of what we have just seen. We will go over to the CCC meeting. We'll watch it at 1.5 speed. My name's Grant Smith Ellis. That was incredible. All 5, basically, all 4 of the 5 members of the Italian-American Commission, the families that run the American Mafia, were brought down. The American Mafia that just a year ago the FBI was saying didn't exist or was gone. It was around. It was manipulating our sports betting, and the investigation is active, and they got them. Ladies and gentlemen, it is according to FBI Director Kash Patel, it is the insider trading scandal of the NBA. It is the biggest American mafia indictment since, I would dare say, since the indictment in the 80s. Since Giuliani brought the indictments in the 80s, since they brought the indictments against the Patriarchas and the family downtown in Boston at 95 Prince Street, since Whitey, ladies and gentlemen, the American mafia was just decapitated in one fell swoop. You just saw it happen. People are going to make movies about this. How it happened in 1 hour. You just watched history unfold. If you happen to tune in randomly, all 10,000 of you over on the Towel X who apparently didn't have many other places to watch this. Thank you for supporting independent media. All of those of you listening, you can support this channel. There's a Venmo sticker. I'm just some guy trying to eat every day. I'm a little towel, but if you like my erudite analysis, there's a Venmo at Grant E1. There's a Cash App Grant Smith Ellis. There is a PayPal, paypal.me/Grant Ellis. I literally do not have sponsors. I have no ads. I'm an independent public information service. If you found me randomly, very good to have you. This is not corporate news. It's independent news. It's powered by you, the listeners. And if you want to give me a towel cheeseburger today, I would love that. I'm trying to go day to day. That said, I also wear the Virgin Mary, so if you're into that kind of thing, Towel loves Jesus, Towel loves President Trump. There you go. What more could you want? We're going to go over to the CCC meeting, but what a moment. What a moment in American history. The American mafia was lulled into complacency and decapitated by President Trump's DOJ in the context of manipulating the NBA game to the tune of defrauding the American public to tens of millions of dollars on prop bets, which means when you bet on how many points someone's going to score, and the player can easily manipulate it by just being like, oh, I injured my ankle. Sorry, I scored under 40 points. Oh, more like 22. I scored under. Oh, and all my teammates used proxies to bet hundreds of thousands of dollars, and they won a lot of money because I got injured and came out of the game. Boom. That was one example. I think it was September 23rd, 2023, when Terry Rozier, former Boston Celtic, was now on the Miami Heat, was playing for the Charlotte Hornets at the time. Like, this is bad. This is the stuff people worry about. I thought it was the sports books. It wasn't the sports books. I was like, what the hell? These games don't make a lot of sense. It was the mafia. Oh, my God. Of course they took over sports betting. That was their bread and butter. I just can't believe they got caught. This is normally the kind of thing you do because you have the friends that won't allow you to get caught. Oh, my word, they decapitated the American mafia. I can't believe it. In 1 hour, we found out the American mafia is still around. They are very powerful. The commission is still running things. And then they got decapitated in the same moment. I don't know if I can truly put this into words, even as a Towel reporter. That was incredible. Listen, I know some of you want to see the CCC meeting. You're never going to see anything like that again. Oh, my God. That's glorious. That's one of the greatest law enforcement operations I've ever seen. Yes, they called it historic. Yes, that kind of wording in a formal setting is very rare. They're not being hyperbolic. They're using that language with a reserved tone because this is historic. The person at the press conference who said you never see 4 families of the commission indicted at once was 100% right. That was the wildest thing I have ever seen. We found out the mafia was alive and well. We found out they were manipulating the NBA and seriously corrupting and defrauding the American public and multiple sports betting apps. And then we found out it got broken up due to a 4-year operation all in the same hour. Oh, my word. Listen. That takes some serious stones. You want to do that? You want to they just did that. They just declared war on the American mafia, and before the mafia could even realize that the feds were going to declare war on them, the mafia got taken out. This is their bread and butter. This is the backbone ever since the numbers games in the early 20th century, mid-20th century, ever since gambling. The mafia has been in charge of it. The casinos, Vegas, sports books. That is the mafia. This was the moment. They just took them out. Listen, the only way this happens, as I mentioned, is if people with a lot of money, like the sports books, take over gambling, which must have happened. because the mafia ran that thing for 100 years. This is it. No, it's over. The mafia might continue to exist after this. There was a lot of talk in the 90s and 2000s about whether it was gone. It didn't really go away, clearly, but no, this is the death knell. It's like taking the backbone away from the cartel by ending their drug smuggling routes. They have to finance their operations. You just took it away from them. And you got 4 of the 5 families. That's how you cut that. You see what they didn't just cut the head off the snake. It was like a 5-headed snake. They just went at it with a friggin' sheath. It's gone. And it won't come back. They don't sell drugs, really, because that's how you really get banged up. Like, the penalties are so harsh. The mafia doesn't really sell drugs. The other mafias do, like the Mexican mafia and the Latin American mafias, but not the Italian-American mafia. Some of them do, but it's really a faux pas. It's not accepted. Not because, one, it's wrong, but it's not accepted because the penalties are so harsh, you're more likely to flip. Watch The Sopranos. Which is a real story, based off the Di Cavalcante family in New Jersey. Tal knows a lot about this. Anyway, so the point is, you have to understand what just happened. Okay, that was a single strike. It was a targeted strike to the leadership structure of the American mafia, and it cannot come back. There is no funding mechanism if you take away gambling. And if they caught them doing this, mark my words, and they're saying it's active, they're going to catch this was going on in the NFL, this was going on in the NHL, this was going on, I'm pretty sure, on the college level recently, but they probably don't want to touch that right now. But yeah, you could hear them say this doesn't involve college basketball as far as they know, but come on. Anything that was being bet on, anything that had players, anything that they could infiltrate, they infiltrated. I'm telling you, I know how this plays out. I'm looking forward a year. We're going to find out that every single bet was being, not every bet, but every league, every form of bet, every type of game, it was all being manipulated, and it wasn't the sport. I kept thinking it was the sports books. Because you have this, really weird behavior by certain players that doesn't make sense. And you can watch some of the YouTube channels that highlight this. And, they do deep analysis. Some plays just don't make sense. Now, I don't bet, all right? You give me $5 or $10 as a free coupon. Okay, maybe I'll bet because, you're giving me free money. It expires if I don't use it, fine. But I don't like the idea of betting, and I take my Virgin Mary pin off when I bet. Forgive me for missing. But yeah, I don't bet. But what I like to do is I like to look at the lines as an indicator of what's going to happen in the game. So I'm always looking at what's the line, what's the over-under, what are some of the big prop bets, where does the house stand to win and lose the most, where could a player manipulate certain stat lines to influence certain things. Now, if you're watching for all that and games just play out and nothing weird happens, you're like, okay, whatever, that's the outcome, it is what it is. But you watch and at a key moment, a player who should catch a ball, I don't know, they look down or they hear footsteps, something that looks normal but is actually acting, and they drop the pass on a key 3rd and 7 that leads to a 4th and 7 that leads to a punt where the other team comes back, scores a touchdown that brings it within the spread, and the player just caused a bunch of money to go from one side to the other. And if you knew the player was going to drop it at that moment, you could make a lot of money on a prop bet. Now, what gets wild is you can bet in-game. So if you have somebody, which they did, who's telling you okay, in the 3rd quarter, on when there's under 7 minutes left, if we have the ball and we get to 3rd down and 7 or more, I'm going to tell the quarterback to target me on a crossing route into the middle, and I'm going to make sure I either drop it or tip it so it goes up and there's a high probability it hits the ground and leads to 4th and 7 or gets intercepted. Do you understand how much money you can make? Look at the odds. Look at real-time in-game odds for drive result predictions. Bro, yes, it's going to get flagged, but if you have spread it out enough across enough random bettors, then you bet $100,000 across a bunch of proxies on the outcome of the 4th drive in that game, whatever, for the home team. And you say that's going to be a turnover on downs or an interception. You could make millions of fucking dollars, sorry for cussing, on $10,000. If you knew that player was going to do a certain thing. And I always used to think, it's got to be Vegas. Vegas doesn't care. Vegas has a good algorithm. The house always wins. They can lose 3 days out of a week, win the other 4, and be happy. They can lose 14 days out of a month, win 15 days out of a month. They're going to be happy. They want to win more, but as long as they don't net lose, they don't care. It's not Vegas. It's not the sports books. It's specific players who are in these rings that point, shave, or manipulate prop bets, and that compromises the integrity of the game. They just ended it, at least in this specific context. I think it's much bigger. The NFL has a much bigger problem with this. We're going to find out this was happening in the NFL. Mark my words, write down the prediction. I've studied this stuff going back to the 80s with Dan Moldea's coverage of some of this stuff. I'm telling you, same thing was happening, and they're going to move on it too. There's too many plays, just like what they were talking about, where Roger pulled himself out of that September 2023 game. There's too much stuff like that. It happens all the time. It's very frequent. They're going to find out you can use digital technology to analyze the outcomes and see where these moments happen. You don't have to just use your eyes. Okay? Wild. And you saw it live. Listen, I would never delay CCC coverage, right? That's not, I like the CCC. I thought something chaotic happened. It didn't. But let me tell you right now, that was one of the wilder things I've ever seen in my life. And not every day do you get to see La Cosa Nostra just taken down by the powers that be at the DOJ. All right, so if you're wondering, Grant, did we miss anything in the CCC meeting? We probably missed a little discussion. Don't worry, I have a towel plan. All right, you want to know what my towel plan is? We are going to watch at 1.5x speed. Now, you might say, why are we going to do that? Well, because it will get us caught up to the meeting, and we won't have missed anything. So, now, we had to watch that presser. Listen, if you are at all interested in the history of sports betting, if you are at all interested in the history of the mafia, that was a historic press conference. That was one of the most interesting things that could ever happen. Very rarely do you see something like that. Not every day, ladies and gentlemen. I was honored to be able to broadcast that for like 10,000 of you. Now what we're going to do is we're going to go over to the Massachusetts Cannabis Control Commission. If you watch my streams, this is what you most people are tuning in for today. So we're going to try a new view today. So we're going to put the CCC up top there, and then we'll put their slides right beneath, and we're going to begin with the beginning of the public meeting. So I'll be with you. We'll eventually get to a lunch. Let me go ahead and shift this to 1.5x speed. Once we get back to live, it'll shift to normal speed. Thank you very much again for tuning in. My name is Grant Smith Ellis, and I am a towel. All right, take it away, government. What are we talking about today? Social consumption and the DIA report. All right, let me get this speed to 1.5. Hold on. All right, let's do it.
Thursday, I met with officials City of Worcester and City of Fitchburg, including the Mayor of Fitchburg. We reviewed the current draft framework for social consumption and the upcoming schedule. After our visit, we met with a few SCP licensees and potential applicants for this license type and provided them an update on our work and answered some questions about the current draft. Friday, I had the opportunity to visit 2 cannabis dispensaries out in Berkshire County. I hope I'm getting the name of this right. Kappa Dispensary in Lenox and Canna Provisions in Lee. Want to thank those respective owners for their time and conversation. I think I was at Canna Provisions for like 2 hours on a busy Friday afternoon, but also had the opportunity to meet with City of Pittsfield officials and share information with them about the social consumption regulations as they're currently drafted. Working on a little bit of my homework, reached out to Springfield and Boston with a call scheduled tomorrow with Worcester, follow up on the census tract discussion we've been having, encouraging all 3 of those communities to respond to your emails, encourage Madam Chair as well. Both, at least Springfield and Boston, who I talked to, expressed interest in responding. And then yesterday, members of our team from DCAP, Licensing, Legal Enforcement Council, and I met with Minnesota officials who are in the process of overseeing their first marijuana event organizer licensee's first event coming up. We discussed their program and our proposed framework, and it was a great opportunity to collaborate going forward. It's interesting to hear how they navigate their 14 license types that they have and how they go about enforcement in partnership with local municipalities. So that's it for me.
Commissioner Roy. Thank you, Chair, and good morning, everyone. Looking forward to getting towards the finish line with social consumption today, and I know we have a few more meetings planned. Just a really brief update. Yesterday, I had the opportunity to speak at the Shield Compliance Conference in Boston. It's a conference that focuses on banking in the cannabis industry and as well as compliance. There was about 100 bankers and banks from across the country that attended, and I was thrilled to participate. And they really reaffirmed what I've been learning as of late, that creative partnerships and joint ventures, which I believe the Gaming Commission has as well. They all agreed. I did ask them. I took a snap poll, if you will, that they would look more favorably on lending to folks in the cannabis space if we had these types of partnerships. So again, again, we agreed access to capital is one of the most challenging aspects with federal illegality. So looking at creative ways to tackle that is extremely important. So just enjoyed my time there yesterday and look forward to speaking Monday at the State of the Cannabis Industry, again back in Boston. So thank you for my time.
Thank you, and I don't really have any opening comments other than I'm happy to get to work, and the fact that these conversations and regulatory writing processes have been going on for 2 years, and hopefully we're going to get this done by the end of the year. I especially want to thank Mike Baker, who has been my Sherpa, walking me through. So, and I want to say we've completed the journey, although all of the videos on TikTok sometimes get me a little worried thinking about climbing that mountain these days. But anyway, I want to thank Mike in particular and the entire legal team for helping me out, because this has been a steep learning curve for me. Again, it's been going on for 3 years, and I'm catching up with 3 years of activity and testimony. So again, I thank the team for their help. So with that, we will move to commission discussions and votes. And as I first raised back in, I think my first meeting back in September, I had raised questions about whether or not the Donahue Institute study, which had looked to expand and clarify the census tracts that that qualify for social equity benefits under the commission. This was done at a cost of $200,000. It's been out there. Obviously, we're now dealing with the social equity issue, and there are a couple of additions to that list that I think could be helpful to the overall success of the social consumption regulation implementation. So with that, I know that Commissioner Roy has a comment that she would like to make, and we do have a draft motion for the DIA map, but I don't know, Commissioner Roy, would you like
Thank you, Chair. A few things, actually. If I may have the floor for a little bit, and I might be a little long. I just want to talk a little bit about Donahue Institute. I want to talk about the research team, the diversity of the research team, and there had been some questions. We got emails about the methodology. So if I may, I'm going to have the floor for a little bit, if that's okay. The UMass Donahue Institute remains one of the Commonwealth's most esteemed and trusted institutional partners in applied research, policy evaluation, and program analysis, serving as a key analytic and policy partner for government agencies and community stakeholders. For decades, the Institute has distinguished itself through its methodological rigor, objectivity, and commitment to public service. Its expertise has earned national recognition and respect, with numerous awards, scholarly publications contributing meaningfully to applied research and evidence-based policymaking. The Donahue Institute's work is frequently cited for its excellence in economic analysis, workforce development studies, and program evaluation, each project demonstrating a deep commitment to accuracy, integrity, and transparency. I wish to extend my gratitude to the UMass Donahue Institute for its continued professionalism and diligence. I am deeply appreciative that the Institute is currently focusing on the statutorily prescribed metrics and data required to assess the delivery license exclusivity period, a critical responsibility the Cannabis Control Commission was unable to complete in a timely manner. The Commission's decision to contract with the Donahue Institute once again should reaffirm or affirm our confidence in their capacity to deliver accurate, comprehensive, and timely analysis that will help guide our policy decisions. I'm confident the Donahue Institute's independent and analytical approach will once again yield findings that strengthen the Commission's ongoing work and support the Commonwealth's broader goals of fairness, equity, and accountability. I am hopeful the Commission deeply values the Institute's partnership and its steadfast commitment to the highest standards of research and public trust. And I also had inquired about our current contract with the Donahue Institute. Again, we were statutorily prescribed to accumulate, assess, and analyze metrics and data relative to exclusivity around delivery. Unfortunately, we were unable to meet that deadline. We voted on an extension. We voted on a second extension. And so we have once again partnered with the Donahue Institute. Phase 1 of the exclusivity cost $30,600, and phase 2, signed in September, was $47,982. And so there have been some questions about the methodology. So if I may, Madam Chair, please. Okay. So it's important for the public to understand, this report will be 5 years anniversary in March, and at a cost to Massachusetts taxpayers of $200,000. So I want to provide additional context around that. The purpose of the project was to, 1, develop a method to empirically assess the extent to which Massachusetts communities have been impacted historically by cannabis prohibition and the war on drugs. Number 2, apply the method to generate, quote, disproportionate impact score, a DI score, that reflects those impacts for different areas of Massachusetts. And 3, provide a ranking of areas in Massachusetts according to the disproportionate impact score. The disproportionate or DI score, therefore, included 4 primary factors at a geographic level. Drug arrests, including number 1, average annual number of drug arrests. Number 2, average annual rate of drug arrests per 100,000 population. Number 3, percent of people living in poverty or economic deprivation. And 4, the percent of residents who report Black and or Latino race ethnicity. So it looked at the racial and ethnic composition. Those factors were examined for 295 municipalities across Massachusetts, as well as for 305 census tracts in the state's 5 largest cities: Boston, Cambridge, Lowell, Springfield, and Worcester. Race and ethnicity data analyzed in this report came from the U.S. Census Bureau. NIBRS was used versus the previously used Uniform Crime Reporting data. Arrests were assigned to the census tract in which they occurred. Score development. 4 key indicators were used in an equation that assigned a disproportionate impact score to each area. Municipalities and or census tracts were scored separately. These indicators were calculated at the area level and included an average number of drug arrests, an average annual rate of drug arrests per 100,000 population, percent of people living in poverty, and the percent of residents who report Black and or Latino race ethnicity. To account for the fact that some areas have consistently high levels of arrest, poverty, and Black and or Latino residents over time, while other areas have experienced more changes in these indicators, the study period was divided into 4 time spans. The scoring equation was applied to generate a DI score and a ranking for each place in each time span. The average of the 4 rankings were calculated to create a final DI score. The final DI score ranges from 0 to 99.52, with higher scores representing higher impacts. The final DI score was again ranked to identify the most disproportionately impacted areas in Massachusetts according to the score. Municipalities with a high concentration of college students or seasonal housing were excluded from the final ranking because the population and arrest data for such areas is unlikely to represent year-round residents. The 5 largest cities were excluded from the municipality rankings because they are analyzed separately at the census tract level. Results: there were 279 municipalities, including in the municipal level ranking. Tier 1 includes the 28 cities and towns in the top 10% of DI scores, ranging from 78.7 to 99.5. The 3 highest scoring communities were Holyoke, New Bedford, and Brockton. Tier 2 includes the next 28 municipalities, which fell into the scope of 11 to 20% of DI scores, ranging from 69.6 to 78.6 for their score. The DI scores in this analysis were calculated using rankings from the following measures and in the following equation: average annual number of drug arrests plus average annual rate of drug arrests per 100,000 population plus percent of people living in poverty plus percent of Black and Latino residents. The time spans used for the analysis were 2000 to 2004, 2005 to 2009, 2010 to 2014, and 2015 through 2017. The data, they ceased to collect it at 2017 because the first adult use dispensaries opened in the fall of 2017. Tier 1, the top 10%, include 88 average mean annual arrests, 308 average annual arrests per 100,000 population, 15% living below the federal poverty line, and 23% Black and or Latino residents. Tier 2 had an average of 50 annual arrests, 226 average annual arrests per 100,000 population, 8% living below the federal poverty line, and 6% Black and or Latino residents. The DI scores for the 305 census tracts with the 5 largest cities are presented in Boston, Springfield, and Worcester had census tracts that fall within the Tier 1 on the DI score. The analysis identifies Massachusetts municipalities and specific census tracts within the 5 largest cities that have experienced high levels of drug arrests compounded by poverty and racial segregation, and thus disproportionately experienced negative impacts from the drug prohibition and enforcement. The areas in the top tiers on both the municipality and census tract rankings are the most disproportionately impacted areas. It is notable, if not surprising, that the majority of municipalities on the current list of disproportionately impacted areas maintained by the Commission fall into tiers 1 and 2 based on the DI scores created in this analysis. Further, many municipalities in tier 1 are legislatively recognized on the state level as, quote, gateway cities. Gateway cities are mid-sized urban centers that serve as regional economic anchors and face a variety of social and economic challenges. It may be appropriate for the Commission to consider using different strategies to attempt to address and ameliorate the impacts of drug enforcement on areas in different tiers or other groupings of areas on this list. Such an approach would reflect the reality that in Tier 1, residents are more likely to have experienced negative impacts from drug enforcement. Eligibility for priority license status and other benefits could be based on a combination of requirements, such as a residence in a Tier 2 disproportionately impacted area and membership in an additional priority group, personal or family history of drug arrest or incarceration, Black race and or Latino ethnicity. A prior study for the Commission led by Dr. Getman analyzed arrest rates in relation to population size, percent of families below the poverty line, and employment rates, and used these indicators to establish a ranking for 160 municipalities in Massachusetts and census tracts in Boston, Worcester, Springfield, and Lowell using the uniform crime reporting data. The current study sought to expand the analysis of DIAs to include most of the 351 cities and towns in Massachusetts and a census tract analysis for all of the cities with over 100,000 residents in the state, and to use additional drug arrests and socio-demographic data. The present study further extends the previous analysis through the use of more comprehensive law enforcement data sets from NIBRS and creates a new empirical approach to identifying communities most impacted by drug enforcement. Drawing on prior research, the study team developed a method to quantify the impact of the war on drugs on geographic areas in Massachusetts using arrest, socioeconomic, and demographic data. Drug arrests from NIBRS were obtained from the Massachusetts Executive Office of Public Safety and Security starting in the 1980s. The Federal Bureau of Investigation began implementing NIBRS in law enforcement agency. Given the nature of DI scores, communities with higher scores are more impacted than communities with lower scores. It may be appropriate for the Commission to consider, again, using different strategies to attempt to address and ameliorate the impacts of drug enforcement on areas in different tiers or other groupings of areas such on this list. Such an approach would reflect the reality that in Tier 1, residents are more likely to have experienced negative impacts from drug enforcement, whereas in lower tiers, it is most likely to be a subset of people who have had such experiences. Eligibility for prior license status and other benefits could be based on a combination of requirements, such as residency in a Tier 2 disproportionately impacted area, plus membership in an additional priority group, such as a personal or family history of drug arrest or incarceration, plus Black race and or Latino ethnicity. Thank you. I know that was long.
Thank you. I just have a quick question for our general counsel. Counsel, do the commissioners need this study to add a census tract to our disproportionately impacted list?
Thank you, Madam Chair. If I could just ask you to clarify the question. You asked,
do we need this study, or do we have the ability to just pick the communities that we would like to add geographically to this disproportionately impacted list? Do we need this study?
Thank you, Madam Chair. I guess the response is that as long as there's a majority of commissioners that vote to take a certain action, so 3 commissioners, you can vote to adopt whatever policy you would like to adopt. But again, it would require the affirmative vote of 3 commissioners to do so.
I understand the quorum and the voting, but what I'm asking you is, do we need to have an independent study, or can we just pick the communities, if we just wanted to vote today, to pick and choose what is in the Donahue report, or maybe we decided the Donahue report isn't what we want it to be? Do we just get to unilaterally pick and choose that, and then we vote and get 3 votes for it? Can we do that?
Madam Chair, if I may, there's certainly no requirement for you to seek outside independent analysis or support for your decision. That being said, it is obviously a better practice to do so, but there's no requirement to your question for you to do that.
So again, we don't need this. We could make this, but this helps us make a more informed, impartial decision. That's what we're doing, or attempting to do here today.
If I may, I'm not sure I can answer that question the way it's been posed, but
I'll rephrase it. So we are not limited by this study. Is that correct? We're not limited.
That is correct, yes.
But I'm assuming that it is best policy that we, and again, after having spent $200,000, that the policy of having an independent study is probably better than us just picking and choosing. Do you think that that's a better policy for the board, or do you think that we should just pick and choose without a study?
Again, if I may,
Please.
again, the decision is up to you. It's not for me to decide or recommend what policy direction that you go in. Generally speaking, it is certainly better to get input from outside organizations, particularly those in the qualified to research and provide opinion. That being said, there are other organizations that may provide context and additional information for you to look at. So, I wouldn't want to take one report sort of on its own without considering other reports or other sources of information that may prove helpful to you.
So okay, all right, thank you, Commissioner Roy.
And I just want to, in the past, I think there's been some confusion about the diversity of the research team. So I just want to share a little bit of the representation overview. Gender, the majority of the team, the research team members were women. Marking strong female representation in research and policy analysis. Racial and ethnic diversity, the team included both Black and white non-Hispanic members, including Dr. Renee Johnson from Johns Hopkins University, and several research assistants contributed to racial and cultural diversity in the group. Geographic diversity, members reside across Massachusetts, urban and rural regions and beyond, including representation from Maryland and New York. This contributed to a wider contextual perspective on cannabis policy. Overall, the research team demonstrated gender inclusivity, racial representation, interdisciplinary collaboration across public universities and public health institutions, aligning with the Commonwealth of Massachusetts' broader goal of diversity, equity, and inclusion in cannabis-related research.
Thank you, Commissioner Stebbins. Do you have any comments?
Thank you, Chair. And, thank you, Commissioner Roy. And walking back to the report, a lot of the issues, thank you for kind of walking through those. I also had a better chance to go back and review the report since our last meeting. I'll be honest, a lot of questions still remain for me, not really with the ultimate findings of the DI report, but how we as a commission move forward. And, starting with the question of, what our intent is here. Is it to, obviously, it's to connect those communities that might have been previously left off the original Getman study, which we know was kind of done in a hurry. This one, UMass Donahue Institute, was also done on a very quick timeline to, again, kind of make up for the lack of time that the Getman study did. But it still leaves a lot of questions for me. And, looking ahead to the motion, I know that we want to get to some type of agreement before we open up our next SEP round. And we just closed an SEP round. So I'm also mindful of timeline, and I want us to do this in a way that is, for me, it's thoughtful, it's engaging with folks who are part of our SEP program now, engaging with those communities who we might be adding or should add. I'll reiterate, the concern I raised last week around census tracts. I know census tracts, as we're all familiar, are a great way to piece together data in the 4 sets of data that the Donahue Institute used. The worry that I expressed last week, kind of continues. And again, Jerry, I appreciate the email you sent out. And I know there's, I think, an early November deadline. You want feedback from the 5 communities that qualify for their census tracts to respond. If I didn't convey it well last week, my concern around just using the census tracts is the war on drugs did not stop on one side of the street. Chances are it impacted a whole neighborhood. I want to engage, at least, as I said, Boston, Worcester, and Springfield. I want their input as to whether they felt that the impacts were felt by neighborhood. I think, at least coming from Springfield, I know everybody knows their neighborhood boundaries and what their neighborhood looks like. So again, those kind of continue to lead to my concerns about supporting any motion today. What I would suggest, and food for thought for my two colleagues, we have talked about having a listening session about the efficacy of our social equity program, get feedback from folks who engage in the social equity program as to whether they have realized the benefits everybody expected, get input from our communities, whether they are seeing the impacts of their designation as a DIA community, an existing DIA community. I know talking to our EPCO team and EED this week, we've tried to do that follow-up. Unfortunately, we have not gotten funding for additional studies to assess the impacts, positive or negative, on DIA designation, and we may never get it. But at the same time, would welcome the opportunity for a listening session. And I think we all got a letter from EON and MCC asking us for that type of engagement. So again, just some food for thought. Again, I think we have some time. I still remain a little reluctant to adopt the new map. I have concerns about what we would be able to offer at tier 2. I think we need to think that through a little bit more, because we have some communities that move from a tier 1 to a tier 2. So a lot of questions still remain for me, a lot of outreach. Chair, by your email still kind of remain outstanding. But those are just my thoughts.
Right. So how about this? Could you convene a listening session? I know you're going to be out of state for a short period of time. If you could conduct a listening session and report back by November 19th, Commissioner Wright?
I think I won't speak for you, but I think we all need to be there. It's a public listening session, not just.
Oh, so we need to.
Yes. So that's right. Yeah.
So we.
Yeah.
Okay.
So if I may,
please, Commissioner Wright.
And I hear you, Commissioner Stebbins. So all of the things you listen, I think to hold ourselves accountable, should put that in a motion language. The things you a public listening session by a certain date, and then we bring it back. So this way it doesn't go out into left field and kind of go on the back burner. If we vote on what we agree on, what we want to see next steps, that and with a date certain, that keeps us all held accountable, like we've done so many other times in so many other motions.
And again, I will repeat, Mr. Executive Director, do we have enough money in our budget to re-engage the Donahue Institute to answer some of these questions, or do we have the opportunity? Because basically it sounds like, what is the intent here? The intent here was, I believe, and again, you've been here longer than I have been, and were you, Commissioner Stebbins, were you involved in this at all when this was happening? Were you engaged and involved in determining what the scope of the work was going to be? I'm not sure if I remember when you got here.
I don't recall being in, I think the report for this work on the study started before I was here.
Was it? I believe it was at the behest of former commissioners Flanagan and Title.
And do we know, again, we're asking what is the intent? It's my recollection that the intent was they were dissatisfied with the first study, and the commissioners determined, again, I understand that across the street, but also I lived in East Hampton when I grew up, and I lived on the town border of Northampton. So just because there are vague municipal boundaries, you know what I mean? So then that begs the question of the entire state, is if we don't have a certain definition of how we're going to put a fence around it, it then becomes absurd. So that's what I'm trying to, because again, I'm thinking of Fitchburg and Leominster. Those two communities, it's almost not even two different communities. They're so socially, culturally, and geographically linked. So do you have a sense of what the potential cost would be to, after the $200,000 we've spent, whether or not we could do this again?
Thank you, Madam Chair. Obviously, I've been catching up as well from past action. So I think I'll cover a couple things within the question of would we be able to pay for it right now with our current financial situation. I think Commissioner Roy covered the two costs that we currently have with the UMass Donahue Institute, who we think very highly of, related to the exclusivity report, which is on a specific timeline based on our regs and is due to you no later than January. And so we have basically used all of the available funding that we have within the current fiscal year to accomplish that goal. So if you were to ask me today to re-engage UMass Donahue on this report, I would not have the financial ability to do that. But certainly I would point out in the last two fiscal years, I believe, based on the motion from November of 22, which I believe this board was included in, the EPCO team has requested funding to readdress anything from the study that was discussed previously by the board, and we've been unable to accommodate that.
Can you just clarify that? So that, again, I remember that goes back to 2022, and I do remember that in some of those subsequent budget years, we actually gave money back to the Commonwealth that we had not fully spent. So do you have any history as to why that was not followed up on? Because we ended up giving back money, and now we're begging for money. So why didn't that occur?
I do not know the answer to that question. I can tell you, obviously, in the example of exclusivity, the CFAO in this past ending fiscal year, where we had some flexibility, we moved to make the exclusivity working group get the resources they needed on that particular report. I don't know from prior years. I know that it was requested in the budget, and the amount was $200,000, a request from the EPCO team to re-engage on a study here, which was not able to be handled. Whether or not there was funding that potentially previously could have been reallocated, I don't know the answer to that question.
Okay, Commissioner Roy, then Commissioner.
Yes, so I guess I have a question for Commissioner Stebbins, to the chair. So when we get the exclusivity around delivery report back from the Donahue Institute around delivery, will you be will we apply the same curiosity lens, put it out first to stakeholders before we're going to put it through the same rigors for that, right? Exact same thing, putting it out, as General Counsel said, listening to other folks, not just accepting it. So want to get assurances that will be put through the exact same process as this report. As the general counsel said, we need to listen to external stakeholders. And so I just, for reassurances, yeah.
Commissioner Simmons?
Thank you, Chair. Yeah, this for me is not about questioning UMass Institute's work. I had the opportunity to work with them when I was at the gaming commission. I know the timeline for the exclusivity for delivery timeframe is really short, right? Because we have to turn around a decision before April, I think, right, to the extension. And Chair, I think to your point, I'm not advocating a need to engage Donahue Institute. I have several small questions about what came out in their final report. For me, I don't need to re-engage them. I think the report they gave us, I appreciate. And, again, I don't feel a need to re-engage them, and not sure why we would.
Well, because we spent $200,000 and we've let this hang out for 4 years. Right. So that's why it's, your tenure, precedes mine. And again, I know that a lot of this stuff is done offline, but we've spent this money and now we're saying that we don't have the confidence in it and the methodology. We're basically questioning their methodology is what I understand. And in terms of getting feedback, perhaps, and again, perhaps maybe we can table this for the day and maybe consider, and I don't want to, but in terms of maybe, and this is one of the things I hope to be doing just in general, with my return back as chair, maybe the first week in November, we could do a listening session and all the commissioners can do that. So I'll table that for, and we'll Commissioner listening.
I do. So Commissioner Simmons, and I appreciate your feedback. So number one is the census tracts, right? So you want to hear directly back from Worcester, Springfield, and who else? I'm sorry, who else did you say?
I think we've reached out to the high communities that have a population in excess of 100,000. Yep. I think, Chair, you gave them till November, early November.
One thing, I think that we could actually speed this up and ask them to get the letter. Yeah, I can't remember exactly what the date was.
And then, so census tracts from the 5 cities, a public listening session with any stakeholders who have concern over this or want to share their thoughts on this. Was there anything else?
I think, there's still an outstanding question, I think, for us that the Donahue Institute gave us, which was you have a whole tier 2, and I want to engage in more discussion on the tier 2 list of communities that they proposed to us that we come up with a different set of ways to treat those tier 2 communities. Mm-hmm. I'm not sure we've all had that conversation. So again, those, kind of for me remain,
Can I just pose a question? When you say in terms of how we treat them, but it's the list, it's the census tract, it's the how we treat them. Is that potentially a different issue?
I think that's the question that the Donahue Institute left up.
Mm-hmm. But my point is in terms of we've got this information, we have this information, and now is it incumbent upon us taking their recommendation on your question? Is that a separate conversation to accepting the $200,000 study? I don't know if I'm making that question clear.
No, if you can ask.
So what you said, so we treat the tiers differently, right? So in terms of, when you're saying treating them, is it how they engage, how they get benefits? What is the treatment that's different? Again, I'm still.
And I think that was the question the Donahue Institute, if I'm reading the report correctly, that's the question they left for us. Like, here are our top 20%. We've broken it into 2 tiers. Commission, you may want to think about how you treat that second tier of communities. If you don't think they're tier 1 but tier 2, I think that, again, that was what I pulled from rereading the report.
Right, Commissioner Roy.
Yeah, and I think the recommendation from the Donahue Institute was for us to contemplate eligibility for priority license status and other benefits could be based on a combination of requirements, to your point. So such as residency in a tier 2 disproportionately impacted area, plus membership in an additional priority group, such as personal or family history of drug arrest or incarceration, plus Black race or Latino ethnicity. So that was kind of, okay, you're in a tier 2. They've run them, all the 4 sets of the points. And so if you, in addition to that, had a personal or family history of drug arrest or incarceration or of Black race or Latino ethnicity. So again, I'm going to ask for motion language to hold us accountable on the listing, on bring back the communities.
So why don't we proceed? And hopefully at some point today we can. Again, my Robert's rules are rusty, but I don't know if it's tabling or we'll move this back in the agenda, and hopefully we can get some motion language that holds us accountable, so it's not another 4 years.
So if I may,
please.
Okay, the motion language should include receiving feedback from on the census tracts from the 5 cities listed in the report, hold a public listening session the first week in November, and bring back recommendations on tier 2 communities.
Does that
anything else you want to add?
Good. General Counsel, are you good with that? Do you need any clarification based on what Commissioner Roy just said?
Thank you, Chair. I think I can start working on some motion language based on.
I just want to be inclusive. Is there anything you'd like to see in that?
No, I think that's the start. I think that's where we're trying to move the ball. Mm-hmm. Again, the letter that was shared with all of us to say, stop. We've walked away with a number of benefits from our listening sessions. So I think having fun in this conversation would be great.
Again, I love listening sessions, but at some point you have to do these sessions. And again, since this has been listened a long time, a lot of money's been spent. We have to make a decision. And if we don't have the votes to do it, we should just, you know what I mean? So I just don't want to be wasting any more time, any more money, and just sort of address it. General Counsel, you do you have the draft of the motion?
No, no, not quite yet. I don't work that fast. I was just going to ask, if I may, to Commissioner Roy, to have you repeat the items that you just stated.
So as we've done in the past, motion language kind of keeps us held accountable with a date certain. So in the motion language, to receive feedback, do we know the date on that letter? Does anybody have that handy? I can share that with you.
The one that I sent out after Commissioner Stebbins made the
municipal about the census tracts.
Excuse me, hold on one second. If I can acknowledge Maggie and Cola, when did the letter, we said coming back, when did the letter go out? That was sent to the municipality. It was right after I think it might have been the day after the last meeting, but I'm not sure. Or it was supposed to be by 11 o'clock, day after the last meeting. And I think it went out under my signature, but I know you facilitated that.
Friday, October 17th.
October 17th.
Wonderful. Okay, so if I may, Madam Chair, please. Okay, General Counsel. So I think I'm just gonna, I'll throw out the three things, and how you suss it out into motion language will be great. So we're looking for feedback from municipal leaders regarding census tracts in the 5 cities enumerated in the report by November 15th. For the commission to hold a public listening session relative to the DIA report during the first week of November, and for the commission to bring back recommendations regarding identified tier 2 communities, I would say also by the November 15th.
All right, I think that's.
Unless Commissioner Stebbins, can you think of anything else?
No, I mean, unless we want to get specific, I know we're scheduled to have a public meeting on the 7th. Do we want to schedule a public listening session?
Yeah, we love it. Okay, so November 6th, public listening session. Okay, that's awesome.
And we can be more accommodating in terms of remote or not. I prefer the meetings in person, but we could do something.
I think testimony, though, we usually have in person.
Okay, all right.
We have in person, but people can also email the virtual interaction.
Oh, but there'll only be 2 of us. Or will it be 3 of us?
No, the first week.
Okay, I'm getting my weeks all mixed up.
I don't know what day it is. Anyway. All right, so we will move this back in the agenda, and then we will vote on that different motion language. And now we are going to the contract extension regarding the company, the contract with Endemia. I think that Executive Director Hearn is going to be presenting this.
Absolutely. Thank you, Madam Chair. And if there are any specific questions, we can also bring up the CTIO on the product itself, CFAO on the contract, as well as the legal team work with the CFAO on the contract. And so Endemia, this is an interim contract to extend what is the badging and credentialing services that were currently provided. The reason it's interim is that we were looking at potential changes to badging, which will obviously be part of the package we'll discuss later. And so we want to be prepared in the future for any potential changes. So this is really a bridge contract extension. The justification of how they.
If you could just, excuse me, if you could just clarify for the public, just the terms of the extension, how long that goes through.
Yes, I believe it is into the end of August 31st, 2026.
Thank you. Thanks,
and again, the procurement team, legal and IT put together a bit of a background for you. And again, we are in a position where I think we all know we're looking to invest and have more robust IT options in the future. So these contracts allow us to continue to work with a vendor that we rely on, but also be prepared in the future to change services as needed.
Thank you. Any questions, Commissioner Roy?
Thank you, Mr. Executive Director. Also, could you just talk about the company? I know you kind of glossed on it, but for the public, what services they provide? I know it's patients, it's caregiver IDs, it's our own investigator ID. Could you just give like a thorough explanation?
We're gonna. I think you're gonna hand that off to the Chief of Technology
and
Innovation Officer. I didn't know you had a new ad, innovation. I like that.
Thank you, Chair. So Idemia is, for the Commission, is providing all the printing services, mailing services related to the patient and caregiver IDs, the agent badges, as well as our own internal investigator and commissioner badges for on-site inspections. They are integrated through our licensing and our medical platform with MassCIP and MMJOS. Actually, is the integrator that sends the requests to Idemia to produce those badges. They produce them in batches once a week and mail them out directly to the appropriate recipient.
Commissioner Roy?
Okay, and just for clarity, we use the word badges, and people associate the word badge with a badge.
Correct. They're not badges. They're more akin to a driver's license.
Yes.
So they're plastic printed. They do carry the seal, so they're more official than just if we were to laminate cards ourselves. Idemia is actually one of the leaders in the world on official IDs, including driver's licenses and such, which is why that was chosen primarily around the patient side for those needing to have the ID card, especially back in the medical day.
Commissioner Stebbins, you had your hand up previously. Okay, Commissioner Wright. Okay, all right.
Oh, okay. I just have 2 questions. This might be a CFAO question. So, what do we spend on average per year to again? This is a service we provide to patients because in the onset, I think patients had to pay, and then the previous commissioner said no. We want to increase access and opportunity for patients. So the commission will absorb the cost of unless you lose it, then you have to pay. And so that's my question. And does this company also have digitized identification that we could look into when we have the resources available.
So I'll answer the second question first, and then I'll turn it over to our CFAO on the budget and numbers. So IDEMIA is a very broad platform. They do offer digital and other electronic services and identification management services. Our plan is to, I believe we previously announced the plan to put out an RFI initially on what the state of the art is today on electronic identification. And they've already expressed interest and would respond to that RFI as I hope as would at that time.
Commissioner Rowe?
Have we analyzed the cost? I mean, we all want to see less plastic. I think we are all in agreement, right? To see less plastic. Have we analyzed what is there an additional cost to digitize? I know I'm sure there's a startup cost, but like, is the maintenance cost similar?
That's one of the goals of the RFI is to identify that.
Okay.
So certainly there would be an initial launching cost to program and put it together. I'm paying for an app or mobile app that would need to be developed. And then typically there's ongoing per badge charges, even though it's not physical. There's still a process for each badge and a cost for each badge, even though it would be a digital cost. So per badge would be certainly mailing costs would go away.
Yep.
But there certainly would be. But that's the goal of the RFI is to get an understanding of what it looks like, so that we can bring it back to you to understand as you begin evaluating the electronic patient badge and the agent badges. What is the true cost savings or opportunity if there is any?
So we might be in the App Store someday.
We could be in the App Store.
All right, very cool. Okay, very cool. And then Lisa, if you know, like on average, what are the commission costs is, and again, not counting the employees, but we provide this as a cost savings benefit to our medical patients. But I know it's not broken up that way. So on average, could you share with the public what we spend?
Sure. Our cost in FY25 was a total of $827,000. Significant. That was split between $220,000 for the medical program and $600,000 for the adult use side.
And Commissioner Stebbins, do you have any questions, comments?
Yeah, and quickly, but with our CFAO, I think Commissioner Roy covered a couple of questions I had about what our plan is to transition to updated technology, right, and ease and efficiency. With respect to our cost, though, because some folks are now being renewed on a 3-year basis, is our expenses coming down when it comes to agent registration?
Yes, our cost in 2022 was over $1 million, so we're about a 20% reduction. So we are seeing the costs go down each year, but it will level out. We are also seeing a reduction in agent renewals as well. So we are seeing a reduction in cost, about 20% less than we were 3 years ago.
Yeah, yes. And so if I can just comment, that is great news. And this is also part of why the Red Tape Reduction Committee, looking at ways that we can actually save money. And this was something I raised a few years ago, the issue of plastic, and it was explained to me in one of the conversations, how do you do this, that, there are some folks who still want to hold that, and that is helpful to them. But as long as this company knows that, I'm assuming, so are they going to be advising us as to how I won't say put them out of business, because we won't put them out of business, but how we are going to move towards a more environmentally sound, but also more possibly secure and also easier to trust? Did you say they're involved in helping us figure out those potential cost savings?
So thank you, Chair. We have inquired with them about their capability of, do they offer digital? Obviously, they know the world is going that direction. They're very active, again, working with Department of Motor Vehicles across the country and coming up with viable solutions for identification. So they know we are, to us, it's a big contract. To them, we're a smaller contract. So they, it's not that they're worried about us leaving them, but obviously they are interested. We want to keep the electronic business. And again, we've asked them if they have capabilities. They provide us a little bit of background material. But again, and offered to be involved when we send out an RFI. They would definitely have expressed interest to want to reply to that in full.
Are they a Massachusetts-based company? I don't know if I remember that.
No.
Okay. Commissioner Roy?
Yeah, my question is more a legal one with regards to regulation. So DGC or GC. So it's my understanding right now that our licensees do not accept electronic forms of identification. So in the medical marijuana access working group, I'm just flagging that if we do digitize, what implication does that have around our licensees? I mean, I've actually seen it happen where someone was refused at the door because they're like, no, I did renew my license with the RMV. Look, I have this, and they're like, nope, sorry. So I don't know if there's any thoughts around that.
Thank you. I don't know if I have any particular thoughts on that. I think part of the justification here for this extension or renewal, if you will, is to bridge the gap and to get us to the next phase of what we're trying to do here. So I think with that in mind, that's the approach that the team has taken.
I think we need a legal review too around the acceptance of electronic forms of identification at this, like in the background.
Meaning how we clarify this currently? Is that what you're asking?
No, I'm saying, like, as we're having these conversations, we all want to digitize. I think we're all in agreement. And so in the background conversation should be, how does that impact our current scheme and how we accept identification in 2 areas, at the foyer in the vestibule and at the point of sale. And so that's just like, this is kind of just like thinking ahead, thinking of red tape removal type of thing, and just kind of flagging it. It's not totally germane to extending this contract today, but it's just like down the road.
But we don't have an opportunity to have these conversations in a public meeting, so this is good. Thank you. Go ahead.
Thank you. And I would express that this is a similar conversation we are having across the board of starting to look ahead as we start thinking about procurement of the medical portal. There's certainly been some changes, that speaking with Andrew, and I know the medical working group, looking at changes in the regulations on right now, it's very prescriptive of how the whole registration process works, which drives a lot of the antiquity of the way MMJOS works. Yeah. And so to give us the most flexibility, and I flagged some stuff for our legal team to look at, is just even the way it's in regulation on how a patient registers and gets their temp registration and temp cards, and some of that's not clear, and some of it creates a lot of extra overhead. And again, I'd nominate that for the red tape review. But this you're actually thinking ahead where I am, being able to get the regulations in line ahead before we make a change of going to a new platform, then waiting to get a new platform, then trying to.
Commissioner, first, you're on that. You're going to be on that working group. Yes? Did we nominate you?
Red tape. I don't believe I was listening initially, but if I'm being volunteered, I certainly.
Volunteered.
Is noted innovation is in my title, and that falls under the scope of innovation. My understanding. So I'm glad to be involved.
It was an error on my part, so I didn't rectify that. Commissioner,
I just have a final question. And I know between the ED and you, Paul, you interact with Canra on a regular basis. I just have to ask, could you ask your counterparts in Canra if any of them are digitized, what steps they're taking towards digitizing their medical program?
I've had some, we actually had that conversation preliminary. At this point, to my knowledge, no one has got a full electronic program for identification yet. Again, a number of other states through the RMVs are looking at electronic identifications, and obviously each state's organized differently, and those that are more integrated with the state central operations are relying on their DMV, RMV equivalent for identifications and such. And I know a couple of states are working towards that, but certainly a conversation we continue. I will bring it back up again as a part of this to see if there's been any changes. So.
Yes, thank you. Appreciate that very much.
Any further questions and comments? Oh, I was going to do that immediately. So anyway, can we quickly take this vote? So Commissioner Roy, I will entertain a motion to approve the contract extension as recommended by the staff. Do I hear that motion? So moved. Do I hear a second? Second. Having been moved and seconded, we will take a call of the roll. Chair votes aye. Commissioner Stebbins. Aye. Commissioner Roy.
Aye.
And it passes unanimously. So we are going to take a short break. We'll be back promptly at 11:30.
All right, want to see something cool? We can just jump forward. All right. Hold on. We can just jump forward. I'm a time traveling towel. Have you ever wanted to time travel with a towel? Let's do it. Let's jump forward. I don't want to miss the beginning, but let's jump forward in time. Let's jump forward more. Oh, look at this. You don't even have to watch the recess. That's the benefit of Towel Stream, ladies and gentlemen. 10,000 people, by the way, were watching at one point on the Towel X. The commissioner was probably like, oh my God. 10,000 people going from the DOJ press conference to the commission's meeting. All right, commission. They're back. Let's take it away. Social consumption discussions coming up. Towels off to lunch.
Commissioner Roy has drafted, or our council has drafted. Would you like to read this?
I want to thank the executive director for providing the motion language. The motion reads as follows: a motion to request feedback from municipal leaders relating to census tract designations contained in the March 2021 UMass Donahue Institute report by November 15th, 2025. Schedule a listening session relative to that report on November 6th, 2025.
If we could just add on or about, we think that that's going to be the right date, but
okay. Yes,
okay.
On or about November 6, 2025, and direct the executive director and the EPCO team to draft a notice to solicit comments for the listening session and receive recommendations from staff and external stakeholders relative to communities identified as Tier 2 in that report by November 15th, 2025.
Commissioner Stebbins?
Thank you, Chair. Thank you, Commissioner Roy. I want to acknowledge that piece because I'm starting to call this the Erica Bruno rule. Her only suggestions that she had of it's great to post the notice for a listening session, but gives us the opportunity to kind of explicitly ask for areas where we're seeking testimony. So that piece about the ED working with the EPCO team, I think would be helpful. Again, I mentioned the ED and the EPCO team of this commission was trying to get money to do a follow-up study on the impact on the airwaves. We don't know when that may ever come, so maybe using this opportunity for the EPCO to put the questions out there to get some qualitative feedback about the impact for DIAs, I think would be helpful. So appreciate that piece being added.
Okay, you'll make Commissioner, so moved. And it's been moved and seconded. I'll take a call to roll. Chair votes aye. Commissioner Stebbins?
Aye.
Commissioner Roy?
Aye.
Unanimously approved. Okay, now, we're moving on to the heart of it today, and I will turn the discussion and review of draft regulations and policy revisions to 995 CMR 500 and 935 CMR 501 regarding social consumption. So I will turn this over to DGC Mike Baker.
Thank you, Madam Chair. It's been great working with you to catch up to speed on all these regulations. Thank you for taking the time. And thank you other commissioners for your comments and feedback. Some of that has been incorporated into this draft. Before we get into this, I just wanted to give kind of an overview of how we got to this specific draft. So we had a public hearing session, I think it was September 8th, but it was early September. What staff did after that was basically review all of the written and oral testimony that we received at the public listening or public hearing. What Government Affairs did was they summarized and organized all those public comments for staff review, and then we had a very large conversation among staff about which comments we should incorporate into this draft, and we ultimately updated this draft on ones that we felt appropriate to amend. So the list before you today that we're going to be reviewing is a list of all of the staff amendments that we've made, and we're going to walk through all of those amendments and tell you why we made them. And I've coordinated with the chair. We've proposed at our next meeting to go through the larger policy discussion areas that are largely under the commissioner's purview as policy matters. So I do anticipate a large discussion at the next public meeting where we'll be getting into some more back and forth with commissioners, because obviously those are purely policy matters. So we didn't implement any policy matters in that fall under your jurisdiction into this draft because, again, we're going to have that conversation next. So in saying all that, we also wanted to thank the rest of the legal team, Phil, Erica, and Rachel here. We've worked really hard to get prepared for this conversation. So in saying that, I think we're starting on page 10 of the draft, and I will turn it over to AGC Bruno.
So the first amendment on page 10 is 500.002, the definition of inversion. Inversion means the unauthorized insertion of marijuana or marijuana products cultivated or produced by an individual or entity not licensed by the of inversion. On page So the first amendment on page 10 is 500.002, the definition of inversion. Inversion means the unauthorized insertion of marijuana or marijuana products cultivated or produced by an individual or entity not licensed by the Cannabis Control Commission into the regulated market. For clarification as to the nature of the amendment, this is really a more grammatical type of amendment to add the word or between individual and entity. It looks like that might have just been something we overlooked, so just wanted to make sure that we included that to clarify that it's an individual or an entity. Thank you. Commissioner Roy?
Thank you, Madam Chair. Thank you, Attorney Bruno. And also, I just want to point out, Attorney Bruno put together this ledger map for us, and this is the first time we've had this, and I can't count the minutes we've spent, what page, where, how, who. So this is an incredibly helpful tool to help us, move at a good pace. So I want to thank you so much. I think it's important that we have inversion in here. Yesterday in our, I think it was in our news clips, or I got it from somewhere. There was a major case of inversion in New York, so it's not unique to Massachusetts. The talking about the issue of inversion, it's nationwide problem. I'm glad to see this in here. They did something in New York called debarment as a penalty. Did you read down your head? And I thought that was so basically the principles involved in the inversion scheme can no longer apply. They've been debarred from applying to be any kind of principle again. So I thought that was interesting. I just want to make note of that. And I don't think we have that punitive measure here in Massachusetts, but and we will be having a meeting, right, Chair, about the how do we mitigate?
We're going to be holding a meeting I'm not sure because a couple of things got moved, but we will be holding a meeting with a group of persons to discuss specifically the issue of inversion and the potential public health and safety threat it poses, but also the lack of oversight also and registration also impacts our revenues. So if I could just say, because I know that I have this here. You have a printed up copy of that.
I do. I asked Abby to do that.
That's
a lot. So thank you, Abby. You so graciously did.
But I just have.
No, I changed the entire way.
Oh, the entire way.
Yeah.
It's okay. We can go through. It's just seeing this is a little harder.
I just like to make notes.
No, I do too. If it is possible to get me at least the first. I don't know, what are the total pages in that printed out version that we have?
130, 121.
Oh, thank you very much. Thank you.
But you're going to be at different pages because this is legal size and that's not.
Okay, that's okay. Then we ran into that before. Okay,
thank you.
If there is any possibility of getting me something in writing so I can be also taking notes.
We'll get a hard copy, man.
I didn't look what that was. I thought it was that and I just opened it up and it didn't.
Travis, I'll draw them too. I'm following along.
Yeah.
I can hear the ghost of Alyssa Stack yelling at all of us right now about printing this, but anyway, senior citizens, not that you're in that group, but senior citizens see as well. So yeah, that's right, you're almost there. Okay, go ahead, DGC, sorry.
Thank you, Madam Chair. So again, just turning our attention back to the definition, and the amendment we're seeking here is just the or between individual or entity, clerical mistake, and we're just trying to clean it up. So easy. It didn't have anything in between individual entity, which obviously, right, and that's clearly not obviously the term of art throughout is individual or entity through the regs, and so we're keeping it consistent with this amendment.
So again, just because this is my first time being at this stage in the regulatory process. So we're just going through, we're not adopting any of this language. So if you can just make sure that I understand how I'm managing this. So we have this, it's suggested by staff. So how do we track everything that we've said yay and nay to? Do we need to take a vote right now to say, yes, we like that, or?
No, so the way that we move through this expeditiously is that you get consensus between the commissioners. So once we have identified that there's consensus to accept this, rather than take a vote, we wait until the end of the package and then vote.
But my point is, so in working at this, if there, thank you so much. If there's not, you'll guide me through that. We didn't really, I didn't ask this question yesterday, and this is my fault. So just making sure that I understand. So how do we technically gain consensus? Is we all just nod and go yes, or what do we do? We're not voting. So
that's generally how we've conducted
it. You're looking now. Okay, all right. So
consensus.
Got it. Okay, all right, good. All right, cool. We got that down. Okay, thank you. All right, going beyond. So now we're going to page 16.
Yes, and then also just to say, we are keeping track of the consensus and all the amendments to be made. So that's why we have the computers out now and are doing it in real time.
Great, thank you. Commissioner Ray, question?
Yeah, did you see? So in the hard copy, for instance, so where we have made changes, amendments, they're in like my copy, like a purpley blue. So for instance, like a non-cannabis entity means. So that means since we're not talking about it today, we've already achieved consensus.
Exactly.
So it's the things that are newer additions, newer amendments, newer. Okay.
Exactly. Obviously, we've been criticized going through this process slowly. We're trying to expedite it as much as we can through hinging our procedures here. And so this is a way of any new material that staff made amendments to. We are focusing on that for this discussion.
Great. That's awesome.
Thank you. Go ahead, Attorney Baker.
The next amendment is at 500.002, registered qualifying patient or patient. Means a qualifying patient who is currently and validly issued a temporary or annual registration card by the commission. The change here is to add or patient because throughout the regulations, the term patient is used, but we haven't identified it as connecting to the definition of registered qualifying patient. So for consistency and clarification, that anytime the term patient is used, it is referenced to registered qualifying patient.
Thank you. Attorney Baker.
Thank you. And just a little context here. We had identified this before in our prior discussions, but we merged the definition to keep it consistent with the practice. Under the definition section, you can see registered qualifying patient or patient. We have if there's two terms of art throughout the definitions, you can do this as an amendment rather than pulling it out and keeping it as its own definition. So we've pulled them together for consistency's sake throughout the definitions.
Okay, left and right, moving on. All consensus. Okay, thank you.
All right, we'll move to page 18. 500.002 temporary consumption event.
I'm just looking here just to back up under residence, and it appears to be that that's only in blue now because it was already there. It's just that's how it comes up because it's a link.
If I may, Madam Chair.
Please, thank you.
Sorry. If I may, it's in blue because it's been amended in prior rounds, and so there hasn't been, unless we are identifying it as the legal team, there hasn't been any subsequent change after public comment.
Okay, Attorney Baker.
If it appears in blue, we had submitted that language to the secretary, so it's live within this round.
Okay.
Whereas if it's not in blue or highlighted in redlined, then that is official reg that has already been promulgated.
Okay, thank you. All right, so we're going to page 18. All right, go ahead.
If I may, Madam Chair.
Please, thank you. Temporary.
So 500.00 temporary consumption event means a single event that a marijuana event organizer facilitates after obtaining approval from the commission.
What may have happened is if you printed up the clean copy, it would not be in the same page and the red lines wouldn't be reflected there because it's the clean copy.
Yeah, so it's not like, let me show you. Okay.
This happened before. It was different.
Thank you. You have the medical regulations.
Oh, yeah, I know it's 501. Okay.
I have what you
right. Okay. So you got 501 too then.
Yeah.
Madam Chair, do you want to take a quick break and we
Yes,
can
I'll entertain a motion to briefly suspend so we can make sure that we're all following the same. Commissioner Rudd?
Makes sense.
Thank you.
Yes.
Commissioner Rudd?
Yes.
Commissioner Stebbins? All in favor say aye. Aye opposed? The ayes have it. So we will get our paperwork done.
I know we emailed around so many things, so I'm
We'll keep the coverage. I'm going to go get some lunch. They'll be back from recess in a few minutes. They're working hard. Your government tax dollars at work, ladies and gentlemen. Also, I'm a towel. If you want to send donations, if you like this coverage of the CCC, I'll go ahead and drop that information in the chat. Someone actually sent me a DM earlier and said they sent me a few dollars for pizza at 7-Eleven. So, all right, I'll go do that. But yeah, I dropped it in the chat. I don't know, it's a public information service. There are no sponsors. You don't see any of that here. So if you like the content, you want to see it continue, you want to help other people become educated, informed, and erudite members of the polity, such as to ward off the usurpation of our representative forms of government worldwide, you can support Little Towel. Towel loves you all very much. Back in a few minutes. Hello, I got some towel lunch. I know we could be watching other things, but I really didn't want to miss anything that the commission did about social consumption. So we're going to hang out. We're going to check this out. It starts back up at 12:45. That will be more social consumption discussion, and I appreciate everybody's patience. Towel's not exactly feeling great, but I'll feel better when I eat some towel lunch, and thanks for tuning in. Well, the Massachusetts CCC is a little late. It is very important, though. They're doing their social consumption markup. So Tao's not going anywhere. I'm going to eat my chicken. I'm going to watch them. They should be back in a few minutes. They had some, like, printing to do or something? I don't know. It had something to do with printing. I was eating chicken. I don't know. But they're almost done with whatever it is they're doing. And then they're going to come back. We're going to eat lunch together. I mean, I haven't even eaten my chicken. I was just cooking my chicken. All right? I had to go get it. I had to go find... I spelled the word distribution wrong in one of my posts. That's okay. Anyway, I'm Grant Smith Ellis. Thanks very much for tuning in. If you're just wondering, I thought they were going to do their social consumption. They're going to do that markup probably in the next few minutes. We're going to watch it together. And the big news of the day was the FBI raiding the NBA, a number of NBA players, and taking down 4 of the 5 families on the Italian American Commission. The mafia apparently was alive and well, but was taken down this morning in a multi-headed strike. Quite a day to be just watching, covering the news, having it all play out. Yes, I am expecting the CCC to return here. They've been on lunch for quite a while. I think at least they're on lunch. And once they get back to work, I will sit down to lunch. So, thanks for hanging out with me today. Not a lot of lunch coverage for me. I did some coverage in the pre-show. And then, of course, we got the opportunity to watch the a little bit of the DOJ press conference about that big nationwide multi-million dollar, tens of millions of dollar NBA betting, bet rigging scheme that was uncovered. So it's been quite a day. And, all right, Cannabis Commission, come on now. It's time to get back to work. Tal wants to eat his chicken. They are obviously, I think what they did was they had some printing to redo because they didn't have marked up versions. And you're talking about printing like 320 pages, so. And I mean, it's fine to have a clean copy, but markups, like red line markups, aren't necessarily going to print. You know, I think you have to print specifically with markups. I also got some candy corn. I shouldn't eat it before my chicken, though. All right. That's enough for me. I'm going to eat. Commission should be back any minute now. Thanks for hanging out, folks. My name's Grant Smith Ellis.
That was me. Yep.
We're not reverbing right now. We're live now? All right, thank you. And again, my apologies to the general public. We had an issue where we were asking for a hard copy of the regulatory change, or a full copy of the regulation, and we had a different copy. So we're in the process of printing that up, but we're going to try to move on. And again, my apologies for making people wait due to technical difficulties. So, Attorney Baker.
Yes, thank you very much. And, great time being here. Thanks all.
Thanks, Paul.
Thank you, Madam Chair. So we are going to turn to the next amendment on page 18. That's the definition of temporary consumption event. And that means a single day event that the marijuana event organizer facilitates after obtaining approval from the commission. The amendment here is relative to a single day. And that is due to clarifying from public testimony what an event means. There was some confusion about what does event mean? Is it multiple days in a row? And so we wanted to clarify that in light of this draft with the 24 days, that's a 24 single day events. And obviously they can be consecutive days under the current draft, but we wanted to clarify in the definition so that folks understood that's 24 hours.
Commissioner Wright?
Okay, can we unpack that a little too? So the 24 days, 5 consecutive days, those are considered each day individual? Is that what you just said?
Yes, exactly. So I think that there's been confusion as to if I have an event and that event lasts 5 days, let's say I had the Freedom Rally and we did a Freedom Rally on the Common for 5 days straight, is that one event? And so if the board, which it chose to under the last draft, had it at 24 days with 5 days consecutively being the max allowed under the license type, we wanted to clarify that 24 days meant a single day. 24 events meant a single day, excuse me.
Okay, so the Freedom Rally, so if I had a event there 5 consecutive days, I have to get now 5 separate permits,
No, that's ultimately up to the board to decide. It's just clarifying again for the 24 events that are allowed under the draft, that they are single day.
Is it how counting it?
Yes.
Versus how we're allowing it to occur. They're almost 2 different things, right? So,
okay.
So this is what I think you're saying. So
Yeah, it's confusing. 5. Yes, so like a marijuana event organizer shall conduct no more than 24 single days of permitted sales in no more than 5 consecutive days. So in a calendar year, no more than 5 consecutive days and no more than 24 single days. So in this, the 5 consecutive days of sales are considered now 5 single days of, it's like at odds.
Yeah, it's 5 single days out of your 24 allowed.
That doesn't make sense to me.
Ultimately, again, this is a commissioner decision. So this was a technical amendment because we felt compelled to make it. However, this does fall under commissioner decisions.
On this, page 18 on this.
And Madam Chair, if I may.
There it is, okay. Sorry.
Yeah, so I'm trying to reconcile this language with the marijuana event organizer language, which is no more than 24 single days in a calendar year and no more than 5 consecutive days. So
do we have internal consistency, or is this something we need to maybe?
So I think that it's consistent, but ultimately, this single day is just clarifying that the 24 allotted days are counted.
So what you're saying, this is a measurement.
Can we marry the language?
So when we were when Madam Chair, when you and I were talking about what to take up, we had potentially mentioned that for marijuana event organizers, we could maybe table it because there's a lot of commissioner decisions relative to it. This is obviously a definition relative to that license type, so we could table it in light of the next conversation.
We had discussed when you were all running through it, and I said that this is one of those things that I still have not totally got my head wrapped around.
Sure.
So I think that there is still some area for debate, and this might not be as some emphasis. So can we do that? Please, Commissioner Stevens, do you have any comments or questions?
Thank you, Chair. I agree with our Deputy GC. I think when people saw the original proposal for a marijuana event organizer license, it was 24 days up to 5 days. So people started to multiply that out and say, oh, 24 times 5, I can do 120 days. So we were trying to clarify the language, certainly. I'm wondering if, as I look at marijuana event organizer, if there's some benefit to including some language around the event plan, maybe in the definition of temporary consumption event. Somehow we can marry that from the marijuana event organizer definition into the temporary consumption event license definition.
Cite it, maybe?
Open to suggestions, but
Go ahead, Attorney Baker.
Yeah, I think one of the things that we were kicking around at the interdepartmental meeting and within legal subsequent to that conversation was kind of what you hit on, Commissioner Roy, which is how do we submit them practically? Are we going to submit them single day events, or if I have that, again, just using this as an example, if we did the Boston Freedom Rally and they proposed it to be 5 days on the Common, you hit on, Commissioner Roy, which at the interdepartmental meeting and within legal subsequent to that conversation was kind of what you hit on, Commissioner Roy, which is how do we submit them practically? Are we going to submit them single day events, or if I have that, again, just using this as an example, if we did the Boston Freedom Rally and they proposed it to be 5 days on the Common, would you have to submit 5 different times? Would you have to get the event plan 5 separate times? That's obviously not the intention behind this draft. However, I think we could handle that in guidance or express language.
Just back up and restate, because what we're saying is 5 days is kind of we're cordoning this off. And we're saying the example that you gave, which is the temporary, the summertime beer halls, near the concert places, right? And so putting a maximum amount of total days, but also saying, we're not going to allow you to be there for every single day, because then and so we said 5 consecutive. But to me, it doesn't feel like 5, 5, 5. It means like you put in your plan and you're going to rope around 5 days within that 24. Right? That's what we're saying. Is that what we're saying?
I believe that was the intent of the draft, but I think as there's been further confusion, that we can clean it up with express language that says
Commissioner Roy?
If I may, instead of saying a single day event, wouldn't it be more accurate to say no more than 5 consecutive days and 24 single days as opposed
24 total?
Total, yes. So
go ahead, Attorney Baker. Sorry.
Thank you so much. I think that this would be a good discussion now that we've raised it at a public meeting. We're all on the same page that we want to turn our attention to it. And I think you have a lot of commissioner decisions relative to the event organizer in general.
You think?
Yes, I think now we raised it, we've talked about it. We're all on notice that we want to touch up on this next time.
Both commissioners consenting? Can we consent? Yes, we're doing that.
All right.
All right.
Thank you.
Sorry, so I'm going to put a little note in the guide.
Electronic cigarettes, electronic cigars, electronic pipes, electronic nicotine delivery systems, or any other similar products that rely on vaporization or aerosolization, provided, however, that tobacco products shall also include any component, part, or accessory of a tobacco product, and provided further that tobacco product shall not include a product that has been approved by the United States Food and Drug Administration for the sale or use of, for the sale or use as a tobacco cessation product and is marketed and sold exclusively for the approved purpose.
Thank you. Are there any comments or questions on this section?
Just a comment.
Commissioner Stebbins?
Chair, thank you. I think this goes back to an earlier review. Commissioner Roy, I think you raised the question of we wanted tobacco to also include tobacco and or tobacco products, I think was the question you had at the time.
Well, it actually came up when we met with folks from the public health agencies or the testimony, and they raised, so that was in statute about the tobacco. And a lot of the young people do the Zins.
That's the nicotine product.
Yeah, that's the nicotine, and if you, it can, and I know everyone's an adult, but you know, they both can interact with the metabolism of THC. They can have impacts. So your point, you bring it up, that was brought up by public health officials that flagged that for us.
Please.
May, I believe as it was read here, that gets flagged by notifying that a nicotine product, which may not have tobacco, because that is ultimately the product that you're mentioning is not technically a tobacco product. There's no tobacco in it, but there is nicotine, and therefore nicotine being listed covers that as well.
Yes.
But are there not like diet sort of supplements that are nicotine based that produce? I mean, I just want to make sure. I just want to make sure I understand what is. I understand the statutory prohibition between mixing, but you know, so you're raising a public health issue that I'd not heard of before. But okay, I'm not. I will.
You want to put a pin in it?
No, I don't want to put it. I don't. I think I'm okay, but again, I also worry about enforcement. And you know, if there are, and I don't know why I'm thinking this, but you know, there may be some nicotine-based other products that are not necessarily tobacco. So that would be my only issue: is how do we, as a commission, police this? Who's going to police it? Right? You know, what if you have a Zyn in your pocket, or how do we do that? Go ahead.
I think what we're trying to get to here is expanding. This is what our licensees can't offer. We're going to have people who might walk in with something in their pocket, but our licensees
So we're
cannot
just talking
sell
about
tobacco or nicotine products.
Then I'm fine. Then I made a mistake, because I was thinking, because we've been having a conversation about yesterday about what's in front of you, what's in your pocket, what's, you know what I mean, and how we can police that. So I understand that, and thanks for that clarification. So do we have consensus that this language is acceptable? Okay, thank you. We can move on.
Hey, thanks, Madam Chair. And then also just to expedite this, so that's on page 19. There's a series of similar amendments because we're defining tobacco. Now that we have to go and capitalize through them, it would be it would slow us down if we went through each one individually. So just offer.
So we will grant you the ability to make sure that this is consistent all across the different places. It's yes. So do we consensus on that? We
And just for clarity, so that is page 33, 93, 100, 101, 103, 105, 106, 116.
Exactly.
Okay.
Thank you. So that's the series of amendments, and
thank you.
To expedite the conversation, we have consensus.
Let's put through a quarter of the page.
Check that all out.
All right, thank you. All right, moving on, page 7. We going back to page 7.
Yes, Madam Chair, if I may.
Please, thank you.
The legal department does have while we're under the definition section, we do have a proposed amendment to the definition of enclosed spaces on page 7.
Please.
Where the definition of enclosed spaces would be read to state, I'm sorry, I'm just getting my.
So I'm looking at enclosed space now. You are.
Oh, I'm sorry, enclosed space, yes.
So, but are you offering additional language that I'm not seeing?
You're adding ceilings.
Yes.
Correct.
Nice.
And I will move forward and read the proposed amendment. Enclosed space means an area possessing walls, ceilings, or other barriers on all sides sufficient to prevent the free and undirected flow of air, smoke, vapor, or particulate matter, except for that which occurs when entering or exiting the space. Such barriers may be removable, but the designated area shall not be considered an enclosed space when barriers are removed. The addition there is for the word ceilings to be added, where enclosed spaces are strictly used in the context of indoor areas. And so we thought it appropriate to add the term ceiling to further define the space.
So this is again walking through, and they've been very good with me. I'm very visual and trying to sort of understand what the box is. So thank you, I appreciate that. All right, moving on.
Moving on, the next amendment is on page 29. And this is to 500-050 1B9B2, which currently states, provide a set percentage or a set portion of sales to the non-cannabis entity, a hospitality on-site consumption licensee, an marijuana event organizer licensee may pay a fee or rent to the non-cannabis entity for housing or hosting the social consumption establishment. And the proposed amendment from legal here to add to this draft is to add, however, this provision shall not apply where the non-cannabis entity and a hospitality on-site consumption licensee or marijuana event organizer licensee share the same persons or entities with direct and indirect control. This proposed amendment is in part to remain consistent with some of the language used elsewhere, where we want to ensure that non-cannabis entities and hospitality and on-site and marijuana event organizers are able to partner where they're not creating a relationship that will affect licensing or license caps. So this is to encourage sort of that landlord-tenant type of relationship and to include that carve out there.
Just need to digest this like for a second.
Do you want them to provide you with the context, or you just want to read?
Add a set percentage. So these are allowances or prohibitions?
Excuse me.
Yeah, sure. Madam Chair, may I?
Please, thank you. I'm sorry.
No, thank you. So setting up kind of the context here. So hospitality on-site consumption licensee and marijuana event organizer. Those are the two licenses that are interacting potentially with a non-cannabis entity. And we've had conversations before, Commissioner Roy, about how we're setting the floor here for participation. So at the floor, if you want to have that landlord-tenant relationship between the business and the non-cannabis entity, then you can, and you won't run afoul of our licensing. However, if you want to go over and above that, then you're subject now to our application process. So again, we're setting the floor here of what the relationship can consist of. And if they want to go above that, they're on notice now that they are now subject to our licensure.
Commissioner Roy?
Page 29.
Yeah, but this is here. Is that?
I can't. No.
So provide.
I guess what's the precursor to provide? What's the sentence before provide?
Madam Chair, if I may.
Please, thank you.
The sentence before provide to be amended, before the amended language. And it's B2. It's a hospitality on-site consumption licensee and a marijuana event organizer licensee may pay a fee.
Shall not.
Shall not. That's what I was looking for. So that's so before provide, because if you read a plain reading, it's tough. So before it's shall not provide. shall not provide a set percentage or a set portion of sales. Do you see what I'm saying? What I'm
Yes, I
saying?
apologize. Yes, I see what you're saying in B, because it states shall not.
Yeah, so the shall not helps me. Okay, so I just gotta, with knowing it's a shall not. So what we're saying is that the hospitality and the event organizer shall not provide a set percentage or a set portion of sales to the non-cannabis entity. A hospitality on-site consumption license and MEO licensee may pay a fee or rent the space. However, this shall not apply when the non-cannabis entity and the hospitality on-site consumption licensee or MEO licensee share the same persons or entities. So if I'm a MEO licensee and you own the tent, Cape Cod Melody tent, but somehow you have ownership and control with my license, then we can do percentage of sales.
Exactly.
But if you don't, you can only get rent or fees.
That's the floor we're setting there, the landlord-tenant relationship. Then we just like for marijuana establishments currently in the pipeline, we don't have their landlords submit queries for our application process. And in a similar way, we want to set up this relationship with the non-cannabis entity in that landlord-tenant setting. However, if businesses choose to go over and above that, we don't want to restrict that. It's just their choice whether they want to be in business with the non-cannabis entity. But that means that the non-cannabis entity is now subject to licensure.
So if I can restate, so this is basically, it shall not share the revenues from the, but we can charge a fee or rental. But it's once you start coming, this is the DR issue and all of those other issues. So it's just, however,
If you're on my license and you own the Cape Cod 10, we can commingle.
oh, but if I'm on your license, then I have to go through the registration process and I have to.
Yes. And then at that point, you own the tent.
Right.
And part of the license.
But this, so again, this is the conversation in terms of some of the sort of existing kind of, between the regulations here. So right now, there are people who can rent out and they don't have to worry about anything. But
correct.
Right. And so once they start sharing those revenues, that's when
You can't share the, right, that's the chicken and the egg. Like,
Right.
you can't share the revenues unless you've already gone through the.
Right, unless you're licensed.
Yes.
So we're saying that we all. All right, Commissioner Stebbins?
I think Philip has his hand up.
Oh, I can't. Oh, sorry, I should be looking at my screen. Attorney Schreffler? And it looks like.
Yes, if I may, Madam Chair, just an additional little point of clarification on this is when putting this together, we were also sensitive to issues where if I'm a business owner and let's just say I own an event hall, just outright, I own everything, but I own it through an LLC and I have a separate LLC that has a marijuana event organizer license or a hospitality license. We don't license people, we license things, the entities. So this allows that person to, I already own the event hall, and I can put my marijuana license in there. Without that, you'd have this kind of a somewhat absurd scenario where I own everything I'm working with, but I can't then just direct the profits from the sales and freely collect them. I have to do some kind of a sort of strange, strange like fee setup to make that happen. So this is kind of a nod to where there is just a single entity owning the whole thing, or a single person owning the whole thing, just divided into entities.
Okay, thank you. Any comments or questions about that last? Okay, so are we good to move on, commissioners? Yes, we're good with this language. Okay, thank you. Right, moving on.
Madam Chair, if I may.
Please.
The next amendment is on page 31 at 500-050 3M, where under the section of craft marijuana cooperative, the section reads, an eligible craft marijuana cooperative may operate a supplemental on-site consumption license within its existing marijuana establishment premises. The change here is to add the word eligible to the language. It previously didn't include that. I believe in the prior draft, because a craft marijuana cooperative was listed under one of the license types for the exclusivity period, there wasn't, the term eligible wasn't included because they would be eligible as the exclusivity period. But for consistency purposes and whenever that exclusivity period ends, it would be legal's opinion that it's appropriate to include that term there.
Okay, thank you. Any questions or comments on that language? Right.
Heard what she said, but I was actually unaware that craft cooperatives were the non-existent craft cooperatives. Fortunately, I did not know that. So craft marijuana cooperatives are eligible to apply for on-site. And by putting a qualifier eligible, explain again why you thought it was necessary?
So all other license types, except those that were included in the exclusivity period, use the term eligible as the qualifier. They will.
This is consistency. That's it.
Yes. Yes.
Okay.
And in the future, you know, once that window closes,
yeah,
you would like the regulations to be future-proof and consistent. So moving forward, whenever that ends, it will provide that consistency throughout.
Thank you.
Madam Chair, the same exact analysis goes for the next amendment, so you could take them together.
And this is micro business to marijuana, micro business, yes, okay. This is down at F. Yeah. Commissioner Stebbins and Roy, are you comfortable that we can find consensus with the language provided by the staff? Commissioner Roy?
Can you define eligible?
Well, I will say, Madam Chair, if I may.
Please,
so I would state that eligible is the process that the applicant will need to go through when applying for the social consumption establishment license. So it's the process that they would need to go through and show that they're suitable, that they've met all of the application requirements. And so I think that's an appropriate term that they would get.
So I guess there was the reason I ask is because there was some confusion I heard directly from micro businesses that they thought they would be eligible for the delivery endorsement. And so is any micro business considered eligible or only certain micro businesses eligible?
Under the current draft, all micro businesses are eligible.
Okay, because that wasn't the case for the delivery endorsement for micro businesses. So it's an important distinction because I know people got into the micro business license type thinking they were going to be able to deliver and they weren't. So all micro businesses will be eligible.
And yes. And
all craft cooperatives that don't exist.
Yes, exactly. Those are the only two licenses that are. The rest are person-centric. You have to qualify as that.
Okay.
So that's
why the genesis of why I asked is because there was confusion last time.
Makes sense.
All right, are we good on this? Okay, moving on to social consumption establishment. 31 also. Okay.
Madam Chair, if I may.
Thank you.
The next amendment is on the same page, page 31, 500-050 6A. And this reads, a municipality may authorize the sale and on-site consumption of marijuana and marijuana products at a social consumption establishment in accordance with Massachusetts General Laws, Chapter 94G, Section 3.
Straightforward. Okay, moving on.
The next amendment we have is on page 32. If you bear with me, I'm just scrolling there myself. And this amendment is to 500-050-6F1A, which reads, a supplemental on-site consumption license is not granted as of right to a marijuana establishment holding another license type. An eligible marijuana establishment must separately apply for and obtain a supplemental on-site consumption license in accordance with Massachusetts General Laws, Chapter 94G, Section 3. And we would propose to add an and there, and 935 CMR 500.
I know it sounds silly, but that comma right there, that's okay. That's what is required there. It's not like a semicolon or anything. I'm just, because I don't know. That's
Behind which one? 3?
behind, after 94G section 3, there's a comma. I'm actually just asking so I understand.
Yes, that's technically
How we do it. Okay, thanks.
And you're adding just and.
And yes, just to clarify, that the word and was intended to be there, but unfortunately it was omitted.
Oh, okay. So wait a minute. So that's what I'm saying. So that's where you're putting the and right there?
Yes.
Okay, fine. All right. Thank you. Any questions, comments? Moving on.
I just, does it have a different meaning without the and?
I think it just, I'm sorry, Madam Chair, if I may.
Thank you.
Commissioner Wright, I think that it just clarifies, and just grammatically better, and it was just an unfortunate omission of myself, to be honest.
Look at it. Is kind of weird. I mean, so just sort of.
We don't want to be weird.
Well, no, I know. So, yeah. Okay. All right. Thank you. Moving on to, this is still on page 32, 6F2A. 6F2A. Okay.
Madam Chair, if I may, we are still on page 32 at 500-050-6F2A. This is a proposed amendment from legal, which would read, eligible applicants and eligible marijuana establishments may apply for a hospitality on-site consumption license.
And again, Madam Chair, if I may, this is another amendment that is consistent if you want to take them together with the one below. So
I'm sorry, I was just looking. Can you hear me?
Yeah, apologies. Didn't recognize me, so apologies. So 2A and 3A, legal is proposing to amend in a very similar nature. No, this is slightly different. So what we realized is, again, under the one before it, it's supplemental. Supplemental has a number of marijuana establishments identified under 1B above. And that amendment is not required for 2 and 3 under 2A and 3A, because really it's open to everybody, whereas supplemental is not quite open to everybody. It's open to existing MEs that are listed there. So when we're reconsidering drafting this, we wanted to exclude the qualifying MEs because it's not necessary. As I stated, it's open to everyone. So just a clarification.
So rather than leaving the specificity, it's just more general language that it includes.
Exactly. So we propose eligible applicants and eligible or just marijuana establishments.
Yes, if I may, eligible applicants and eligible marijuana establishments.
And
can I ask why the broad term as opposed to the more specific? Is that because this also could have an impact in the future, or?
Sure. So yes, marijuana establishments is all adult use licenses under 500. And so by having the list there, it's actually inaccurate because it's not listing all licenses that we have. If we use ME or marijuana establishment, then it covers everyone.
Gotcha. Okay. Anybody have any questions?
We do.
Commissioner Roy?
Third-party transporters, I thought we included them.
Yeah, so if you, Madam Chair.
Please, thank you.
Thank you. So that is for supplemental, and that's found under 1B just above.
I see it now.
And again, the 2A and 3A, it's open to everyone. So the limited list here is actually not the intent of the board.
Commissioner Wright?
So Third-party transporters can have attached to their warehouse
Yeah.
a supplemental establishment.
Right.
However, and I'm digging back now in the timeline, we did have to amend below under marijuana transporters in the same section to allow them to have other licenses. So we did make that amendment, sent to the secretary. That was largely for your advocacy.
Yeah, yes, yeah. So if I may, Madam Chair, Deputy General Counsel, so no, so couriers can't partner. And why can't why couldn't a third party transporter please partner with the yoga studio?
They can. We're actually clarifying that in 2 and 3 here.
And what you're saying is in the language above, it's clarified?
Sure. Rachel, if you don't mind, could you just move up to 1 slightly up? So if you, I'm gonna back up here and talk about 1 first. So for supplemental, the board's intent was or at least as I understand it was, if you have some space existing marijuana establishments, then we'll include you in this list because you have something to pull from to add to for supplemental. So you have enough space to have that consumption area attached to what your footprint is now. So under 1B, every ME listed there is a ME that has enough space, we thought, that they could use for a supplemental establishment.
So in theory, it's almost like these are places that already technically have warehouses?
Yes, or enough space with it. And then, so, sorry.
No, I just want to, but the craft cooperative is land. And it's in here. And courier, I've been to couriers that have space. So I just want to think it through before we lock anything in. Let's just talk about it for a second. So technically, I mean, theoretically, a craft cooperative is a piece of land. Might not have a, right?
It's a cultivation.
Yeah, so outside normally, right?
Well, it doesn't have to be.
We could have a hoop house or a greenhouse.
Right, but my point is that they're still, and I think of warehouse as just place that people are already in a regulated fashion holding product, whether it's being grown or manufactured or sold. And what I'm thinking is courier
is just delivery.
Is just cars going back and forth, and so there's no sort of place. Now they could, but I'm not using the word warehouse the right way, I don't think, but that's how I visualize this. Okay.
There's, under this current draft, there's nothing stopping a courier from obtaining a hospitality license.
Right.
There's nothing stopping them from obtaining a marijuana event organizer license as well. This is just supplemental attached to their premises.
And yes, and I agree with all of that. I'm just saying, do we deliberately want to omit them because they are an exclusive license type, the courier, and so we're purposefully excluding them from supplemental and just keeping them with the eligibility for hospitality and event. I just want to make sure that's what we want.
Well, can you restate what she just restated so I understand how close?
Sure. So she's saying who can qualify for supplemental? Do you want to expand the list of marijuana establishments that can qualify?
Because it seems to me, so craft cooperative is basically just a farm, and the reason there are no craft cooperative licensees is because it assumes a cranberry versus a cannabis model of farming. So it is farming, probably generally, but it doesn't have to be outdoors. But every craft cooperative is going to be like any sort of outdoor grower or farm or indoor. They're going to have fences, and they're going to have to do that. This seems to be like the only place that doesn't have what we consider a warehouse, right? And I'm using that word probably inappropriately, but is this the only one? And
like a brick and mortar?
Well, it's not even brick and mortar. It's just the security to keep the product under the regulations. Like if you're a farm and you're going to have fencing and you're going to cameras, and every other entity has that kind of something that's going to protect, keep from the public store. It could be an open field in a farm. It could.
So if a courier wanted to do a fun bus in their lot. It's all cambered up. It's all requirements.
Fun bus, but anyway.
Fun bus on a premise, their lot. They want a fun bus. All cambered, all requirements are met. That's their version of supplemental. They can't do it.
Can they do it? Has anybody?
They have an RV all on their. I'm just.
Do we know? But do we want to do it?
No, they're not driving around with the fun bus gets. It stops.
As long as it's parked, my towel interjection is as long as it's parked, it doesn't matter. Let them do it.
I'm just saying it's an exclusive. I don't mean to be silly. I'm not trying to be silly, but it is an exclusive license type, and we do have couriers, and you know, if we
already have a protected group or a group that we're trying to help already through social equity, and you're trying to understand that given the sort of, the only word I'll say is physicality of how they function now in relation to the product. Because they are a social equity licensee now, and the only ones that don't implicitly have.
That's the only one we're leaving out, I guess is what I'm trying to say.
That's what I'm saying is that.
And if that's the will of the board, then that's the will of the board, but we are consciously leaving them out of this. And it's the only equity license type we are.
Any thoughts? My fellow commissioner, not having been privy to a lot of the back and forth. Like I see the cars, right?
I mean, for me, I think as we walk through it, I think to your point, it's about all the other folks we have eligible for a supplemental are people that have brick and mortar warehouse, right? They already have the facilities. A lot of those facilities will already comply with our regs. So I think that was kind of an easy way to do it. I hear you about the couriers. Certainly, you know, I think by changing the language under 2, if they don't have that physical presence, and it varies courier to courier, whether they just park their car someplace and go pick it up, they certainly then become eligible for hospitality or the marijuana event organizer. But I think we were trying to keep supplemental to that brick and mortar component.
So excluding them because they will still, if they're included, they're going to have to use the warehouse. They would not be able to do it. So why exclude them? Because we're going to require them.
That's right. So I'm trying to say, thank you. Okay. They would have to, like, we went to see.
No, but you're saying this is now I don't like to use the words protected, but this is a special group. And
we're leaving out
leaving a special member of the group. No, a special member of the group out.
Yes.
And if we put them back in,
they still going to have to comport with our regulations.
Right.
Whether they have it today, they will eventually have to comport with it.
So I hear what you're saying.
I'm just trying to be
fair. No, but I think that your point is correct, and especially because these are people who are, you know, already potentially in business, but they're still going to. So
this could be another revenue source.
Right. So I don't know how comfortable everyone is in terms of a consensus here, but I actually now I understand what you're saying. No, but I understand why you might not include them because currently they're not an establishment that already has the security scene cameras and all that stuff now, but they would have to be.
And this could be another revenue source for them, which is, we all know it's been a struggling license, right? We know it's, you know, it has its issues.
That's a really good call. I would not have seen that, but so I'm glad we had this chance to kind of walk this through. Do you, Commissioner Stebbins, do you have any negative thoughts towards adding them? Because I don't think that it changes any sort of regulation, security. It just says you guys get to be in this special group and we are not going to specifically exclude you from the special group.
Yeah, I have no problem adding that. I think we'd be adding that under B, marijuana one courier.
Yeah.
Right.
Good call.
Sure.
Thank you, Commissioner Stebbins.
Sure. I have a question, and thanks for going back up under 1, because this is looking at the language under C, and this is an issue that came up in a conversation we had with a potential applicant. They are hearing from both tax and insurance advisors about using a different entity, might still be same ownership, but a different entity to operate the supplemental, so that if something goes wrong, their supplemental is getting sued, not their supplemental in their retail and their supplemental in something else. So I just want to make sure if the language we have under C would, again, allow for that separate business entities, same ownership, separate entity.
Later date, so an attempt to cordon off liability or that is going to be defeated by joint and several language that I think we're going to be putting in later. Am I incorrect in stating that, or am I correct? Do you know, remember we had this conversation yesterday, and it sounds like what he's saying is that I actually, again, recovering attorney, I actually represented a cab company, and the way medallions were, every medallion, every cab company, there were 2 medallions in a company, so that it was just limited to basically the value of the cabs. And so that was to evade broader liability, because obviously cabs are going to be getting into traffic accidents all the time. So the intent of people to set up separate corporate entities may, in theory, protect them from that exposure. But I think we're going to be saying that is not, or am I wrong about that?
Madam Chair, if I may.
No.
So we were speaking to that in the specific context of a marijuana event organizer license type, and it during temporary consumption events, so that whichever marijuana establishment may be what I'll call subcontracted in to provide the product, I think the intent was that all parties are responsible for the activities that occur during that consumption event. And so the joint several liability is very specific to that type of event, where I think what Commissioner Stebbins is speaking to is a separate instance where an already established marijuana establishment would like to obtain a supplemental on-site license. And so in order to protect themselves, they would like to separate those businesses for liability purposes. The nature of those, so that there's, separate insurance contracts and separate business entities themselves. So if they were to face litigation or a lawsuit, it would only be as you were speaking to, it'd only be subject to one of those businesses wherever that conduct occurred. So I think that's different than what we discussed yesterday, but I understand the thought process.
Okay, all right, thank you. Thank you, Commissioner Stebbins. Commissioner, Attorney Baker.
Thank you, Madam Chair. Just highlighting one of the other considerations for the courier is that some couriers have their principal place of business in a residence or residential, their homes. So ultimately, just want to clarify, I think we have somewhere else that
If I can, they would have to abide by all of this. They would have to have a headquarters. It can't be in their home. They're going to have to have warehousing.
Exactly. So I wanted to just kind of raise that now that that's the expectation, is it's not in someone's residence. That wouldn't be allowed under this draft. So just clarifying.
Yeah, and that's going to be clarified for them. But I think that the point is we want to protect the groups that we're protecting to make sure that they have those economic opportunities. But all of that other stuff, they're not going to be able to have their headquarters in their home anymore if they want to do this. They're going to have to do something else. And
Zoning won't allow it, probably either.
Yeah. Oh yeah. I don't know if you heard that, but Commissioner Stebbins said the zoning probably wouldn't allow it anyway. So how do they allow it now? I guess they can. So. All right. Any questions or comments? Nope. Moving on. And this is requirements for the handling of marijuana, reporting foodborne illnesses, and we're going to page 62. Is that it?
Yes, Madam Clerk. I apologize, Madam Chair. I'm coming from the court where I'm oftentimes saying Madam Clerk, so I apologize. Madam Chair.
I don't mind, Your Honor. That's, that's but, 62.
62. And this is 500-105-3E. This amendment reads, marijuana establishment agents shall report any occurrence or suspected occurrence of the illness believed to have been due to the consumption of marijuana or marijuana products to the commission as required by 935 CMR 500 110 9A10 and to the Department of Public Health as required by 105 CMR 300 131 illnesses believed to be due to food consumption. Marijuana establishments shall cooperate with any disease investigation activities being performed by the Department of Public Health, the applicable Board of Health or local Board of Health as defined by 105 CMR 300.020. One thing I will also clarify on this is a legal amendment to this language here would be to eliminate agents and to have the responsibility be placed on the the marijuana establishment as a whole.
And is this sort of belt and suspenders? Would they not already, or this is because it's not food, so we're pushing not necessarily food items and the DPH. Is that what we're doing here?
Yes, Madam Chair, if I may.
Okay.
Yes, so this was a comment and request that came through from the Department of Public Health that there be that reporting to the Department of Public Health if there's any concerns as to foodborne illness. So you are correct where the introduction of cannabis or marijuana to any type of food, if it's an edible or something of that nature, we take it out of the food category for DPH, but they have specifically requested that line of reporting. And we also thought it appropriate to make that report to the commission as well if there's those concerns.
So we're not talking anything that's ignited, we're just talking anything that's edible.
So we are, just to give some context, we are under the handling of marijuana. So this is in the manufacturing process. And so it's specific to those points in time.
When you say those points in time, I'm missing.
I apologize if I was unclear. So those particular points of handling, I guess I would say.
Points of handling.
Yes.
Okay. Okay.
Yeah.
Gotcha. Okay.
I'm in the processing of the marijuana itself.
It's clear to me now. Thank you. Any questions or comments regarding this language, Commissioner Roy?
So the infused, and it's going to be consumer infused. So was it the grapefruit juice or was it the tincture that got somebody sick? And what do we does that account for that?
Yeah, I think Madam Chair.
Please, thank you.
Thank you. I think regardless of whether it's from the DPH kitchen or one of our establishment from the other side where cannabis is being handled, if this ME finds out that a customer had that reaction within their establishment, they ought to give notice to both us and DPH. So that's what this is.
I'd like to make a friendly amendment to this and add non-marijuana for marijuana products because that would account for the cranberry juice as well.
Does that are my fellow comfortable with that?
It just broadens it to cover that.
Go ahead, Attorney Baker.
And just to double check, you're saying the consumption of after the consumption of non-marijuana or of marijuana or marijuana.
Am I reading? Are you trying to clarify that this is?
We're on page 62, right? Yeah. We're on E. And so the way I read it is the suspected illness, if it's believed to have been due to the consumption of marijuana or marijuana products, they need to report to the commission. But what if it was the cranberry juice was off code and nobody realized it, and then they did the infused, so well, we don't have to report it because it doesn't say we have to report it in here.
Yes, that's a very good point, and we can be overly inclusive. That's always probably preferred here.
Yeah.
There is a little technical quirk where once the consumer adds marijuana to that food product or drink, it then technically does not become food or drink. So there's that legal fiction that arises at that point. So we have oversight of obviously our licensees and marijuana products through that. So again, once it is marijuana or marijuana products, then it's.
I hear you, but I feel like that's a loophole.
I totally agree.
Where they could say every time it was the cranberry juice. How do we know?
In that instance, they would still have, there is a reporting requirement strictly under DPH. The
Commission want to look into it as well.
I'm not.
Yeah, I hear you though. I hear you, but I think it's just closing any potential loopholes that's all it's doing.
So has your friendly amendment, are we talking another friendly amendment here?
No, just the same friendly amendment of how's it worded?
Thank you, Madam Chair. Can I offer to try to clarify the language here so that I can understand consensus? So maybe we could say something like the consumption of food, drinks, marijuana, or marijuana products, just to be inclusive of your consideration. Commissioner Roy?
Say it again so I can hear it.
Sure. Basically, to Commissioner Roy's point, marijuana or marijuana products is less inclusive than she's seeking here. So the terms that we would use here to not confuse our terms of art under definitions would be food or drinks, which indicates non-infused.
Would it be easier just to say the consumption of non-marijuana products, marijuana or marijuana products, to keep it consistent? Because you're consuming it.
Is there a word for that implies consumption? Ingested?
Well, it says consumption.
Yeah, no, but I'm just saying what by definition, it's already.
So I guess like we're gonna mandate they have shelf stable snacks. So I grab the bag of Doritos and I decide I want to put some tincture on my Dorito. I just want to make sure that that's somehow accounted for.
Please, Attorney Baker.
I think that we support inclusive language here.
It's whether we say food and drink or non-marijuana products. So
my proposal back to you would be consumption of marijuana or marijuana products or non-infused food and drink.
And you're stating it that way because you said it's not food once it's considered not. Once the tincture goes in the cranberry juice, you said it's not considered what? Food. Right. So that's why I said non-marijuana products, but you're saying non-infused, but I don't think that goes far enough. I'm sorry, Mike.
I was just going to know, Madam Chair, I saw Attorney Scheffler's hand up.
Oh, I'm sorry. I'm looking this way and I Attorney Scheffler?
I was just drawing your attention.
Thank you. If I may offer maybe a little bit of clarity here. When we say non-marijuana products, that's a very wide universe of things. That could be medicine, that can be food, that can be drink, that could be paint supplies or pesticides. I think what we want to do is, at least I would offer this, I suppose, to the board, is saying non-infused food and drink kind of captures everything that's going to be in that space. And please, Attorney Baker, correct me if I'm wrong, but that's kind of what we're trying to accomplish with this language.
Does that get at, do you think that gets at what they're trying to say? Commissioner Stebbins?
Thank you, Chair. And I think Philip offers an interesting way to piece that, because it's not just going to be food that might get infused. Somebody could just be ordering a burger that has nothing done to it. And I'm sure DPH would welcome us notifying them if somebody got sick from just a plain old In-N-Out burger or something that gets delivered.
If someone has a foodborne illness, don't they already have to report that? Attorney Baker?
Thank you, Madam Chair. That's why we didn't include it initially, but because they have reporting requirements already, and if it's coming from a DPH, local Board of Health regulated kitchen, they have those requirements already baked into their regulations. But to Commissioner Roy's point, it never hurts to be overly expressed here in these regs.
Do we have a language that would make you comfortable, or do we want to?
Do you think the non-infused would accomplish that?
Yes. Because basically that's before the merger. Right? So.
Or without the merger.
Or without the merger. Yeah, but once they're merged, that's up to us. All right. Attorney Bruno, sorry.
Thank you, Madam Chair. And just on a final note, just to Commissioner Roy's point as to the trying to capture shelf-stable food and then food that's allowed on site, the terms non-infused food or drink are exactly the language that we use there, so that would be an appropriate.
Okay.
Thank you.
Thank you
so much. Thank you for hearing me out. Thank you.
All right, we can move on? We're good? Okay, so we're now moving on to security requirements, 500-110, page 78.
Madam Chair, if I may.
Yes, thank you.
Yeah, thank you. So as you mentioned, the next amendment is on page 78. This is actually a commissioner decision. We could take it up next time, or it could be a quicker conversation. As I've expressed to you all offline, there are certain parameters around what is allowed, especially what's allowed at our events. There's a statutory mandate here that we cannot sell or store cannabis products or marijuana products in plain sight, and the current draft has extended that restriction to consuming out of plain sight as well, but that is ultimately a commissioner decision. So again, if you want to take that up tomorrow or next time when we're doing commissioner decisions, that's appropriate, but we did have that up next.
Can I request the indulgence of my fellow commissioners? This was a fairly robust conversation. I will share with you that I think that the whole plain sight issue, that going further than what the statute requires as it pertains to sale, and it doesn't reference consumption. I think that this for our team is going to be an enforcement nightmare, and I know you may have Commissioner, you may have a different position than I do, but I'm trying to understand in terms of sight lines, especially when stuff is outdoors, how do we do some of that? Commissioner Roy, we might want to push it back, but I want your thought on it.
Yeah.
I tend to I don't have a problem with these sight lines, right? We can go out and we can drink beer, and people can see us drink beer, and I don't understand why the difference. So I'd love to hear your opinion on that.
So we have sightline requirements in retail.
Right.
Windows can't look in, right? Can't sales floor. So those exist, and they've existed.
But that's still
2017.
there. That's still there.
Right. And so that's consistent. And the only thing is the consumption. And, I spent most of my adult career on youth prevention and seeing people, I'm not naive, they're adults, but, if you're at the Big E and you got your, 6 and 7, 8-year-old, is that what you want them to see?
They see at the Red Sox game.
Could have been made opaque with security line going in. You were checked ID as you were entering, and not required by the state of Michigan, but were required by the vendor in their agreement with the city of Detroit. They had security staff wanding people for metal, not for patting them down for anything they may be carrying. As you entered in, they had a number of vendors who were there to provide, brand awareness. but could have been there to be part of an area that would be used for social consumption, including tables. And then they had a fully opaque tent in which you entered in, gave your ID again, and then you were entering in where the bud tenders were, all the products were, the menus were. As you entered out the back after your sale, there's also multiple ATMs within that tent. As you entered the back, they had bathrooms, again, in the idea that people in the future would be there and staying on site after they made their purchase to consume. Because there was no consumption for this particular event, they essentially asked you had the option to go to the bathroom or to leave out the back. In the back section behind the opaque tent, within the entire framework of the event, was also the delivery truck, which brought in the product from the retailer and could have been used, should they have so chosen, to stay there overnight as the on-site lockbox. What the vendor chose instead was for the delivery business to bring that back to the retailer at the end of the night and bring it back the next morning. It was a 3-day music event, so they were there to do sales for 3 days. I believe it was Friday, Saturday, Sunday.
Commissioner Wright?
So again, what was happening in the opaque tent?
That was within, if they had made the entire outer fence at the line of what was licensed opaque, they could have, if approved, allowed for consumption to take place in that space. The fully opaque tent, where the second check of the ID was entering in like you would into a retailer, where the bud tenders and products were set up,
right?
And it was just sales,
right? And I think, if memory serves me, and thank you, that's really helpful, is we talked about different scenarios other than the frog pond.
Yeah.
One thing in the frog pond, a bowling alley where you got a kids league 3 lanes down.
But so is there language that we could put in? Because we also have language which we will be addressing about advertising and things like that. So in thinking about maybe advertising the standard, that I don't want this at a bowling alley where kids are. I don't think it should be anywhere near kids. And although we do.
So kids don't go to the frog pond?
No. Well, I'm saying the frog pond is just a visual representation. Oh. That's what I'm saying. It's just, no, all right. So again, I'm dating myself, but the Music Inn out in Lenox, I don't even know if it exists anymore. Music Inn, Lenox, Bob Marley. Anyway, so I think of the Music Inn, and I think of the sort of physical. It literally was a bowl, and the stage. Maybe that's where. So do we have to tell them they have to put it up on the hill, and then we opaque it? That's what I'm trying to get my arms wrapped around. Is how do we don't hide consumption of alcohol from kids, and I do think that there are ways that we could probably draft this, that we have a statute that prevents that from being in Publix. But it's mostly because, and I'm sorry, I'm not being linear here. I also have been asking questions about, and I know you, Commissioner Jones, I watched the meeting where there was the visual of how we would rope things off. So right now, we have not even necessarily walls, but cordons. So we can have people come in and there's just a cordon. But in those instances, everything is still going to have to be age required. You're going to have a license to get into the space, right? We're going to have that. My question is, how do we, especially in these outdoor venues, I'm looking at your screen that you have up on your laptop there. If it's down the bottom of a hill, I can see over that screen. I don't have to be too high up to see around that screen. So I'm just practically speaking, how do we regulate those sight lines? And if we're saying opaque, I want to define, and unless this is just guidance, I want to define what that means. I personally think that we need to be fairly flexible here. I understand the desire to keep this away from kids, but maybe we should I might want to take a little bit more time on this, Attorney Baker, and Ryan.
Thanks, Madam Chair. I could have done a better job introducing this specific piece because there's also one other piece to this too, which is why we brought it up for staff amendment. So we added served in light of the new language that we have, the hospitality considerations in this this new draft. So not only is it consumed, but it's also served that you're looking at whether to include here. Again, we cannot amend sold or stored because of the statute. So it's two things that you're considering now as a commissioner decision, and that is served and consumed.
So could I ask my fellow commissioners indulgence, because I'd like a little bit more understanding of this, any testimony that people might have provided, because again, I also see this, I have a different perspective than my fellow commissioner right here in terms of how we do that. But I'm also trying to understand practically, because if we're saying that it does have to be outside site, are we then going to mandate that it be in a tent? I mean, do we have to, and so I'd almost feel more comfortable if we're saying that we prescribe what we're going to do. We very clearly prescribe it in the statute when you're looking at retail. It has to be behind an opaque, and whether or not the legislature is going to take that up, I don't know. But that's, and all of this was passed a while ago, before we've had the history of how these businesses function. So if I could ask your indulgence, I'd like to get a little bit more time with this to understand what this means, how we're going to enforce it. And, you know, maybe we tell everybody if you're going to be drinking, you got to be under a tent. So you can be drinking beer on one side of a field, but without a tent, but you're going to be on the other side of a field with a tent. So I just like to dig into that a little bit more. So can we to the next conversation? Are you comfortable with that, Commissioner Roy, Commissioner Stebbins? Executive Director, yeah.
Absolutely, and this is more for your future discussion as well, but just to be clear, one of the things, if there were social consumption going on, the fence itself had a sort of partially see-through sheet, I would say, on it, but a more technical term, I'm sure, from a fencing company. But they could have upgraded it to fully opaque. So at the line of sight walking in public on the city street, you would not have been able to see in to see what was going on. You could not see into the tent where the sales were. The thing that I pointed out, which is within the Michigan regulations, is that this was also a parking lot next to tall buildings. So anybody within those buildings is looking directly down into it, right? But that is not a concern from the Michigan perspective, because the intent is somebody who's walking on the street level. Those buildings are private property, right? So it was the point of sale specifically must not be able to be seen. If social consumption had been going on, they would have had to have a different type of fencing than they had. That was basically how Michigan looked at it.
So that's also, you know, when you think about something that can be viewed from higher up, that wherever we land on this, I just want to make sure that it's enforceable, that and it's also something I think for the communities, how we do this. Again, it's my personal opinion, not necessarily shared with my fellow commissioners, about what should or should not be shielded from view. It's just I want to make sure that we're handling this in a way that's consistent. And when I'm thinking practically about a Biggie or about Fenway Park or you know, someplace like that, how is that going to function differently? Good. Commissioner Roy?
Yeah, and I just want to level set us too, because currently sold, served, and stored is out of the sight of young people in retail, correct? We all can agree on that.
Under this draft, yes.
Well, under the current stat, well, now, so, I mean, a marijuana retailer, everything that's sold, stored, is young people can't see it, right? The windows are, you can't see through, and whether you agree with that or not, that's the current environment.
Under statute. Yeah.
Yes. So basically it's consumed. It comes down to that word. And the example, the pond, and if they need binoculars to see it,
no, then that's what I'm saying, is I think that there are plenty of instances where you're not going to need binoculars. And so I'm just trying to understand how high is the wall? we need a tent, because I don't think that we're, unless we leave this up to the municipalities, I don't know. But I just want to get a little more time to kind of get my arms wrapped around this. And you and I have very different opinions about this, so I respect that. So if we could just have a little bit more time, if I could get a little more time, and if there's any other testimony that you want to share with me that we could do inside the open meeting law, I would like any more your thoughts. Or
Well, I mean, I'm just trying to, like the yoga studio, right? You're gonna have people of all ages and so it's okay, like.
No. See, I think we're kind of talking past each other right now, right? It's that in a yoga studio, or what if it's outdoor yoga, right? And so what if it's yoga on the beach? What if it's, so I still think we need to define what the parameters are, how you come in, and it's why we were having a robust conversation. I added ceilings because I'm thinking visually, right? So I just want to get my arm wrapped around, because I think that in a yoga studio, it's brick and mortar. It's generally going to be indoors, and you're going to have an ID to get in, aren't you?
No, not if it's.
We're not going to have age appropriate
for that, but anybody can walk into to Shannon's yoga studio.
Yeah, but I'm assuming that well, this was also the question I had in terms of, we talked about barrier, and I'm trying to figure out what barrier is in our previous conversations. And so I don't want people to be able to wander in, and we haven't necessarily fully defined barriers. So I think we're in robust agreement that we don't want kids walking in, but I'm assuming that all of this, and I may be wrong, because the conversation I had about barrier, I don't think that any kid who's maybe going to a yoga class should be able to walk into this. And I'm assuming that there's going to be some policies, procedures, age appropriate identification of who gets into this space.
But what if it's, the rooms are divided by just clear plexiglass? And
well, I asked that because I didn't think that the term barrier was defined well enough to protect against
so
that.
the preteen yoga class is looking at the, the plexiglass.
I'm totally with you and in agreement on that.
Yeah.
But it's, I think part of it is we don't have the clearly defined barrier, or anyway.
Madam Chair.
Sorry.
Thank you. I think part of the confusion here is really what is the premises that they're establishing here. So if it's a bowling alley, is the premises the entire footprint of the bowling alley, or is it, the 3 lanes to the side? And if it is the 3 lanes to the side, you likely could not have indoor smoking occur because
it would be wildly posts.
Right, because obviously that would seem to other patrons that would have to be in what's called the enclosed space. But that doesn't get to that's the smoking issue. It doesn't get to the visual issue of that being opaque.
Probably, but it doesn't eliminate the possibility, right? You could have a well-heeled bowling alley chain that can afford the $1 million air handling system, and the last 3 lanes to the right for that, and then the other 3 lanes next to it, and they're, oh, mommy, look. But I'm just saying.
No. We're really not that far apart, because I raised this question about barrier, that when we have something inside a footprint, how do we stop it? How do we stop people wandering in to the consumption space?
Madam Chair, they wouldn't be able to get, the kids wouldn't be able to get there because they'd have someone at that premises checking IDs before they can enter that.
But if they had three bowling lanes, and you're probably not smoke, because I don't think that there is a ventilation system good enough to segregate without a wall, right? So my assumption is, if a bowling alley can do this, they're probably going to they should be taking IDs at the front door if they're having anything in an open space like that. No, or is that not correct?
Madam Chair, it might be good to just have these hypotheticals offline so we could walk through
Okay,
all
yeah,
of that.
all right. Well, that's what I'm saying. So I have a lot of questions, and I raised some of these questions about barriers, and it totally addresses what you're talking about, because I don't want anybody wandering in, but I haven't been satisfied that I understand what barrier means. Okay, thank you.
Just before we wrap this discussion up, there's no one under 21 that would be allowed in these facilities. So I just wanted to clarify that. And it really is heavily dependent on, in the application, what is defined as the premises. And so and because we've allowed so much business flexibility in how they operate, it is also dependent on whether it's indoor smoking, whether it's indoor non-smoking. So I'd love to be able to run through kind of all of the scenarios offline with you.
Okay, thank you. Yeah, and I once again, I apologize to my fellow commissioners because I'm still trying to wrap my arms around this. So good conversation. All right, but can we move on from this and we'll get some additional information. So where are we now? We're looking at, which one are we?
Madam Chair, if I may.
Please, thank you.
We are at page 93, 500, 141, 3E.
Page 93.
I'll give everyone just a minute.
Thank you. Proceed.
A marijuana establishment may sell non-infused food, water, and drink items that are pre-packaged prior to arrival on the premises and are shelf-stable. Such sales of shelf-stable products shall be limited to products sold in a manner that does not cause the marijuana establishment to be considered a food establishment under 105 CMR 590.001. The marijuana establishment shall obtain all licenses and permits as necessary prior to the sale of shelf-stable products. The relevant amendments to this particular section are the added language prior to arrival on the premises. The clarity there was through public comment with the Department of Public Health to provide better clarity that these are non-infused food products that are coming to the marijuana retailer, not something that's going to be created on site and packaged on site. The remainder of the amendment is post public comment is such wow, Sally sells seashores. Oh man. Such sales of shelf-stable products shall be limited to products sold in a manner that does not cause the marijuana establishment to be considered a food establishment under 105 CMR 590.001. Again, that was a request in public comment from the Department of Public Health, just to clarify that these sales are not necessary of shelf-stable products is not going to cause the establishment to be regulated under DPH.
So no popcorn machines.
Yes.
Popcorn, sure. Smart food in bags, but
Yes, exactly. No popcorn.
Right.
all right. Any questions or comments on this? Hearing none, we can proceed to Commissioner Wright.
And this, by saying ME, it takes into account our retailer friends.
Yes, so that's that's the heading that we're under right now is for retail establishments.
And I just want to say, and I want to thank you and everybody because that was a robust conversation. And this, what I've heard is this additional revenue source will be helpful to a lot of our retailers. And I think Commissioner Stebbins, you shared the fun fact that snack sales around ME retailers go way up. So I don't know where you get that information from, but so now they'll be able to enjoy that revenue.
Well, having run the Girl Scouts previously, we actually knew that some of the biggest cookie sellers were actually outside of California marijuana stores. On the West Coast, yes. One of the young women who sold the most boxes of cookies was selling to her patrons on the way out the door. Very proud of her. So. All right, moving on to page. Have we gone through everything on page?
Yeah, that's it. I'm sorry. That is a marijuana strain Girl Scout cookie. Did you know that?
Well, as a matter of fact, the Girl Scouts are very jealously guard their trademark, and they sued the heck out of that.
That's true.
But is it still?
I assume that they might have changed the name because I know that the Girl Scouts
That is true. The name is now GSC.
sue easily when they might be doing it, but I know that they were subject to a significant lawsuit. So are we on now recording sales, or are we on?
Madam Chair, if I may, the next amendment is a proposed amendment on page 93, but I think we may have covered that with the inclusion of tobacco to eliminate the term tobacco products, as that term is now encompassed by the sole term tobacco. So I will exclude visiting those amendments now that we've covered that. So we can move to page 94. And this is 500-1405I, which reads, a marijuana retailer who operates a supplemental on-site consumption license in the premises shall distinguish sales for retail only and sales for consumption through the seed to sale SOR. The amendment here is to add the term seed to sale for consistency. It was something that we recognized was omitted. And so it was an addition for that term.
Okay, Commissioner Roy?
I have a friendly amendment. Should we add point of sale as well?
May I ask a qualified question? So, Commissioner Roy, the seed to sale system is working directly with the point of sale. I'm not sure that the point of sale system, by going through the seed to sale, could not be impacted, but I might be incorrect. So, but that would be, we're going through the seed to sale is what gets to the point of sale. But you're saying through the seed to sale and
the point of sale.
I don't know if they can be separated, so I think that it covers it, but I don't know that it's problematic either. But that's just my initial thought.
Chair, if I may. The amendment was to clarify that we're referencing the specific definition of seed to sale system of record, which is also noted as seed to sale SOR, which means the electronic tracking system designated and required by the commission to perform a process. So it was essentially, the amendment was because part of the defined term was missing there. I'm not sure if that helps answer your question, but I just wanted to give a little bit more clarity.
So I believe our Chief Technology and Innovation.
Thank you, Dear. I do want to point out that some of our MEs use metric directly, their seed to sale system directly to record all transactions, then they may not be using a point of sale system. So having it included might force someone who might otherwise not use a seed to sales, might not use a point of sale system.
So, but do all our point of sale systems interface with that? Like, not everybody uses. There's one that 80 to 90% use.
Correct.
Now, for the ones that don't, does that interface with metric?
To my knowledge, most point of sale systems do, but it's not a requirement. So now, wouldn't be efficient for an ME to dual enter, but there are those that may dual enter, both record the sales transactions in metric and in their point of sale system.
If I may, Madam Chair, so Commissioner Roy, just to clarify, would it be through the seed to sale SOR or point of sale system? Is it
be interfaced with the POS? So the SOR must be interfaced with the POS.
I think so, but I think also to your point, and we can confirm by answering the question of if it is a and or, but so for consumption, sales for consumption through seed to sale SOR or POS or point of sale system, is that basically what you're asking for?
Wait, I'm sorry, can you repeat that?
So it would be basically your question is to add for consumption through seed to sale SOR or point of sale system.
And, not or.
And point of sale system. Okay.
You say and or. I'm saying and. I'm saying both. It needs to be
and or. That. No.
And would apply. I could do it in my point of sale system,
right.
Or not into our system of record.
I'm saying both.
As I understand it, I'm not the legal expert on this one, but in our standard adult use, it doesn't specify point of sales, though requirement is it has to be in the seed to sale, however it gets there. And whether that's a manual or through a point of sale system, the requirement is to be in the seed to sale system. And I'm not sure, so I'm that's really cautious, cautious. If you say point of sale only, it may supersede the.
That's right, and I don't want to do that.
Yeah.
That's not my intent. But my thought was, I know we had an enforcement action where folks weren't recording things properly in the seed to sale of record and weren't reconciling and so this is like that belt and suspenders, because we've had enforcement actions where it was not done properly. So this is just an insurance policy to make sure that it is.
So do you want to?
All I would like is and POS. Are you comfortable? You're comfortable.
Yeah, I'm comfortable with it. Obviously, I think it's a bigger conversation too, but in general, beyond just the social consumption conversation.
But I also think that as we're kind of moving forward, and obviously we don't have our funded upgrades to technology, and so some of that, a lot of this is going to be evolving and developing as we hopefully get our resources to update our own manual systems. And it might also be maybe through guidance or encouragement that, especially when we're dealing with something that is going to be a brave new world, new licenses, new kinds of, we don't know what the barriers are, but how we do that. So as long as we're comfortable, I think that your addition is appropriate. And I think that a lot of this is going to change over the course of the next 12 to 18 months to when this gets unrolled.
Certainly, potentially. I just want to make sure that you're not breaking that what you want is the requirement of the seed to sale, which is the
yes.
Right now,
right.
That's where that is the.
It's both. It's not one or the other.
Yeah. But you also want to make sure that you're not also tying someone who does not have a point of sale system to have to use a point of sale system to track.
So as a cash box?
I mean, they use cash, not cash, but they could be directly just using metric only seed to sale.
But that is their point of sale.
But it's not by definition a point of sale system. Cautious.
It's just. Oh, sorry.
We can.
Yeah, okay. So I think it would be appropriate to take a short break so at 2:45, we will come back. Attorneys Baker and Bruno, I'm hoping that we only have, I think, one or two other things that I wouldn't say controversial, but more complex. So if we could, I will entertain a motion to go into recess until 2:45. Do I hear a motion, Commissioner Roy?
So moved.
Do I hear a second? Commissioner Stebbins, having been moved and seconded. All those in favor say aye. All opposed, we will break until 2:45. Then you can Google that.
All right, hello, Tell friends. Let's take a pop in to look at the Julio Fulio trial. All right, my name is Grant Smith Ellis, and the commission is in recess. We're almost done. Social consumption regulations are coming. I think a lot of people are going to be happy with this. It's pretty robust structure. I think it's looking pretty good. The only people who aren't going to be happy with this are the people who are now regulated. The events, they're screwed. They have to get HCAs, local host community agreements. I mean, maybe we can talk a little bit about that. We'll see what the Julio Fulio trial is doing. So let's pop in. Let's take a look. And the commission is back in 10 minutes. So let me just pull this up on the screen. All right, let's watch.
Sentence. Fully was talking about Therese on social media.
On social media.
Mm-hmm.
And then she says, I'm trying to put 2 and 2 together. And and she says to you, that is Julio, though he recruit a bunch of dumbass NIGGAS who's willing to die. Is that what you said in response to her?
Yes.
And what do you mean by he's recruiting a bunch of people?
Well, it was something that really was city known and everybody was saying, like, I'm not the only person that said that. A lot of people in this city has said that, like, he recruit a lot of people to die, meaning that he got a lot of people that will come behind him ready to risk their life behind him, and he's still out and alive and living his life.
And he's a part of 6 Block, right?
Correct.
And then she responds back, right, and he's starting to realize, but first time I saw him, that shit clicked on him. When Julio called, we all in the garage, he talking about NIGGA, always want me to ride with him when he down here, so I can be the one die, not him. I ain't no bodyguard, bitch, I was dying. What's she saying when she says that?
I believe she's referencing to what Therese told her about him and how he felt about Julio.
Okay, so she's not saying that she's ever met Julio when she says, when we called, Julio called, we all in the garage, he talking about NIGGE, always want me to ride with him. Who's she referring to when she says he always wants me to ride with him?
Well, she was dating Therese at the time, so I'm pretty sure that phone call happened while she was with Therese, and she overheard the conversation.
And how does Therese know Julio?
They used to be in the same group, and then they split up.
6 Block.
Well, it's a lot in 6 Blocks, so I guess you can say that, yeah, he was 6 Block side.
And did you have any concerns about Therese riding around with Julio?
That would be something between her and Therese.
Isn't that just what she's telling you here?
Objection, speculation.
Overruled.
Well, yeah, if he's saying that he don't want to die and riding for him, then I would be worried if that was my boyfriend at the time.
And right before that, you're talking about he's recruiting a bunch of people, right?
Yeah.
It was in direct response to that message, right?
Right.
And then what was your response to her?
LMFAOO, bitch, I'm crying, cause no, for real, like, B, do your own drill. The fuck, don't nobody want to die behind your squid face, A. At least he know, shit.
Okay, and who are you referring to now?
We're still talking about Therese.
Your Honor, this time we pass the witness.
Okay, cross.
Oh, it's right over there.
Good afternoon.
Good afternoon.
These messages you see here, what's the date on the message?
2021.
January 2021?
Yes, sir.
Alicia's still in high school?
Yes, sir.
She's 17 years old?
Yes, sir.
This is almost 5 years ago.
Yes, sir.
There's a message there in the middle from you. It's not really a message, it says emphasized, right?
Right.
You're emphasizing a message that Alicia sent to you, Alicia Andrews sent to you, right?
Correct.
All right, what does it mean when you emphasize a message?
It means like I agree.
All right, so you agree. Now, when you and Alicia are texting back and forth, how old are you at the time?
I'm 18 at the time.
All right, are you young at that time?
Yes.
All right, and when you and Alicia are texting back and forth, does this have anything to do with Alicia wanting to kill Julio Fulio?
No.
Did you ever want Julio Fulio to die?
No.
Even though you emphasized the message there, did you want Julio Fulio to die?
Objection, Your Honor, relevance?
Overruled, but she has already asked and answered it, so anyway, what's your next question?
Even though you emphasized the message there, did you want Julio Fulio to die?
No.
All right. And when you all are talking back and forth and you're calling each other the B word, bitch, are you all really meaning to degrade each other?
No.
All right. Is that more of a figure of speech?
Yes.
All right. And when you all are talking back and forth with each other, is this a form of gossip?
Yes, it is.
Are you and Alicia Andrews gossiping about what's going on in Jacksonville?
Yes, we are.
With all these different people, whether it be Therese, whether it be Fulio, whether it be this group or this neighborhood, is that gossip?
It is gossip.
All right. And is it ignorant gossip?
It is ignorant gossip.
All right. And you two are sort of spectating what's going on out in Jacksonville. Is that accurate?
That is correct.
All right. So you all see a lot in Jacksonville as it relates to this gang activity and people not getting along. Is that correct?
That is correct.
All right. And the commentary that you see here, that you're engaging in, even when you say that you would put a bag on somebody, that is more satire than anything.
That is correct.
All right. Do you even know how to put a bag on anyone?
No.
Do you have any money to put a bag on anyone's head?
I do not.
All right. Would you even know who to call to put a bag on someone's head?
No.
It's in the messages. You see here it says he needs to die. You see that?
Yes.
You've seen people say that Alicia Andrews needs to die, correct?
That is correct.
Online?
Sustain the objection. That's inappropriate.
Have you talked to anybody, or has anyone talked to you in the same sort of manner before?
Yes.
Sustain the objection.
Can we come sidebar?
No, sustain the objection. Ask your next question.
Satire than anything.
That is correct.
All right. Do you even know how to put a bag on anyone?
No.
Do you have any money to put a bag on anyone's head?
I do not.
All right. Would you even know who to call to put a bag on someone's head?
No.
It's in the messages. You see here it says he needs to die. You see that?
Yes.
You've seen people say that Alicia Andrews needs to die, correct?
That is correct.
Online?
Sustain the objection. That's inappropriate.
Have you talked to anybody, or has anyone talked to you in the same sort of manner before?
Yes.
Sustain the objection.
Can we come sidebar?
No, sustain the objection. Ask your next question.
All right. The way that you all are talking in the messages, is that new to you?
No.
Is this something you've never seen before?
No.
Is it something that's only Alicia Andrews is saying?
No. It's something that city known.
Fulio, a lot of people did not like him, correct?
That is correct.
Overruled. As far as the context of this text conversation.
Fulio was one of the top instigators in Jacksonville when it came to drill rap. Is that accurate?
That is correct.
All right. And he was one of the more popular drill rappers in Jacksonville. Is that correct?
That is correct.
He had a lot of enemies, right?
That is correct.
And those enemies existed outside of ATK and outside of 1200, right?
That is correct.
All right. You see this message in the middle here, talking about an individual named Robert?
Yes.
All right. This message is talking about an individual who died at Rains. Is that correct?
That is correct.
Is Rains a school in Jacksonville?
Yes, it is.
And did Alicia Andrews attend Rains?
She did she didn't graduate from Rains, but she did attend Rains.
She attended Rains. And when she attended Rains, did an individual die at Rains?
Yes.
At a football game?
Yes, sir.
Is that what Alicia Andrews is talking about here?
Yes.
her reality.
Yes, sir.
All right. And how Robert was accused of killing Rains.
Correct. He was accused of killing Spaz.
Okay, I'm sorry, not Rains. Correct me. Thank you. That Robert was accused of killing someone at Rains.
Yes.
So she's just talking about what's going on at school.
Correct.
Alicia Andrews ever told you she was planning on killing Julio Fulio?
No.
Did Alicia Andrews ever tell you that her boyfriend was planning on killing Julio Fulio?
No.
Or that any gang, are you in a gang?
No, sir.
Is Alicia Andrews in a gang?
No, she is not.
And earlier you said that Alicia Andrews had heard rumors of her boyfriend being in a gang. Is that correct?
That is correct.
Is anything in the text messages that you saw from 5 years ago, is any of this any sort of coded gang language?
No.
Since these text messages almost 5 years ago, do you know of Alicia Andrews texting you saying that she wanted Julio Fulio to die?
No. That was the only time we talked about Fulio.
All right. No further questions.
Okay, redirect.
Yes, those were only 3.5 years before the actual homicide of Charles Jones occurred. Is that correct?
That is correct.
And what you are saying is idle gossip. You're also talking about real people who died. Is that correct?
Correct.
Leaky really died. Is that correct?
That is correct.
Spaz really died. Is that correct?
That is correct.
And Spaz is Gerard Joe Rod Adams. Is that correct? That's his name.
That is correct.
That's Will's friend.
Correct.
That's a person who went to high school, correct? You said
I didn't go to Rains, so I cannot testify to that.
You didn't just testify to the defense attorney when you said Spaz that he was shot at Rains High School?
That's public knowledge.
Okay. And it's also your personal knowledge, isn't it, ma'am, that your good friend, Alicia Andrews, went to Rains High School. You know that, right?
I do know that.
So you're talking about this idle gossip. You're talking about real events and real people who have died in the defendant's life, correct?
You're saying her personal life, like it wasn't like her sister or cousin or anybody that died. This is stuff that we've seen on social media and we were discussing it.
Okay. But you're the one who said it was her friend, right?
We both know him. Like we know him. We're from Jacksonville.
So you're a friend as well.
I wouldn't really call him a friend, but I know him.
Okay, but you just testified that it was your friend. Is that right? That's your words, friend, right?
Okay, well, friend is I'm going to say associate. Like, we know him. Or we're acquainted with him, but I wouldn't call him our friend.
What does drill rap mean? You just said to the defense attorney, Julio Fulio's one of the most infamous drill rappers in Jacksonville, right?
Correct.
He's not the only one, right? There are other famous drill rappers on the other side in Jacksonville, right?
Correct, but he was the face for his side.
What about Young and Ace? Is he the face of drill rap for ATK?
That is, you can say that, yes.
Okay. Do you know who Spinabenz is?
I know of him. I don't know him personally.
Heard some of the drill rap from Spinabenz? Right? There are other famous drill rappers on the other side in Jacksonville, right?
Correct, but he was the face for his side.
What about Young and Ace?
Right.
Is he the
And
face
we are
of drill
back.
rap for ATK?
And if we can, and we know that, we got past recording sales, page 94, is that what we're looking at right now?
Put some suggested language. Chat. Oh, me?
I can add it to the main chat.
Yes, thank you.
And that's actually one point I'd just like to make, you know, during the meeting, this is one of the things I raised, right? I noticed last week that when people are like asking for legal opinions or there's conversations going on outside of open meeting, it would be really helpful, you know, for instance, we had the general counsel I know was texting and trying to get some answers during the last meeting. And I think it's appropriate that we make sure that we limit any of those sort of offline conversations so that we can all see what the question is being asked, what the answer is, if we're not going to be doing it in public meeting.
Just for clarity, so let's say the general counsel needs assistance from the DGC. Right. He needs to answer in the group chat.
Yes.
Okay.
Yeah, I don't think he's not here, but anyway, I've already raised it with Mike, because I think it also, when we understand the legal question being posed, we can determine whether or not the answer reflects the question that was asked. We just want to make sure that the question is being asked, the accurate one, and then the response we're getting back is accurate. So anyway, let's go to page 94, and we're all set.
Madam Chair.
We're recording sales. Please, Attorney Baker.
Thank you. So just going to reread to orient us again. So a marijuana retailer who operates a supplemental on-site consumption license in the premises shall distinguish sales for retail only and sales for consumption through the seed to sale SOR. So again, this amendment is us adding seed to sale prior to SOR because that is the defined term that was left out of this last draft. So we viewed this as a technical amendment. We're getting into the more substantive dialogue pertaining to that. And the ED offered some language that is elsewhere in the regs that says after the point of sale, comma, there shall be a reconciliation of that inventory in this SOR. So that's up for debate from the board now.
Can you give me sort of further, just further context, just a little bit more of an understanding of what we're proposing here? I think I understand, but if you could just dive into a little bit more.
So again, for the purposes of legal raising this issue right now, it's the technical amendment adding seed to sale for the definition, but backing up some more background here. The reason why we need to separate these two is because for DOR purposes, for HCA purposes, whose license is the sale coming under? So that's the intent behind this provision holistically, but I see Commissioner.
So thank you, and that's really helpful that you just said that. So I've toured so many retail establishments that sell locally blown bonds and glassware, and so do they buy it in the retailer and they go and use it in the supplemental side? And how do we record that? So I'm thinking of the glassware and the bond. That's why I wanted, but this doesn't even satisfy that. That's why I wanted point of sale recorded as well, because to your point, commingling, DOR, it was bought in the retail, but it's used in the, or they're going to take a few off of the retail shelf and stick them in the supplemental side. And so I just want to account for all of that.
Attorney Baker.
Thank you. So under the current draft, social consumption establishments can sell branded goods and marijuana accessories under that license.
Right.
So in this hypothetical we're in, again, we're in a marijuana retailer that has a supplemental on-site consumption license. So that's where we are.
Right.
So they're going to have one line for retail, get it and go out essentially. And then the other line, which is get it and then go to the consumption area for consumption. So what am I saying?
So in that line, I'm going to pick up this awesomely locally hand-blown pipe glass bond, and then I'm going to bring it into the other side. But the other side sells glass bonds too. So I just want to make sure for DOR, they're two different license types. And so everything should be properly recorded under the roof of that license type. And by adding point of sale, Metric doesn't care about the glass bonds.
Mm-hmm. Right. And so we are recording marijuana and marijuana products through the seed to sale. And again, that's what we care about here. I've mentioned this to commissioners offline and at a public meeting, but our establishments here under social consumption have to comply with all regulations under 140 as well for cannabis retailers, which includes language where they must adopt separate accounting practices at the point of sale for marijuana and marijuana product sales and non-marijuana sales. So we have that kind of elsewhere being considered, to your point.
But that's for the, repeat that?
Sure. So that's, and thank you, Enforcement Council. The citation is 145G
Yes.
for retailers, but again,
That
you
applies to
cross-site.
retailer. Yeah, so you're cross-citing.
Right. So our social consumption establishments do have to comply with that as well. I think your consideration is captured there.
Could you read it again? Just
Sure, of course. So this is again 145G, and it says a retailer shall adopt separate accounting practices at the point of sale for marijuana and marijuana product sales and non-marijuana sales. And these amendments have gone through a lot of revisions here, but I'm pretty sure that we have an equivalent.
That's what I'm saying. We need
amendment for 141 as well.
Yes, I want them to be in harmony.
And if I could just quickly, because I'm looking at sales, because one of the things that we went over yesterday in my tutorial is we were talking about rental and
response.
Yeah, and sanitation.
Yeah.
And so that's not sales, that's rental.
That's rental.
So where's that?
That doesn't cover it in seed to sale.
Okay. I just raised that. I don't know, because we got sales, but we're gonna have rental of bonds apparently, which I only learned yesterday. So I don't know how that works.
Madam Chair, if I may.
Please, thank you.
I'm just going to read some language that's also under 141 specific to social consumption establishments. This is 141 4E. All marijuana and marijuana products sales shall be tracked by the social consumption establishments using the seed to sale SOR. Marijuana establishments licensed to operate supplemental on-site consumption establishments in its existing marijuana establishment premises shall ensure separation of sales under the marijuana establishment license and sales under the social consumption establishment license. Marijuana establishments selling marijuana and marijuana products through a marijuana event organizer license at temporary consumption events shall track the seed to sale SOR and shall provide this information to the social consumption establishment.
Again, that doesn't account for the bond rental. None of that accounts for the bond rental.
I think
it's something we need. I mean, if this is something, not that I don't want to have consensus here, but I had never heard of this until yesterday, that this was an option, and we were talking about it in terms of public hygiene, but I think that this raises, it is sales, because technically someone's going to pay someone, but I don't think of a rental necessarily as a sale. So we should just let's.
So, do you want to? So, if I may, all of that language is great, but it just accounts for separating the marijuana products from the retailer to the supplemental, but it doesn't account for the bong, the glass blownware, and the bong rentals anywhere in that.
The language that I had read to you did, because it's marijuana products, and non-marijuana.
For retail, and you're saying it's cross-cited, but should we expressly state it as opposed to just cross-citing it?
If that's the board's choice, then sure.
I would suggest cross-citing is good, but the clearer and the more explicit we can be in these regs what we mean, I think the better, because here, plain reading of the statute, sometimes even said the Cannabis Control Commission tends to be a challenge, right? So I want to make sure that we are establishing a plain reading, that there is no subject, not subject to interpretation, not subject to any confusion.
Thank you, Madam Chair. So there's two things going on here, right? What's before you is under I, and then you've also added the consideration for the non-marijuana recording. for social consumption establishments, do you want to put that into this reg? Or that's, I'm exploring where the board is on both questions, and we're happy to draft offline and come back to you if there's consensus.
And I think that Commissioner Stebbins, are you good with that? Okay. All right. Thank you. That was helpful. All right. Thanks. Moving on. Thank you. And this is, that was reporting sales. So we're now going to written policies and procedures on page 98 through 100. Is that where we're going now? Okay.
Yes, Madam Chair. Yes, thank you, Madam Chair. We are at page 98, 500, 141, 2. We'll start with B. This reads, procedures to ensure that products purchased for consumption on site are distinguished from products purchased for retail sale, which are not to be consumed on site if applicable. This particular language was brought down from 050, which is where the written policies and protocols.
Can I just back you up? We're too big. Oh, I thought I heard her say E. I'm sorry, B.
I apologize.
I'm sorry. Go ahead. Thank you. Sorry.
Thank you. Yes, this language was previously housed under, excuse me, 500-050, section 6, where written policies and protocols were previously kind of summarized. And so it was one of those SOPs that we realized hadn't been previously brought down as we had done with all of the others. And so that language is taken from that previous section.
Are there any comments or questions about that? Commissioner Stebbins? No, we can have a consensus and move to the next one.
The next amendment is to subsection C, just following B, procedures to ensure that all sales and service of marijuana and marijuana products under a social consumption establishment license comply with 935 CMR 500-141A. You'll also see the strike through of the language below. The changes to this particular section are to add the language and service and comply with 935 CMR 500-141-4A. What we've done is we thought, because this language is much more regulatory rather than house it in technical standard requirement language, rather than house it within what's required for a protocol, to actually build it out within the actual social consumption establishment sales subsection, which is where it seemed to be more appropriately housed. So that pin site is the cross reference to where it's now built out.
Thank you. I think I understand that. Any questions or comments? Okay, moving on, and we are now at proposed amendment page 100.
Madam Chair, if I may.
Please.
We are on, I just want to make sure we're all following along. We're on page 99, and we'll be looking at subsection D. I apologize.
That's okay. 99 subsection D. I got it. Okay, thank you.
Okay. Procedures that describe sales and service practices, including but not limited to procedures for order taking, product handling, portioning, delivery to consumers, and ensuring that all sales and service activities are conducted in compliance with 935 CMR 500-140 and 935 CMR 500-141. Such procedures shall include a description of dose verification practices to ensure that any marijuana products offered for consumption on site are sold and served in accordance with the limitations established in 935 CMR 500-141 subsection 3. This is all new language. In part, this is based upon what we heard in public comment as a comment to further describe and require written processes for things like dose verification and how the marijuana is going to be handled within the consumption establishment when you're actually making those sales and service. And so we thought that it'd be appropriate to include that language here.
Commissioner Wright?
This might be a question for INE.
But with the social consumption and being able to break down into,
Could I just, if you want to?
I'm gonna throw it out and then going into single servings or micro servings, have we consulted with, is Metric able to handle this? Metric will do this.
Please, thank you.
Yes, and yes, INE has been essential in that conversation because of their direct work with the vendor. But other states are doing it right now through Metric, and we would also be able to do that. It would require us updating our agreement with Metric to include this. But that is something that we will work on post promulgation.
Okay, yeah, that's hugely important. Yes, okay, thank you.
Thank you, Madam Chair. I'm hoping, hopefully here, which I believe will be the 29th, we'll discuss, we can have some also just discussions about implementation, what we're seeing right now, what we'll be working through, and then also at that point, the CFA will be able to speak to how we're quantifying the budget impact of the social consumption regulations as you approach completion. And so right now, the CFA is looking to summarize all of that. That would be one of those components of what we may need above and beyond. We're using our IT platforms right now.
Thank you. Any questions? We can move past this. Attorney Bruno?
Thank you, Madam Chair. The next subsection is E, procedures that describe infusion processes permitted by consumers, including procedures to prevent cross-contamination and to ensure that no infusion activities occur by marijuana establishment agents in violation of 935 CMR 500 141 9C. And that is a cite to an express prohibition on infusion on site. And this again was in response to public comment that we received to more clearly require these establishments to define how they're going to be allowing these practices.
Mr. Roy?
What's that, DPH?
Oh,
here.
Attorney Baker?
Thank you. And thank you for the question, Commissioner. This is actually, we've spoken to so many stakeholders here. It's not just DPH, it's both our consideration for our regulations, DPH's consideration for theirs, and also DOR's for theirs. Once you merge these products together, all of our regulations are intersect and it gets way more difficult and ultimately not workable. So for some context and for the public, we did receive a lot of public testimony that wants us to have live infusion, and unfortunately because of those parameters from all the agencies, we can't take that step. So just wanted to put that out for the public. That's why we went the other way from some advocacy here, and it's unless the federal prohibition is lifted, we can't cross.
No, but it's also just respecting taxation, public, you know what I mean? Those kinds of things that we're trying to respect.
Exactly.
Any questions or comments?
Yes. No, and I just appreciate that, Deputy General Counsel, because we did get feedback about, the infused foods, and a lot of people had high expectations and high hopes. But it's really not this board being like prohibitionist in any way. It's the parameters within the Schedule 1 and the federal illegality that hampers our ability to permit that. Correct?
Exactly.
Yeah. Okay.
Moving on. If we don't have any additional questions.
Madam Chair, if I may. The next amendment is under section F. After a conversation earlier, this is related to those public view discussions that the board had earlier. And so I will reserve this one as tabled for a later conversation. Next is subsection, let me just double check. F, or I'm sorry, that was F, and we'll be going to subsection I. Procedures to ensure that marijuana or marijuana products purchased on site do not leave the premises except as otherwise authorized in an exit bag under 935 CMR 500 141 B3 and 935 CMR 500 141 4M. These are just clarifications that any excess beyond what might be a point of sales limitation. I know that those are things for the board's consideration, but anything beyond what the consumer might be wanting to consume at the time that they're within the establishment, they have the ability to have that doggy bag go home with them. And this is a policy and protocol that establishment will require going forward.
Commissioner Roy?
And this allows for the scenario that I go in, I say, give me 2 pre-rolls, I get an emergency phone call, I got to take them to go. And I didn't even spark, nothing got lit or sparked, right? That would allow for scenarios like that as well.
If I may, Madam Chair.
Thank you.
Yes, exactly, Commissioner Wright.
Yeah, okay. Perfect, thank you.
Okay, consensus, moving on.
The next subsection is subsection Q, which has brought us to page 100, which reads, emergency response procedures where social consumption establishments shall contact emergency responders if a consumer demonstrates signs of unresponsiveness or medical distress in accordance with 500-110-9A10. These procedures shall require marijuana establishment agents to remain with the consumer until the emergency responders arrive. The addition here is more technical to add marijuana establishment before the term agents to, again, with consistency with the definition. Agent alone isn't a defined term, but marijuana establishment agent is. So that was for consistency.
Well, one of the questions that I did have, and again, I haven't had an opportunity to walk through every, section and subsection. So this is also pertinent to training. I know that will come later, but obviously that comes in here. Are we requiring at any point within this stuff that I haven't gone over with you, are we going to be requiring something like TIPS training? Do we require fire extinguishers? Do we require defibrillators? Do we require somebody to have CPR training? Is any of that baked in at a later point that we'll be discussing?
Madam Chair, if I may.
Please.
Yes, so the social consumption establishment agents will all be required to undergo a special responsible vendor training specific to social consumption establishments. I believe that's something that's going to be built out through the guidance process and in the implementation next steps for the commission.
Okay, Commissioner Stebbins?
Thank you, Chair. Yeah, just an update. When we get to that RVT portion, there are things that we already prescribe. We can also add to that list of anything that we want to do. And we've come across another state that now I'm blanking on which it is that has a social consumption agent training that a whole bunch of us are going to try to go through. So, some of those components we can certainly build into it as we go forward.
Thank you. Attorney Baker?
Thank you. And I think we received testimony to add CPR to the training. And again, we haven't come across that holistically. It's a commissioner decision, and we'll get to that next time. But to Commissioner Stebbins' point, that is under your discretion on what else to add to the program.
Would you also, before we get to that a little bit, I think we're going to get to that, or I don't know if we're going to get to that later. But what is required on premises for bars? Obviously, everybody has to be TIPS trained. That's a basic. Do they require people to have defibrillators? Are they required to have somebody on site that knows CPR? Obviously, I would assume any responsible event organizer or on site is going to want to do that. Obviously, protect themselves from potential liability, but is that anything in the, yes, Executive Director?
I may have to look into it. I think the way that I would recall it is that wouldn't be in the example of the bar through the ABCC, it would be through the building code. But I will confirm that. That's my understanding, but I will confirm that and get back to you.
Meaning that localities are already doing stuff like that.
Right. Most of those requirements are more related to fire code, building code, those types of things, and not necessarily built into the fact that they are a bar from the ABCC. And so in this instance, again, there are requirements in these municipalities that don't necessarily need to be considered by this board, but we will review that to ensure that is picked up, because there's a number of things that we've discussed in the context of social consumption, putting out something that's on fire, for example, that does fit into and exists in fire marshal parameters because of cigar shops, et cetera, that already exist. And so we've looked at those, but I'll confirm the CPR and the defibrillator, whether that would need to be considered here.
Thank you. Commissioner Stebbins?
And thank you, Chair. And quick clarification. Actually, I learned this as we went through the process. TIPS training is not required by the ABCC. Obviously, I think folks do it to get the benefit on their insurance and lower their liability. So that was an interesting fact to pick up.
And I think in the chat here, Commissioner Wright has stated that the ABCC does not require establishments to have a CPR certified person, although they mandate responsible. What says here? They do require?
Well, it says server training such as tips.
Got it.
Not necessarily.
So they don't prescribe it. Okay. All right. Good. That's it. Yeah.
Sure, and I would just note as well, some of the conversations we've had in the past as well, you know, in a one-day liquor license scenario, a lot of times what the municipalities now do and what they've essentially been trained to do over 80 years is where the ABCC may allow you to have an event where not everybody serving alcohol must be tip certified or something to that effect, and maybe only the business owner is. The municipality will generate within our one-day liquor license that we're providing you that everybody who's serving alcohol is tip certified, and then they set that themselves, and they've made that choice above and beyond the ABCC's guidelines. So those are some of the things as well that I think.
So we will be kind of creating this for the first time if we haven't seen it in other jurisdictions. They don't do it in Colorado, California.
New Mexico. Sorry, New Mexico is the one that is.
Point. I think it is a local control issue because I just, for instance, the town of Lexington, if you have an establishment of 25 seats or more, you must have a person certified and choke saver certified. So I think it's a local control issue at that point.
All right, thanks. All right, we can move on. This is helpful. Thank you. Attorney Bruno?
Thank you, Madam Chair. We're still on page 100, subsection S. If indoor smoking consumption areas are allowed by the social consumption establishment, including the ability for consumers to use the methods of combustion, smoke, heat, vaporization, and aerosolization indoors, procedures and building plans or schematics to ensure compliance with 935 CMR 500-141-10. And you'll see below that there's language that has a strike through. The changes here, of course, in addition to the strike through, are specifically to add the compliance with 935 CMR 500-141-10. That change is due to the removal of those technical requirements housed within written protocols and policies and procedures to be moved down to the indoor smoking consumption area section. So those have been essentially transplanted down to a subsection.
Thank you. Any questions or comments? All right, moving on.
To subsection T, if outdoor smoking consumption areas are allowed by the social consumption establishment, including the ability for consumers to use methods of combustion, smoke, heat, vaporization, or aerosolization outdoors, procedures and building plans or schematics to ensure compliance with 935 CMR 500-141-11. This is again similar to the transplant of the language for any outdoor smoking requirements rather than being housed in policies and procedures to more appropriately be placed in the outdoor smoking consumption area requirements.
Thank you. Any questions or comments? Moving on.
The next subsection is U. Procedures to ensure that smoking tobacco procedures to ensure that smoking tobacco or consuming tobacco products are prohibited. This was, again, one of those other legal amendments to
say that out loud. So these are R.
Consuming tobacco products. It would be is, but I apologize, Madam Chair. The legal amendment is to remove the or consuming tobacco products because tobacco now encompasses tobacco products. Okay. And so one of our legal amendments would be to revise that language.
Okay.
So should be read as procedures to ensure that smoking tobacco is prohibited.
Okay, thank you. Right, any questions, comments? If not, moving on.
The next subsection is subsection V. Apologize. Bear with me. Okay. Sanitary practices in compliance with 105 CMR 500.000 and 105 CMR 300.000 if applicable. The amendment here is just to add in the .000s for both citations for legal consistency.
And is this what we're, so I think you stated to me yesterday that this is being left almost purposefully broad because we're still not necessarily sure. Is this where we're talking with the bong rental? Or is this, what sanitation is this?
So, Madam Chair, if I may.
Sure.
This is sanitary practices as a whole, you know, making sure that the trash cans are emptied and the bathroom is cleaned. But there are some other locations where what we discussed yesterday is, we will certainly get to those.
Okay, thank you. Thanks for that clarification. Okay. Moving on.
And subsection AA is the last amendment in this section. Excuse me. A social consumption establishment licensee shall update its standard operating procedures when utilizing new consumption technologies or marijuana accessories in its indoor smoking consumption areas in order to limit secondhand smoke or vapor and in accordance with 935 CMR 500.1045. The amendments here are really grammatical, to add A before social consumption establishment, as well as after the word technologies or marijuana accessories. So we wanted to make sure that we are capturing any future types of marijuana accessories, whatever the world might create.
Thank you. Any questions or comments? None. We have consensus. We will move on.
We will move on, excuse me, to page 103, the age verification section.
You want some? Do you need water?
Oh, I have some right here. Thank you.
I know that when you're having to talk for that long, you don't need a vocalization break.
No, I'm.
She just wants to get done.
I appreciate it. Thank you.
I couldn't keep doing it.
It's just a bit of my annoying asthma, so bear with me. No, yes, it's no big deal. So we will look at subsection B. A social consumption establishment shall conduct age verification upon entry using commission-approved ID scanning software. The amendment here is this whole language, and so we wanted to kind of break out and clarify that all of these establishments will be required to use this ID scanning software.
Oh, shall? Am I in the right place? We're B?
We are 103, subsection 5B. Page 103.
Okay. Social establishment shall not allow.
5B.
I'm looking at it. I think I'm looking at it. Go ahead, Commissioner Roy.
And this is, you know, part of the red tape removal. What I would like to propose is with this software, you know, when we get to the red tape, you know, we hear time and time again, we have to check the ID, not once, but twice. At the point of entry and at the point of sale. So down the road, I'd like to propose, if you have this software, then you only got to do it once. And if you're doing it by human eye, you got to do it twice. Because then the advent of AI and these IDs, honestly, the only truly way to detect if it's legit is through this software, because it's the number. It has to check cross databases to make sure that the number is accurate on the license. So it is to incentivize people to get this software, which a lot of them do have it. Maybe we say, okay, if you have this software, which I don't think is very cost prohibitive, then you only got to check it once at the point of entry. But if you don't, and you're doing it the old-fashioned way, then you got to do it twice. So just like you know, kind of incentivize.
But I agree with you, except in also thinking about our barriers versus not barriers. When we have, you know what I mean, when I say consumption, am I getting wrong that we will have age verification and tracking with the ID once.
Twice.
Twice.
But I was saying down the road, when we talk about red tape removal.
Oh, all right, okay.
Down the road.
But I'm just thinking about this in terms of what I think of your concern. I agree with you, but thinking about when we're, having different locations within either established footprint in terms of an internal brick and mortar place or out.
Just a handheld just a handheld little.
No, I'm agreeing with you, but in terms of, because we were talking about what flow of coming in and out, like I'm thinking of some potential locations. For instance, there was a downtown location that had a bar, and then on the other floor, there was on-site consumption. How are we, if there was...
We're doing it anyway.
Okay, all right.
Yeah.
Okay, you know what I'm saying?
Yeah.
Okay, all right. Thank you. We can move on unless there are other questions or comments.
We will move on to subsection C, which reads, on entry into the premises of a social consumption establishment by an individual, a marijuana establishment agent shall immediately inspect, using commission-approved ID scanning software, the individual's proof of identification and determine the individual's age. An individual may not be admitted to the premises unless the marijuana establishment agent has verified, using commission-approved ID scanning software, that the individual is 21 years of age or older by an individual's proof of identification.
Any questions or comments or any further?
If I might.
Commissioner Stebbins?
Yeah, I think I agree, the incorporation, right, of the two new technologies, and I think, Sharon, as you pointed out, temporary locations, it's helpful to have something that's obviously not hardwired, but capable to be being used. But I think employing it, and you look down to C, which is the old C, which has been stricken, is that there was an interest, I think, expressed in testimony of make social consumption kind of a hospitality restaurant feel to it. So check my ID once, don't check it for every transaction. So I think those two pieces tied together and striking out the old C, I think, is tended to address those comments that we heard at the public listening session.
Good point. Thank you. Any questions or comments? If not, we can, Attorney Bruno, sorry.
Madam Chair, if I may, I'm just receiving from INE that they may have some comments if you would like to recognize them.
Absolutely.
I hear you. Gaming Commission, did they approve, do you know? Do you remember? Did they approve the?
If I recall, and again, this is going back a few years, but I think there was presentation by the licensee to say, here's the technology we want to use. I don't know through our investigative team, whatever information or data that they looked at to confirm that technology, but.
May I ask, did you confer with the Gaming Commission?
I'll have Tim respond to that.
Okay.
Yes, we did, if we may.
Nice.
Please, thank you. Thanks.
Thank you, Madam Chair. So we were able to review just regulations from the Gaming Commission on this. And so I'm reading from it's 205 CMR 136.07 in subsection 8, which is forms of identification, subsection A. So what it reads is a gaming beverage licensee or jointly responsible person shall use an identification scanner to detect fraudulent identification and may rely on the following forms of identification to demonstrate proof that a person is 21 years or older. So while the language does include similar language requiring an identification scanner, it doesn't have the similar language saying that it must be commission approved. So while there might be some presentation, I'm not necessarily aware of that. The actual regulatory language does not require the Gaming Commission to approve that identification scanner.
You don't have to read the citation, but can you read the language again, just if that's okay?
Please, thank you.
Yes. So the language states, a gaming beverage licensee
or jointly responsible person shall use an identification scanner to detect fraudulent identification and may rely on the following forms of identification to demonstrate proof that a person 21 years of age or older, and then it identifies the specific types of identification that they can rely on. I can also note as well that under Chapter 94G, Section 9, there is language that is similar to language for liquor stores or other stores that sell alcohol, just identifying that licensees, agents, or employees can reasonably rely on certain forms of identification to show that somebody is 21 years old. But there is no identification scanner requirement contained in the statute there.
So Commissioner Roy, does this mean that because so if I can
is your objection not so much with the ID scanning software, it's the commission approved part?
Right.
Okay, so if we strike that, you're happy, it works?
If I may.
Yeah.
Yes.
Okay.
Yeah.
Then let's
So
do that.
Language, if we strike the commission approval
Yeah.
now.
Okay, then you're totally comfortable with it?
Yes.
Okay. See, that was easy. That was good.
No, I appreciate the chief's comments, and I think it somewhat shifts the responsibility. We can say use this technology. I think it's going to be incumbent upon our licensees to make sure they get something that doesn't let somebody through the doors who's under 21, because then they potentially run afoul of our regulations.
Right.
So there's almost the onus on them that they're going to check the technology and make sure it works.
Okay, so you're good with it? Just
Yeah.
I think we're gonna have to start a secret shopper program to do like they did with the lottery to see if you can get in if you're 21. So at some point in time, we're gonna have to figure that out.
Right.
This is how we can do that.
Okay, so we're
Take your
gonna-
friendly amendment and get that done.
Yeah, so the language as is fine, except commission approves.
Thank you. Attorney Baker, Attorney Bruno, you guys all set with that?
Yeah, thank you. Thank you, Enforcement Council. I'm happy to take a look with you offline and try to make that amendment.
Yes.
Yeah, I mean, I think it's easy, so just strike commission approved twice, about 3 times.
All right, thank you. Thank you. All right, we have consensus on that. Moving on, Attorney Bruno.
Sure, I have a fan over here. Do you need to put it over here?
It is, it's stuffy.
If we can, no, but I think that we need to make sure that the reason we have to close the doors is gas running out there and they're not sensitive to the noise coming in, but it's getting very warm in here now. No, don't worry about the fan. I just want to make sure. Moving on, Bruno.
Thank you, Madam Chair. The next section, we're moving on to section 141, section 6, consumption areas. This is 500-141-6A, which reads, a social consumption establishment that allows an indoor smoking consumption area or an outdoor smoking consumption area shall separate the designated sales and service areas from consumption areas. Each indoor smoking consumption area, the changes in this section are specifically to add the language after designated sales and service areas from. And that is in light of.
We're bleeding over into 104 now.
Oh, yes, I do apologize.
Because
just barely.
Yeah, I just, so I'm trying to follow this here, so.
Madam Chair, if I may.
Please, thank you.
This is an amendment to keep in mind the hospitality aspect to add that service areas language, and that is the basis for that amendment.
Okay, Commissioner Roy?
Isn't this also to keep workers safe? In other words, so they're not inhaling secondhand smoke, right? Wasn't that part of the intent as well to kind of make that separate from the consumption area, I believe?
Madam Chair, if I may.
Please, thank you.
Yes, Commissioner Roy. So this is with this hospitality mindset, we're thinking about, not only where a sale might occur, but if a service is going to be made at a table. And so, or if they're going to be served at the bar, whatever other types of areas they might be served in. And so this being specifically in regards to smoking areas, it is, to your point, to protect those workers who might be, exposed to smoke and whatnot, to make sure that their exposure is limited so that any sales or service that they're making is not going to be within those smoking areas.
Okay, so in that scenario, then there's no like high top tables where the bartender comes over, goes back, gets it and bring it, right? So that's not gonna happen under this scenario. Everyone will go up to the point of sale, place their order, get their order, and go to the consumption area.
Madam Chair, if I may.
Thank you. Oh, I apologize for interrupting.
Yes, that's exactly correct. That was the board's, my understanding of the commission's policy on this particular matter for public health and safety reasons. And so this language does separate those.
Is that what we want?
I mean,
Commissioner Cummings.
yeah, I think there's some intention behind that. I think, this is particular just to smoking. So you could still have your beverage, you could still have your food, I think, delivered right to your table or your edible, but this is just confined to indoor or outdoor smoking.
Did he state that?
Yes, exactly. And that's the distinction that's important. Because if you're allowing for indoor non-smoking, then you can commingle the service with the sales. Whereas we are separating that if indoor smoking is occurring for the public health reasons you stated.
Thank you. Thank you.
No additional comments or questions. Moving on, Attorney Berna.
The next amendment is
still on page 104.
104, yes, Madam Chair. So we are on 104. The next amendment is to C. I apologize, I did include B on the list, but it's actually C. The indoor smoking consumption area shall be an enclosed.
I'm on page 104 and it's C up here. Okay.
I apologize.
That's okay.
The indoor smoking consumption area shall be an enclosed space separated from the sales and service areas with a secure door and shall only be accessible from the sales area in supplemental on-site consumption and hospitality on-site consumption establishments. For marijuana event organizers operating a temporary consumption event within a non-cannabis entity, the indoor smoking consumption area shall be an enclosed space accessible only through a secure door located within the non-cannabis entity.
There you go. Yeah. But sometimes it's in an enclosed space, but sometimes if it's outdoors, it's not. Yeah, it's still enclosed outdoors. Sure. I mean, I
appreciate the promotion. So yeah,
we're all good.
So yes, just to the context in which we're approaching this is the indoors.
Right.
So it's just pertaining to indoor for this provision, which needs to be in an enclosed space.
So this is, and I'm, smoking. I see. I understand this and I get this. This indoor got to be separated. Got to have the barriers, ceiling, wall, everything. But this is just for indoor smoking. Okay. Any questions or comments, attorneys? No.
And then we will move on to D. The outdoor smoking consumption areas in a supplemental on-site consumption or hospitality on-site consumption establishment shall be separated from the indoor portion of the social consumption establishment's premises by walls or other barriers and a secure door, and shall be separated from sales and service areas. Outdoor smoking consumption areas shall be accessible only from the sales area in a supplemental on-site consumption or hospitality on-site consumption establishment. The amendment in this section is to clarify that this is applicable to supplemental on-site consumption and hospitality on-site consumption licensees. There was maybe a lack of clarity that it was possible that this type of separation was also required by marijuana event organizers operating a temporary consumption event, which it would be very, very difficult for them to, this language is really contemplating brick and mortar types of establishments. So it would be very difficult for somebody operating something temporary to be able to achieve those kinds of permanent walls and barriers. And so this subsection, the language was just to clarify that it's applicable to supplemental and hospitality site.
Any questions or comments? Nope. And moving on.
And so legal has a proposed amendment on page 104 in the same section to E, which I will read as, excuse me. Marijuana event organizers shall submit as a part of its event plan an explanation and a diagram where indoor smoking consumption areas or outdoor smoking consumption areas are located. An outdoor smoking consumption area shall be at least 30 feet away from the sales area. The marijuana event organizer shall separate sales and service areas taking place in a temporary or mobile structure, including but not limited to tents, trailers, trucks, or other enclosures from outdoor smoking consumption areas. And I know that's a longer one, so if you'd like me to add that into the chat, I'm happy to do that.
Please, but this is also where we are now talking about a temporary outdoor smoking consumption event, and then we are, because we skipped over this yesterday, we are talking about needing a 10 for that.
If I may, Madam Chair.
Thank you.
So this is language that is imagining where the sales may take place. So if there is a marijuana event organizer that has a truck that's set up food truck style to make those sales, to separate that sales area, to have the outdoor smoking consumption area at least 30 feet away from that truck, for example, or if they're making those sales within a tent, to have the outdoor smoking consumption area 30 feet away from that tent.
Can you explain the point of, if there's one indoor, but for outdoor, what is the point of the 30-foot distance, especially for outdoors? And now we haven't got to it yet, but we're debating what is visible and what is not visible. So does that 30-foot barrier, if we're already saying this has to be under a tent if it's outdoors, why are we moving it further away? Is that to protect the workers, or is it, what is the issue?
Yes, exactly, Madam Chair. As we've talked about in this discussion, we can't amend the sale and storage piece. So we do assume that that's going to be under and or if the board chooses some other temporary structure there. And so in that idea, there are going to be workers within that tent, and we want to make sure that there's physical separation from them so that the smoke isn't going directly into the tent, and they could ultimately receive that secondhand smoke and potentially get impaired.
The tent would also, this is also another issue, the tent would also keep any smoke, even in an outdoor setting, on top of people.
Yeah, so if I may,
please.
We modeled this after what most buildings have outside. If you're going to smoke 30 feet away. So that's why we proposed this in a similar nature to try to prevent that from leaking into the tent area.
I get that, and this is again I think trying to conceptualize how this especially works in an outdoor setting and the barriers and the distances. So I appreciate that, and I appreciate the explanation of why that 30-foot language is there. So do we need to, are there any questions and comments? I'm not seeing that in the.
Oh, I apologize.
That's okay.
While Attorney Bruno's typing it, we have similar language that prevents.
It's okay. She's just gonna. Okay.
So this 30-foot language is it's trying to get at what we have in the other context where with the brick and mortar, you have to have things that would prevent the smoke from going in and leaking into the brick and mortar establishment. Again, we don't have that, but we want to offer flexibility. So this is a similar provision to be preventative from that smoke going what is within the tent.
It's also appropriate just to, in terms of keeping track, having, I have this, but does the public get to see us? So that's just trying to make sure we have consistency there. So thank you for putting that up there. It also becomes part of the records of
Madam Chair.
Thank you.
The script that you have, the public has as far as the agenda goes. So that's a part of the public meeting.
So that is in there. So,
Yep.
Okay, fine. Thank you. If there's no questions or comments, are we incident reporting now, or are we still?
Madam Chair, if I may, we are still on 104. We're now at subsection I and number 2.
Oh, okay, I'm ahead of you. Okay. Thank you. I see it now.
Consumption areas, sales areas, service areas, and food service areas, if applicable. This change was to include service areas, again, with that hospitality mindset, just to make sure we're requiring a marijuana establishment to keep its diagrams up to date, which will also include service areas.
Thank you. Any questions and comments about this amended language? Hearing none, let's move forward.
If I may, Madam Chair. The next amendment is to subsection J, number 2, which goes from 104 to 105. It reads, a supplemental on-site consumption licensee that operates in a marijuana retailer and operates an indoor non-smoking consumption area may continue retail operations and may allow social consumption sales and service to occur at the same time. The amendment here is to clarify and add after may allow. We've added social consumption, sales, and then after sales and service to occur at the same time. And so this amendment, I'm sorry, I'm just reading it one more time. A supplemental on-site consumption licensee that operates in a marijuana retailer and operates an indoor non-smoking consumption area may continue retail operations and may allow social consumption, sales, and service to occur at the same time. So the point being that they can commingle those things. They don't have to have those barriers or separation.
Attorney Baker.
Thank you. We're also clarifying, which was correctly pointed out in the public testimony, that in a couple of instances we added retail sales, what would be social consumption sales. So it would be like we confused what was allowed to be sold at the package store versus at a bar. And so we're offering clarification here that the social consumption sale is the most appropriate term of art to use in this instance.
Questions or comments? You're still digesting.
I am. So it's, obviously it's non-smoking, gummies, tinctures, edibles. And so it can happen on the sales floor.
Madam Chair, if I may.
Please, thank you, sorry.
Yes, sorry. Yes, Commissioner Roy. So because the only requirement for the separation is really for the smoking areas. And so this subsection is really kind of identifying that they can continue their retail operations. They don't have to separate those. They can continue their social consumption sales. Of course, they have to have maybe a diagram of where their designated consumption area is. So if that's roped off, but they don't have to separate the sales areas for the sales or service of marijuana or marijuana products. Both can happen at the same time.
So if it's non-smoking, any delineation of space or any, it doesn't, and we're getting to that later?
No, I think no matter what, the consumption area will have to be designated. So if you're going to allow for them, consumers to walk around the entire retail space, I mean, that's probably not what you want as a business. So I don't imagine that the consumption area would include the line, obviously, for retail. So again, that would have to be in their application as to where the consumption area is. Likely, it's going to be in the corner away from the retail line.
Right, but this was also my question, and I thought that I saw this when you were presenting it before, that in terms of the delineation, I mean, is it a velvet rope? Is it are we requiring anything like that? I mean, we have to define it, but how do the customers know where to go and what to do? Commissioner, right?
Yeah, that is at odds with another area of our regs. This is a marijuana establishment may display in secure locked cases samples of each product offered for sale and subject to the requirements of 935 CMR 500-110. These display cases may be transparent. An authorized marijuana establishment agent may remove a sample of marijuana from the case and provide it to the consumer for inspection, provided the consumer may not consume or otherwise use the sample unless otherwise authorized herein. So it's like, it's the index case, but now they can walk around to, like, you see what I'm saying? It's a little bit at odds with that.
Attorney Schreckler?
If I may, Madam Chair, to address Commissioner Roy's concern on this particular point, at the moment that the edible or whatever product they've gotten, at the moment they purchase it, it is now their property. It is not owned by the marijuana establishment. It belongs to them. So that's kind of where that sort of display case restriction that applies to marijuana owned by the marijuana establishment, not something that has now been sold and belongs to the consumer. It's more just a question of the space in which they are consuming what is now their property.
Okay. Commissioner Wright?
Do we need to be more prescriptive in saying may consume only in the designated space, so it's not on the sales floor?
See, that was what again, when I was watching the presentation a month or so back, and I was looking, and I remember saying, we can put it in a plan, but if you're a customer and you walk in, how do we tell the customer, this is the space that you get to walk around and consume? Obviously, there's got to be something that's defined, because you're going to be having people chasing them around, and how do we, do we want the people who are serving have to be chasing people going, no, don't go there? I just think that we need to clarify what we're requiring in terms of that. I don't even call it segregation, but designation. And I don't know if we have that language clarified. And if someone walks over it, what happens if we have a plan? And I saw how you had put together, again, I saw the schematics. So here's the footprint, right? This is Shannon's retail establishment, and we're going to let this part of the room be for consumption. Don't we want to tell the customer, stay over here, don't be walking over there? Should you be bringing your seltzer over to go look at the t-shirts that they're selling? Can they do that? I think that's a little unclear, and I don't want to have either our enforcement, local, and public, service, the first responders, our bud tenders, whomever. How do we put in place that so that customers sort of self-police? Does that make sense? Again, I've seen how you diagram stuff out, but how do the customers know? It's kind of like we're counting on them to know and to abide, so we don't have to have people constantly policing them about where they're supposed to go.
If I might,
Please,
I
Stebbins.
think we're ending the responsibility right now with the licensee, like designate your space. But I think to your point is, how do you let the consumer, how does the consumer know, either through signage or the velvet rope or whatever, what that consumption area is? Unless, right, you're going to have an agent there saying,
And I think it's
over here.
not defined, it could be in the parking lot.
Right.
If it's not defined, like, right? So I think we need to say in a defined designated area, because someone could say, well, I'm gonna go in my car. This is a social premises area.
Right.
So.
Attorney Baker.
Thank you. I'm just a little confused because we do have consumption areas as the defined areas within the premises where consumption is the only place that consumption is allowed to occur.
Commissioner Stebbins.
But that's what the licensee gives us, so we know where the space is. I think we're trying to get to, how does the consumer know I can go over there, be where the couches are around a rope, or they paint it on the floor, like consumption area. How do we make sure that the licensee is identifying it for the consumer?
Right.
And people are walking in to ingest a substance that will alter their inhibitions and their, you know what I mean?
Right.
And just as we need to tell people, I don't know, at a bar, you can't remove, I mean, it's not the one-on-one, but we tell customers what they can and can't do with their can of Budweiser and where they can go. And so I just want to make sure that people know, not even self-policing, but how do we define it so people, we don't have to have people chasing them around. There needs to be something.
It has to be appropriately defined and designated for consumers.
Invisible.
Yeah.
So I don't know what that looks like. And maybe we move, I don't know what that language would be, but it just feels like it needs to be something.
I think we're all in agreement.
Yeah, no, I think so. And I don't, it's just basically, is it a rope? Is it a couch? A couch, but some sort of visible, tangible delineation of space where on-site consumption is allowed within the larger space. Attorney Baker.
Thank you very much. Yes, okay, I agree. I understand what you're saying now. Thank you for the clarification. So then that's the policy question before the board is, what does that look like for you? For you all, what do you want to see there from the licensee pointing it out to consumers? Is it a rope or barrier? And this is, again, to put this into context, this is only going to rise under a supplemental establishment within a retail space that is non-smoking. Exactly. So that's where we are here for this draft, because if it was smoking, it would clearly be within an enclosed space.
That up, and
Right.
we're pretty tight on that. And so people aren't going to be left to their own devices to be smoking. They're going to know exactly where they can and can't go. Commissioner Stebbins, you had.
Thank you, Chair. I think it's a matter, you're right, this is a very narrow niche of licensees that one might have the space to do this or want to do this, but we will know on paper as the commission where they're designated. If you go back to our kind of crude boxes, where in the retail space they want to allow on-site non-smoking consumption. I think where, and I hear your question, I don't know if we want to get too prescriptive. You know, it's going to be rope and stanchions, it's got to be a sofa. It's like, I think we need to put the onus on the licensee just to define it so the consumer knows.
A visible delineation so the customers know where to go. I don't know, I don't think I've stated that, but some sort of visible, recognizable delineation.
And we have a similar context already to pull from, right? We have limited access areas where we have signs that say the staff only. So I understand what you're saying.
Happy to work with him on that language.
Right, thank you. All right. So we're moving on, but we're going to clarify that language. Attorney Bruno?
Thank you, Madam Chair. So the last amendment in this section, I believe we are now to page 105M. If an emergency requires law enforcement personnel, firefighters, emergency medical service providers, or other public safety workers to enter a consumption area, the social consumption establishment shall stop the consumption of marijuana and marijuana products until such public safety workers have completed their investigation or services and have left the premises. This language was added, I believe, specifically DGC Baker had pulled this from other states that also include consumption, but the goal here being for public safety purposes to essentially stop consumption if there's an emergency. So we wanted to include a provision in the regulations that allows us to require that and requires the establishment to essentially stop.
Is this consistent with, say, alcohol and beverage rules? So give me is there a scenario? I mean, obviously if there's a fire, you're going to want people to walk out. So if someone faints, and we actually were talking about a person and another non-regulated who fainted.
Yeah.
And so does that imply if someone just hasn't eaten all day and they go down, what if they went down and someone, oh my God, and they have to call an ambulance, and maybe that person pops up and goes, oh my God, just give me my bag of smart food and I'll be fine. So what does that require the whole place to shut down?
Madam Chair, if I may, please. I see Commissioner Roy.
Yeah. If I may. I think this might be overly prescriptive because, to your point, if someone passes out at Fenway Park, does everybody have to put their beer back away from your beer? It's like, no. So obviously, if there's a fire, they'd have, people evacuate. I just think this might be.
Commissioner Stebbins?
Yeah, if I can, I think Commissioner Ray bring up a good point. I think what we might be missing here is a delineation between, I'm not sure I'd want a public safety official having to walk into a on-site combustion space and be exposed to secondhand smoke.
Right.
If they're walking into a space where everybody's just enjoying an edible, I'm not sure I'd see the same. I think there's a varying degree to.
I agree with that. So combustion.
Combustion.
You're saying what you're proposing is just cease combustion.
Cease combustion. Because I don't think we want any of our, they start to jeopardize their job if they.
But also thinking about ceasing combustion, right? So I just want to,
they'll stop.
But if we're also, think about this practically, if we stop, and then all of a sudden people who have been ingesting, they have to walk out. And what is the process for also making sure that people who are walking out, that they're not walking out? They don't have to walk out, they just have to stop consumption. Yeah. But if they stop consumption, are they going to sit around? I mean, that's, I think we're trying to find something that is not overly prescriptive, but that also, if you stop, if I were at a bar and they go, oh, and stop serving your Chardonnay, I'm not going to stick around waiting. If someone, and I was at a restaurant a couple weeks ago, actually a person who went down, wasn't feeling good. They came in, they took her out, she was fine, right? So if in a bar we had to tell everybody to stop serving alcohol, you're not going to have people in mid-consumption are walking out, I would assume. So how do we address this? And where did you say, Attorney Burnham, where did this language come from?
I think I might have pulled it from a California regulation.
I can't say how.
I think I may have pulled it from a California regulation.
Commissioner Stebbins, how do you feel about this? You think this is overly prescriptive?
It might be a little overly prescriptive. I go back to, I see the value of, I don't need public safety officials walking into a combustion area. Because again, we don't want them exposed to secondhand smoke. We don't want them exposed to being suspected of, when they go back to their headquarters, of having been somewhere else. So I could see maybe a tailor to combustion, but maybe not to the other forms of consumption.
Attorney Baker?
Thank you. A simple amendment to get at this would just be to add indoor smoking consumption area before consumption area here, and then you couch it in just the combustion smoke that you're seeking at.
Are you both comfortable with that, Commissioner? Are you comfortable with that, Commissioner Stephens? I am. Yeah, I am. Yeah. I also think that this could be an enforcement. I think that we are comfortable with that, so we can move on.
Madam Chair, if I may.
Thank you.
We will be moving on to subsection 8, incident reporting. And this is at page 105. This is 500-141-8B2, which reads, any instance involving the consumption of any marijuana or marijuana product at the social consumption establishment by a consumer that was not purchased from the social consumption establishment.
If we can back up, so what we're saying, in addition to the incidents of the consumption, shall notify the commission of any of the following incidents, no more than, okay, so now we're getting into, so it has to be reported if, and then can you complete that? It has to be reported to the commission.
Yes, so I'll read the whole, I think.
Because
Yes, absolutely. In addition to the incidents identified in 935 CMR 500-110-9A, a social consumption establishment shall notify the commission of any of the following incidents immediately, or if circumstances prevent immediate reporting, no more than 24 hours after the following. Any instance involving the consumption of any marijuana or marijuana product at the social consumption establishment by a consumer that was not purchased from the social consumption, not purchased from the social consumption establishment.
That's inversion. That's inversion, bringing it in from the outside into.
Okay, all right.
And yes, and the amended language is exactly what's in red, is at the social consumption establishment, just for further clarification.
Thank you. No questions, moving on.
We'll be reading subsection 3, any instance involving the consumption of any marijuana or marijuana product from the social consumption establishment being consumed in any area outside the designated consumption area and on the premises. Or, again, this is a clarification change. What we had done is replace a designated sales area or other with any area outside of the designated consumption area and on the premises. Or, oh, I apologize, I'm misreading my own notes. I'm sorry, this is a much, much simpler amendment. It's to add or at the end because that was missing. So I apologize.
Thank you. All right.
Makes it much easier.
Questions or comments, Commissioner Roy?
In the incident reporting, what about service to a minor? Did we account for that? Report to
Meaning if there's service to a minor?
Yeah, service to a minor. I'm wondering if we should do that here, that should be reported to the commission.
I think that, Commissioner Downs, I think that makes sense. Do you think that that makes sense?
I think it makes sense. I would go a little bit beyond service because service is an actual transaction.
Yeah.
It's just access to the premises. You want to be mindful of getting that reported.
Sales, service, or consumption.
Yes. And this is also sort of a practical issue, and this is also, it begs the question for later on when we have to enforce this. It begs the question about our enforcement. Oops, no, someone dropped it off for me. Okay. Anyway. I know my screen just went on and I was afraid that we just lost. Yeah, we just lost service. So it also,
in thinking about this, right? We want to encourage licensees to self-report. And I have seen incidents in the past where licensees we want to do whatever we can in the practical enforcement with ID, that in terms of any sort of system test, we need to do a better job in making sure that our fines, that we don't have 140, diversion of one joint is $140,000, yet it's not equal. We have been, the auditor and the inspector general have both determined that we have unequal treatment, disparate treatment of different licensees. So I think that it also requires us as a commission, as we're putting together guidance, putting together these rules, that we know, have some clarity about what the penalties will be, the fines will be. Because this is one of those things that we're putting this in place and we want to encourage people to self-report. And so I don't know how we do that, Mr. Executive Director, but I know we need to do it. One, because the auditor and the IG have told us that we have to do it. But when I look at this, I want to incent a licensee to do the right thing so that they're not going, oh my God, I'm going to have this huge fine, I want to hide it. So that's just sort of an editorial comment right here in terms of what we have to do, in terms of providing greater clarity and equal enforcement of the law for all our licensees. Again, that's just an editorial comment, but we should add the minors. I think that we've agreed to that. I think that Mr. Stebbins agrees to that. But again, I'm making that editorial comment because I could see someone not wanting to report, and that we need to make sure that we're encouraging that. All set, we can move on.
Thank you, Madam Chair. This is the last amendment under Section 8. Again, this is for incident reporting. Any instance in which the social consumption establishment becomes aware by observation or notice in any form, including but not limited to information from federal, state, or local officials, news organizations, social media, public records, employees, vendors, patrons, insurance companies, and individual or other third parties, regardless of whether such notice is direct, indirect, written, or verbal, that a consumer who patronized the social consumption establishment was arrested for operating under the influence of marijuana as prohibited by Massachusetts General Laws, Chapter 90, Section 24. This amendment is intended to capture what is already captured with respect to alcohol and operating under the influence. So when a defendant is convicted to or pleads guilty to operating under the influence, the judge is required by statute to inquire where they had their last drink, whether it was a public establishment or somewhere private. And so that,
what is that? That's the law is that?
I think it's 94.
No. Whatever do we call it? It's the dram?
Last drink.
Yeah. The dram act. Yeah.
And so, excuse me. And so there's a mechanism for reporting if there's consistent reports of one bar where there's multiple people who have been convicted for operating under the influence, and they're all leaving this one bar.
Right.
And so there's this structure that gets reported to the ABCC automatically through the court process and by statute. And so what we were trying to capture here is another type of process for the commission to receive some information, because right now that statute applies only to alcohol. There is no reporting requirement for marijuana. And that makes sense, of course, because social consumption establishments have not yet existed.
Right.
So there was no public establishment that they would have been leaving. But right now in statute, there is no mandate for that same reporting. So we're trying to build it in here. I know it may seem extensive, but the language is intended to capture, if a social consumption establishment, if they become aware from some Facebook post by the police group that this person was arrested and, they reported that they were leaving Stebbins late night cannabis bar.
I'm operating.
I'm sorry, I'm picking on you.
All right.
Sorry, I'm picking on you. But if they see that on Facebook, this language, even though they're not necessarily notified by law enforcement directly or in writing, that language would require them to report that their knowledge of that arrest to the commission.
So how do you police someone going on Facebook and what they know or should know? I mean, are we implying certain knowledge, saying, oh my God, it was all over Facebook, say that the Stebbins Bar is in Orleans. I am on the Orleans Facebook page. So is Mr. Stebbins supposed to, is there an implied knowledge? We know you're on the Orleans Facebook page. And that's the only concern I would have is it becomes, that's what I get a little concerned about is this seems to go a little bit further. And I don't know what is there imputed knowledge that we're going to be enforcing here? I definitely understand the alcohol issue and the court reporting and what happens, but what are we doing here that you should have known that because it was all out there.
Madam Chair, if I may.
Please, thank you.
Yes, I certainly understand the difficulties of the enforcement side of this. I think this is more about the expectation set on the licensee, is that we are setting the expectation in our regulations that you are going to be reporting to us whether or not you've learned of somebody who's arrested that's left your establishment. We're certainly open to amending the language if it's a bit too expansive, by all means. I think that, there's, in the world today, social media and things of that nature are just so popular. We were trying to capture some of those ways, but I'll certainly let Commissioner Roy.
Yeah, again, this is incident reporting. It's just reporting to us.
Yeah.
No further.
But what they're self-reporting is a violation of law, and we're sort of putting some, which could result in a fine, a penalty, whatever, if they have served someone and someone goes on the Facebook page and says, I'm not quite 21, but I got to go to,
Would you rather them not report it?
No, it's not that I don't want them to report it. I just want to be very careful because we know prosecutors, I just worry about as long as here I see notice. And again, notice could be, well, it was there. You should have. And so the only thing I just want to make sure is that there is no implied responsibility through social media and these other things, that there has to be actual knowledge that in the course of doing business, they notice. I just because we saw this Facebook post, and I know for a fact that all of our people in the I&E team are all over media all across the country when we have to do certain background investigations. So I wouldn't want someone to get in trouble because we had an investigator said, wow, I saw this and you didn't report it to us. So that's my only concern, is what's the level of imputed knowledge that we're going to be. I agree that we have to have them report, but what protects them from overzealous? You should have known that. So Commissioner Stebbins.
Thank you. I appreciate us having a chance to think about this language. I think this might be aligned with what you're talking about, Chair. I start to get a little anxious when they hear from an individual, so-and-so got stopped, and they were at your place last. I mean, we'll start having incident reports come in just because anybody maybe wants to do damage to my, establishment, starts playing on these complaints. Now we're reporting all these complaints. If there was a way to limit it to, they get a notice from a federal, state, or local official, or a public record, or something that just kind of takes the other grouping out of it to make it limited, but it's right. We're not holding a licensee to say, why weren't you perusing social media?
Yeah.
But it's like, you got a notice from the police department.
Right.
Okay, that we ought to know about.
Right. That makes more sense to me.
If I may. So Commissioner Stebbins, I agree with you. So you're proposing strike things that are not like government, like official.
Yeah.
So strike news organizations, social media, employees, vendors, patrons, insurance companies, an individual.
Insurance companies in there. If the insurance company finds out about it and calls you and says, we might up your rate.
Okay, so then conversely, leave in federal, state, and local officials, public records, and insurance companies.
Attorney Baker?
Thank you. I think you could maybe leave employees or change it to agents because that's.
Clarify that for me.
So an agent would be obviously a representative of the business, and if they found out and then they told.
Oh, that makes sense, that this is someone, I've observed it, boss, and we need to take care of that.
Yeah, or I came across this record, this official record. So I think, I mean, maybe instead of employee, it could be agent, but.
Yeah, I think agent is probably a better word.
I do too.
And again, it's really, I just don't want to, at some point in time, say, this was all over the Orleans Facebook page. How did you miss it? And I just don't want to hold them accountable to something like that. That's not official, because I've seen a lot of stuff on the Orleans Facebook page that is not necessarily actionable. So people complaining about different things, so.
If I may, that's very helpful policy input. So we presented something very broad. It's very helpful to have the narrowing. So thank you.
Thank you. Commissioner Roy?
But so they could take into account, so if they happen to see it on the Orleans page.
Yeah.
What if we just leave it included but not limited to? And then we say federal, state, local, insurance. So if they come into additional information outside of those buckets, they can report it.
My only issue is I want them to have knowledge, and I just don't want there to be, you should have known.
And I agree, but so that, I think it accomplishes that.
Okay.
So we leave in including but not limited to what we all agreed on. That I think accomplishes both.
Yeah, and we'll have, and obviously if there is some incident that we become aware of, did you know about that? And they're gonna have to be truthful, so. Okay. Any other comments and questions? If not, moving on.
May, Madam Chair?
Attorney Brewer.
We are on page 106 under section 9, prohibitions. Yes, 106. And we are at 500, 141, 9B. So subsection B. Yes. A social, excuse me, a social consumption establishment shall not permit the sale or consumption of marijuana or marijuana products in violation of 935 CMR 500-160. And that is a pin site to the testing requirements. So this is new language as a whole. It's intended to state that the establishment can't sell any marijuana or marijuana products that have not been properly tested. And that's really getting to the next subsection, which I can read as well, since they really go hand in hand, which is C, infusion or any other method of combining marijuana or marijuana products with food or drink by a marijuana establishment agent at the social consumption establishment is expressly prohibited. Nothing in this section shall prohibit a consumer from infusing their own food or drink with marijuana or marijuana products that have been lawfully purchased at the social consumption establishment. So this, again, is new language. We did receive much public comment as to live on-site infusion. Because of the testing requirements that are mandated before any marijuana or marijuana products are sold or consumed, that live infusion process is just something we can't accomplish under the regs as drafted. And so we felt, the legal team, in response, there was a request for clarification on both sides, for and against. And so we thought it appropriate at this place to include that express language, just for better clarification as a whole.
And she's looking at B and C, so it's for the top of the page right there.
Okay, thank you.
She's read the two. You gotta do that.
I'm good.
Okay. Any comments or questions? Hearing none, we can move on.
All right. The next subsection is D, allow any marijuana establishment agent to consume marijuana or marijuana products during the course of a work shift. This is to add, the amendment was to add marijuana establishment before the term agent, because that is the full defined term.
Thank you. Any comments or questions? I think that makes sense. Go ahead.
The next subsection is E, allow the sale or consumption. Oh, you know what? I'll skip this one because it was to capitalize tobacco.
Oh, okay. So all you're saying is there's just capital T.
Yes.
Okay. Mr. Stubbs, do you have any comments on that? No, you're good. Sorry.
The next subsection is J. And again, we're under prohibitions. A social consumption establishment may not permit marijuana or marijuana products to be sold or served to an intoxicated consumer. The amendment here to the change in language is to mirror the dram shop statute, which is a statute that applies to in the alcohol world, where bars and those types of establishments are prohibited from essentially over-serving their consumers. And so this language was changed to mirror that language in that statute to clearly show that the intent is to have the language be applicable in the same way.
Mr. Stebbins?
Thank you, Chair. And correct me if I'm wrong, this ties back to language that all licensees, at least retailers, have right now, that they can deny sales to a person that they feel is exhibiting impairment, regardless. No test, just like we think you're impaired, we're not selling you anything else.
If I may,
please.
Yes, that's exactly correct, Commissioner Stebbins.
And this is one of the things in practice that I do get a little bit nervous about, given your background, you know, in alcohol and, you know, understanding. I have a skepticism about theory, or theories.
Yes, theories.
So I, you know, and understanding what impairment is. And again, this is just a little bit of editorial. You know, I know that I can go to my local restaurant and I can have my dinner and have 1 or 2 glasses of wine, and I know what impairment is. And given, you know, sort of within 90 minutes, I've probably been able to ingest and my body will metabolize the alcohol in there. So this is the one thing that I do get a little bit nervous about, is that I like wine, you know, I'll drink it alcohol free after. I just like the taste of it. So I don't know. And I think that this is really going to be under our RVT and when we get there, but just understanding that I think that this is going to be difficult for a lot of licensees to do, but we need to do. I don't know what the status or standard is across the country, but I don't know if you have any comments about that. How impairment will be determined, because we know that the tolerance levels, especially when it comes to cannabis, is very widely. So how are we going to do that? Not that I'm asking you, because we still got to figure it out, but it's just, I don't know if you have any commentary, not an answer. Just
yes, Madam Chair.
Thank you.
So I kind of see this as a differentiation from impairment and intoxication. I see impairment as being a scale. You know, how impaired are you? Are you so impaired that you are intoxicated? Because if you're consuming, you're probably going to be impaired in some way, shape, or form, and it's a matter of how impaired have you become. I know with law enforcement, you know, they are looking for the standard things in their training. They go through a training where they're looking for things like bloodshot and glassy eyes and slurred speech, and if they're unsteady on their feet. So those are the types of things that they're looking for. I don't have personal experience in what the RVT training looks like, or even without, even beyond social consumption. But I know that this is something certainly, you know, the country is working to understand as a whole, whether that's beyond drug recognition experts. I know that those protocols and procedures are not necessarily adopted across the country by courts. And so, you know, there is a big push to find a standard as to what is going to be helpful for these agents and bud tenders and police and law enforcement as a whole.
And as a defense attorney.
And as a defense attorney, certainly, yes.
My background is you know, I have a, you know, a concern about how we're going to do it. But again, we don't need to get into that here. We can move on unless there are any comments or questions. Commissioner Roy.
I have a question unrelated to.
Please.
Okay, so you were on J, right? So if we go to I, and it says allow, so the prohibitions, we are prohibiting someone to allow consumption outside of the designated consumption area. So let's go back to the page before, page 105, where I have a big pin. The commissioner at the top of the page on the hard copy, number 2, Commissioner Stebbins was going to work offline. So 2, as it's in a plain reading of 2, is at odds with I, because we're saying a prohibition is allowing consumption outside of a designated consumption, and unless you say my whole sales floor is a designated consumption space. Number 2 is we're saying we need to be a little more prescriptive into and saying a designated space for consumers to know, right? A supplemental on-site consumption license that operates in a marijuana retailer and operates an indoor non-smoking consumption area may continue its retail and operations and may allow social consumption on the sales and service to occur at the same time. But I says only within a designated consumption area can you do it. So this is why I feel we have to go back and say designated consumption area. Does that make sense?
Madam Chair.
Convoluted.
I think that's helpful, Commissioner Roy. And what's funny is I'm reading it a little bit differently. So I think that goes to the point that maybe some clarification is helpful.
Oh, yeah.
I'm reading subsection 2. In the context of that entire section, we discussed how there needs to be a separation of sales and service from smoking consumption areas. And so this particular subsection is stating that there doesn't have to be that separation because there isn't smoking. And so that I'm reading it to mean that that doesn't necessarily mean that.
Yeah, so it's, I mean, there's ambiguity.
Right. So I think that goes to the point is we can certainly clarify.
Okay.
If I could, Attorney Scheffler had his hand raised, but I don't know if we've already covered, if Attorney Bruno, Attorney Scheffler, I saw you raising your hand and there you are.
I just wanted to say that it would theoretically be a legitimate site map if you had the counter where sales take place. That's all limited access, and then the area where everybody's walking around, or you have some tables, couches. You could designate that whole space as a designated consumption area, so people could get their products, sit down, drink, chat, or get up and look at products or things. I do understand. I wanted to echo what Attorney Bruno was saying, though, that we probably could be a little more clear on this point.
Yeah, that's all. There's a little more clarity would be great.
Thank you, Commissioner. Oh, sorry. Yes, you done? Are you done?
Well, yes, no, I'm done on that. And thank you, Attorney Bruno, and thank you, Attorney Scheffler. I had an email from a constituent, and so before we adjourn today, I just want to, I think we're good. It should take like literally less than a minute to go over, but I don't know if you want to save it to the end or.
What do you?
Well, I heard from our friend Devin Alexander, like we all know Devin, and when we talked about the shelf stable products, and we have it in there that a marijuana establishment may sell non-infused water, food, drink items, repackaged. We discussed this before, that delivery operators can be able to do that. And so my understanding is they do fall within a marijuana establishment. So delivery operators. So Devin, if you're listening, the answer, which I, believed, and I said that to him, is that the delivery operators can sell their Doritos.
Oh,
okay. So yeah, that was it. Okay, Devin.
Commissioner Stebbins?
Sure. Quick note to Devin, not yet, but you will be able to. Like, don't start tonight. And just going back to this conversation between that section 2 and allowing consumption outside the designated consumption areas. Again, I think this gets back to the licensee is going to tell us where that designated area is. It's conveying that to the consumer that we need to just marry that language.
Yes. And thank you for saying that immediately. That's the Grenville's example. So we were talking about the place that was the subject of a Supreme Court decision, and all of law students said, yay, good decision. And we all showed up thinking they would have a liquor license the following week. So anyway, it didn't happen. No, it didn't happen. Obviously we didn't do very well in constitutional law or local law. So anyway, all right, moving on.
If I may, Madam Chair. So we are on now page 106. We have made it all the way to section 10, indoor smoking consumption area requirements. So the first subsection that we'll go through here, because we've already covered tobacco, is subsection D. Excuse me. This reads, access to indoor smoking consumption areas are restricted to consumers, marijuana establishment agents, and commission staff. This was again to add marijuana establishment prior to the term agents for that full definition.
Commissioner Wright?
I think we need to broaden this because we're gonna have air handling systems and you might need an emergency HVAC guy to come in, gal to come in, and, you know, so, right, and they're not necessarily a registered agent. So I don't know how we can address that.
So would you like to, how would we address this, Attorneys Baker and Bruno? Do you want to think about it and we can, I know that I'm getting tired right now. So,
Yeah.
you know, I left my house at like 7 this morning. So, you know, it's getting to be a long day and we get a lot through. I'd like to make sure that we can get as much here done so that, and we have some time. So do you want to think about that and we can come back with some language? Commissioner Stebbins, did you have a point?
Thank you, Chair. I was just going to say, you know, designated vendors, invited vendors. I mean,
Integrated business, what is it called now?
yeah, that term. But I mean, that's just under the SAP program. But I mean, we could say contracted vendors. That would cover it.
Are you good with that, Commissioner? Right, contract?
Yeah, because, and they have to sign in anyway, and we need their ID. They have, that all needs to be completed. So, yeah, I think contracted.
Okay, we're good with that language that Commissioner?
The attorneys. Yeah, good, okay.
All right, thank you. All right, no more comments. Thank you, Commissioner Stebbins. Moving on.
Thank you, Madam Chair. Subsection E, marijuana establishment agents shall receive adequate personal protective equipment and the legal amendment will be, shall be provided options to marijuana establishment agent. I'm sorry. Let me back up. I apologize.
Oh, here, I'm looking at the wrong place. Thank you. Glad you're back. Thank you.
See, I knew that. I was.
Yeah, you saw I was looking at it.
E, marijuana establishment agents shall receive adequate personal protective equipment and shall provide options to marijuana establishment agents to view the indoor smoking consumption areas in a smoke-free and vapor-free area. A social consumption establishment shall not prohibit or restrict a marijuana establishment agent from wearing or using personal protective equipment while working in or around an indoor smoking consumption area. That second sentence is new language. We did receive some public comment in regards to this, and we thought that'd be appropriate so that any ME agent who would like to wear PPE who's working in these areas can't be prohibited from doing so.
Hearing no comments, let's move on.
The next subsection is F, and just to preface, these are the requirements for the ventilation and filtration systems. A social consumption establishments with an indoor smoking consumption area shall include 1, a ventilation system with the indoor smoking consumption area that shall maintain negative air pressure relative to adjacent spaces at all times of operation. I can speak to this if
please. Yeah.
So the negative air pressure within the indoor smoking area is meant to kind of keep the smoke going through the ventilation system and pulling it in towards the indoor smoking area. So if there's adjacent areas and smoke is escaping through the doorway or whatnot, think of it sort of like the fan in your bathroom and it's sucking up the steam. And so it's pulling that smoke into the filtration system, the negative pressure aspect.
Thank you. Any questions or comments? Hearing none, moving on.
2, a separate ventilation system within the indoor smoking consumption area capable of 20 complete air changes per hour at a minimum. Excess air required to create negative air pressure volume must be directly exhausted to the outdoors in compliance with all applicable building codes and building and fire codes and environmental regulations. Excuse me.
Commissioner Roy, hold on. Commissioner Roy?
Attorney Bruno,
Yes.
I'm wondering if we should add shall be in front of capable to be consistent, because we have shall in number 1, shall maintain negative air pressure. So in number 2, a separate ventilation system with indoor smoking consumption air shall be capable of 20 complete air changes per hour at a minimum.
Are you including language before then?
Yeah, so that, like, number 1 says shall maintain. So I'm wondering if we should say shall be capable in number 2. Number 1C says shall. Yeah, so number 1 says shall maintain negative air pressure. Number 2 just says capable of, shall be capable. I'm just for consistency.
But
Oh, I was just going to, Madam Chair, if I may, I'm just going to say, yes, I see your point. I think that's certainly
Okay, yeah, thank you.
thanks. Moving on.
I'm sorry, Madam Chair, I just want to clarify, are there any questions as to that section?
Yes, thank you. Commissioner Stebbins, is this, you had mentioned about the at one point, I know you had done research on this. Are you comfortable with this? The 20 complete air changes? I know you had done some research around this.
Yes, and the upcoming discussion on the filter rating as well.
Okay.
I think 20 we're okay with.
Great. Okay, thank you.
3, a separate system within the rest of the social consumption establishment that shall be capable of 6 complete air changes per hour at a minimum. Excess air required to create negative pressure volume must be directly exhausted to the outdoors in compliance with all applicable building and fire codes and environmental regulations. This is a new subsection, which again came from some public comment to provide some sort of additional ventilation and filtration for adjacent areas. So when you think of, for example, hospitals and their surgery rooms that have very, very much more stricter standards for those areas, their waiting rooms also have a certain air changes per hour and ventilation requirements. And so this again goes to whether if there's any smoke escaping those indoor smoking areas, it's being addressed through this 6 air changes per hour. The 6 air changes was appropriate pursuant to the ASHRAE standards, in addition to some other expansive public comments that we saw come out of Nevada and their regulations that have come out. They've adopted the same standard, which they found appropriate.
Thank you. Any comments or questions? And obviously it is going to take us a while to implement this. And as I'm assuming that in the next year, technology, whether it's ultraviolet or, a number of different things, it may, be a new market may be there to help solve some of these problems. And then we might have time to make any changes if needed. So moving on.
Actually, I do. I just have more commentary than a question. So, and right, I agree. We want to keep the space where the consumption is happening, the air is clean as possible, and we want the adjacent air for employees to be as healthy and clean as possible. So I agree with all of that. And we all know that these air handling systems are not free and they are expensive. And so now we just added the burden of another air handling system. So what I would say is when we get to partnerships and joint venture agreements, and so just keep an open mind when I'm going to propose around general partnerships, what that could look like to increase access to capital. So everybody just kind of keep an open mind when we get to that point, because now we have an additional air handling requirement, which is not going to be cheap. So that's just kind of greasing the skids for that.
And again, given all the time and attention looking at this, we don't want this to be crap cooperative. No, we know how many people have gone for a social equity program. We know how many social equity licenses are in commence operations. So we want to make sure that it is something for people to make money. That's the whole point, making money. So. Thank you. Attorney Bruno, moving on.
Thank you. So we'll be moving on to number 4, and Commissioner Roy, with that in mind, this next language will certainly help affect or try to reduce the cost. A minimum efficiency reporting value, MERV, 14 or higher filtration system capable of handling the entire volume of air within the indoor smoking consumption area, or an equivalent system pursuant to 935 CMR 500 14110H, which is a pin site to an alternate ventilation and filtration option, which we can discuss more in a moment. So this language, previously in the prior draft, there was technical standards housed under written policies and procedures that were different from the location and the regs that we are right now. So the prior draft had HEPA, a HEPA standard, versus this MERV standard. HEPA is like the absolute highest high standard.
HEPA is all we were talking about 5 years ago.
Yes.
Right.
And it is very, very costly, and from a implementation standpoint, from a maintenance standpoint, with the cost of how much filters are to replace and that they require much more consistent replacement. Also the energy required to maintain that system, it's actually significant. And so in researching this section and with the public comment significantly, the MERV, which was the other standard that was already within the regulation, what we've proposed is the MERV standard of 14 or higher, which is still incredibly protective of public health, but it is a much more cost-effective program or standard that we hope will be more accessible for people who are hoping to have an indoor smoking consumption area. This is something that Nevada actually had taken a look at. So in the state of Nevada, their social consumption or their equivalent cannabis lounge regulations started off first with the HEPA standard, and their stakeholders found it so overly burdensome that the regulators came back in 2023. They revised specifically only the ventilation and filtration requirements. And so they came to the conclusion that a MERV 14 or higher would be sufficient to protect public health and safety, while also being mindful of the need for economic feasibility. And so we, as a legal team, found it with the public comment appropriate, and with it already being something that was proposed in the regulations previously, to propose this standard.
Commissioner Ray, you placed something in here. She has placed into the comments some information about rating charts for efficiency, I guess, of filtration. Is there anything you want to comment here? You're just sharing that with her.
Well, yeah, I'm just sharing that, and it says the MERV filters are effective for capturing cannabis dust and other particulates, with higher MERV ratings offering better efficiency for finer particles. For cannabis grow, MERV 11 through 13 is often recommended. So we have MERV 14. Does that mean it's less efficient than an 11 through 13?
If I may, Madam Chair.
Please, thank you.
14 is higher, so it's one step above.
Better.
Yes.
So more stringent.
Yes.
More. Okay. Yep. Okay. And then just Attorney Bruno, if we could add shall be.
Oh, yes.
Cool.
Thank you.
Thank you.
Moving on and restate where we are again. Sure.
Excuse me. Thank you, Madam Chair. Yes, we are at the bottom of 106. We are at section 10 F5.
Okay, here we go. Yep, I see it.
Odor control equipment sufficient to mitigate cannabis odor from being detected at the property line. This language was previously under the written policies and procedures where there were technical standards housed, and we've just brought it down to the actual technical standards section.
Thank you.
And also,
go ahead, Attorney Baker.
thank you, sorry. And also it went from eliminate cannabis odor to mitigate cannabis odor.
Yeah,
So,
you're not going to eliminate it.
right.
Yeah. But this is also, and as a former town manager, this is a municipal issue, and they're going to figure out where this is, how people, I mean, you know, how this is going to impact the community. So it's something that we will be providing wide latitude for the local officials to do that. Okay, moving on.
So we are now at subsection G, which will go past into page 107. Prior to final licensure, a social consumption establishment with an indoor smoking consumption area shall demonstrate compliance with 935 CMR 500 140 110 by submitting a ventilation and filtration compliance letter prepared by a Massachusetts licensed mechanical engineer supporting documentation. This subsection as a whole is new language. With the ventilation and filtration requirements set forth and with the public comment, we thought it appropriate to include a way for the commission to see that the ventilation and filtration system setup is actually in compliance with the regulations. So a professional who does this type of work, a licensed mechanical engineer, is going to be signing a letter that this complies. That's their license on the line, so they would be responsible for that certification. This is somewhat of a policy decision for the board if that's something you would like to require. I'll leave it at that.
I'm happy with it too, but this is also one of the things that this could be potential and additional business opportunity for persons to be ancillary businesses. That this is something that not that we have to do this obviously right now, but it's also making sure that if we are requiring certain vendors and expertise, it might be a good idea in 12 or 18 months that we create some of those opportunities for people to find those people that appropriately. So I don't know, in terms of this definition of what that established expertise is, I'm assuming that there's some standard out there, but that would be the one thing I would want to make sure that in the long term, Executive Director.
It's interesting, and I would note under H where it references the executive director. I'd like to come back to that, but it is interesting because building inspectors and building commissioners in Massachusetts since legalization have had to, in certain instances, basically rely on licensed mechanical engineers' stamps because it's not normally within their wheelhouse to do some of these odor mitigation and ventilation issues. So it seems like building commissioners might be doing the same. I don't think that that's duplicating. I think it means that we're probably accepting something that some of these businesses are already having to do for municipalities. So I think it probably might actually create an efficiency for businesses. But it is something that has kind of become a standard at the municipal level, where building commissioners are looking for these stamps from these engineers as well.
Thank you. Commissioner Roy?
I hate to do this, but can we go back to page 106, number 5?
105?
Number 5 on page 106, where it says odor control equipment sufficient to mitigate cannabis odor from being detected at the property line. I'd like to require an odor management plan. And also the property line. So if you're in a strip mall, how does that help your abutters? So I'm wondering if it should be premises versus property line.
But is this for us or the municipality to do?
This is indoor smoking consumption requirements.
Mm-hmm. So when I read 5, odor, so you're saying like we're mandating odor mitigation
at the property line, and I'm saying if you have abutters.
Oh, I'm missing. So your point is with property line?
I have 2 points. Property line, I don't know if that's sufficient enough. If I can think of multiple scenarios where there's like carpet store next to a cannabis, and they share the property line. So I'm shopping for carpets, and carpets ain't gonna stink like weed.
But are we assuming? And aren't we assuming that this odor mitigation that the municipality? Well, I don't think there's again, given my experience, it's my understanding that don't we already require some sort of odor mitigation, or is that, in my experience, I remember submitting a plan regarding odor mitigation for farm, right?
To the commission or to the city?
The city.
The city, right. So I'd like, you guys agree, I'd like to have an odor management plan.
Attorney Baker.
Thank you very much. Friendly amendment would be just that we have all the SOPs under 141.2.
Yeah.
And if you're thinking about this, I would just recommend putting it in there. But I also see agency Striffler.
Yes.
There's consent.
Attorney Scheffler, sorry, and I am trying to keep an eye out for you. Sorry about that.
No worries. Thank you, Madam Chair. Just a little bit of context as to where this language originally came from. In the host community agreements, there has been language in there that is extremely common of, odor mitigation technology sufficient to end it at the property line. So a lot of this was borrowed from, taken from an extremely common and very frequently seen provision in host community agreements, which may speak to where municipalities play a part in this relationship. I just thought that might be helpful.
Thank you, Commissioner Roy.
And it is somewhat, but this is a whole new animal, if you will. This is consumption versus just a grow. So I don't know if property line is sufficient and we need to say premises. I'm just trying to be mindful of abutters.
But do we care premises versus property line? I understand Attorney Scheffler's point, but if we say premises versus property line, are we kind of saying the same thing, but putting a tighter rope around what we're going to suggest the municipalities do? Attorney Baker.
Thank you, Madam Chair. I think that property line would be a larger footprint than premises.
Good point, exactly.
So wouldn't, are you advocating for leaving it at property line?
No, as advocating for switching it to premises.
To premises? Okay.
Yeah. You're going to have some folks in heavily dense urban areas. And I'm just trying to be mindful of that. And I don't know if the property line does it. So that's why I'm putting premises in.
I don't think premises is going to ruin anything. And I think that it's going to be up to municipalities. I mean, just like where you look at where most of the municipalities initially allowed under zoning laws where you could not have cannabis. They're all in the outskirts and, off and away from residential areas. So I don't think that premises is going to mess anything up unless you think that, Commissioner Stebbins?
Yeah. Thank you, Chair. It does bring me back because I'm wondering where else we use premises, like designated premises. It might be within the property line. So it's the actual area where consumption is happening.
That's right.
May not align with the property line.
Right.
Executive Director.
Thank you, Madam Chair. Just to understand the point, I think it's more beneficial to the business to be held to the property line than to the premises, because the buffer in some of these instances of how they may be not allowing their odor to impact neighbors might be within the difference between the premises line and the property line, right? So potentially distance between the premises line and the property line is part of their mitigation. So I would think that they would rather be held to, we're going to make sure that odor doesn't go past the property line rather than the premises. I might be misunderstanding your question.
Yes, I think so. I'm talking about their folks that sit within the same property line. How does that help them?
But won't the municipality, so we put together, did we say we're going to do an odor? I can't. An odor mitigation plan
under the SOP.
And but with the municipalities, again, I just haven't gone through this process. There was absolute intention that the city, and we're talking an outdoor cannabis grow and we put together a plan for odor mitigation, like talking about putting plants around, you know what I mean? And that's outdoors. So I'm just, not that I disagree, but I just want to make sure that we're not being, what would be Executive Director, if you could just restate why this would be problematic to do premises versus property line, because my sense is that of the handful of communities that are seeking to bring this into their footprint, into their community, that they're going to be very, very cautious in terms of how they impact their neighbors. People will be able to, if they're going to be abutters, they can say, you know what I mean? Any abutter, it doesn't have to be a property line, but I'm assuming any abutter, even a, I mean, do you think that someone that is in the same building, in the same property, is going to have an opportunity to, you know what I'm saying?
I think that my experience, if I may, going to different communities, they are looking to us. And we're the experts and they're looking to us. So I just think that, you know, people thought, but when cannabis first was voted in by the will of the voters, that there were going to be all these crazy impacts that never materialized. But the one that some communities struggle with is the odor.
Yeah.
And so, I've heard it. So I think this actually protects the licensee because they've done everything. They've provided us an odor mitigation plan. So I just think going the extra step will save a lot of, how do I say this, problems.
And a lot of the headaches are going to be managed by the municipalities themselves. And they allow these things in their community. They're going to be people coming out, and so maybe by having that higher standard.
I think a higher standard is going to save some aggravation down the road.
Commissioner Stebbins, do you have any objections to that? And again, I hear what Commissioner Roy is saying, but I guess do you have any concerns or premises versus property line?
Thank you, Madam Chair. I certainly agree. I like the idea of the odor mitigation plan being folded into some of the SOPs, as Deputy GC Baker suggested. But I think I'm where you are. There's the municipal piece of this, and again, balancing what I think is a legal definition of premises versus the property line. So that's where I'm.
And where did we get stuck?
Property line is open air. It's going to dissipate. It's going to, and it's like the premises is, if you have a butters.
So what you're saying is that you're concerned that I don't know. I mean, I'm thinking of I've never been, but I know that there is a retailer that's on Route 18 in Abington, and it's off in an industrial park. And I think of those big corrugated, those big metal buildings.
Right.
So what I think I'm hearing you say as an example is that in those buildings, a lot of CrossFit. They got, you know what I mean?
Right.
Maybe there's.
That's right.
And
that's
so
my point.
We're talking about the property line, but what's leaking?
That's what I'm trying to say. And we got rid of the word eliminate and we used mitigate. So we lowered that standard. So
your CrossFit athletes.
Right.
Next, worried about that.
I'm worried about the CrossFit athletes. Yeah.
Oh, sorry, Schroeffler. Sorry, thank you.
Thank you, Madam Chair. I just wanted to, I had a past life where I did a lot of land use and appeared before a lot of local boards. And when we are setting a floor, which is what this would be, we may be stepping on the toes of local planning boards or those creating HCAs. As I mentioned, this language was largely borrowed from existing HCAs. So towns are already doing this and imposing it as a obligation on the municipal level. So this may be something where we're creating an obligation where a city or town doesn't even want it. And abutters may also, there may be a bite of the apple for them at the planning board stage where they get noticed this is going in. Hey, I'm going to come in. I'm running the carpet store next door. I'm really concerned this is going to affect my business. I just wanted to flag that as a potential legal issue vis-a-vis local government.
All right. I would love to get a little bit more input from maybe some some of the folk from, I don't know, it's the MMA but I would love to, just because I'm not, I understand Commissioner Roy's concern. I don't disagree. And again, I'm thinking, I'm trying, I visually, I can understand. But I also think that having been through and listening to Attorney Schreffler, having been through, I know that the city of Greenfield at least was very prescriptive, you know, in an open air setting about odor mitigation. So I'd love to, only because it is getting late and I want to see if we can get through this. Can we maybe get a little bit of feedback from the MMA or from, you know, some larger communities to make sure that we're not going to be stepping on their ability to do that, and whether they would welcome this, or is this part of guidance where we can say to municipalities, hey, you really need to be thinking not only about the property line, but making sure that you do this. So can we get some feedback?
And I agree with, and I've said, well, the other thing in my mind is mixed use property. Yeah. And maybe there are residents that can't afford to get an attorney to fight odor, or, you know, so, you know, not everybody has access to argue, or, you know, and I'm like, just thinking, there's mixed use buildings too.
I hear you, but I'm also thinking practically. What I've seen so far from municipalities is they have pushed to sidelines. You know, most of our cannabis, not most, but a significant. They're pushed into the urban. I mean, the parks, the industrial,
the outskirts.
Right, the outskirts. So
right.
they've already done that by their zoning in many instances. So could we just? I do think I want to take into consideration your concern, but I also hear the executive directors.
Just one more point, if I may. Sorry, thank you, and I won't belabor this anymore. But what I was hearing on these municipal tours is there's a different lens, and they want them near the mass transit and the bus stops, and they're going to move them into the. So this is what I'm saying. So,
all right, could we move on? Could we ask our legal team to maybe get some feedback from the MMA about how practically this would work, and to make sure that if indeed we are with an eye towards not having intoxicated people out and driving and needing that transportation plan, it's obviously going to be potentially near probably more densely populated areas and cheap to gel with other tenants. So if we could just get some feedback, and then we can move forward. So anyway, I appreciate that. That's what we're here for.
That's right.
To make sure
we can't do this behind closed doors, right? Law, so it gets long.
But if we can move on, and I do think that this is one of those things that if we get a little bit more information, it'll help color our conversation. Go ahead, Commissioner Attorney Bruno.
Absolutely, Madam Chair. I just want to reorient us, and we are. I need that a lot sometimes. I guess I'm reorienting myself. I didn't realize that.
That's while you're reorienting. So looking at the clock at 5:10, what is your informed opinion? You know, where, so we're sort of finishing. What is your informed opinion about how much longer you think this could take? And again, I just want to be mindful of anybody's needs to get on the road, get dinner if you haven't had lunch. So. And I don't, I think we already, and I will say to the remaining 49 attendees who are watching this, that we are going to be meeting next week on the 29th. We have a tentatively scheduled, or we are putting a hold for November 7th. And we will take enough time to get this done right. And that's right. Been my mantra, that we don't want to do this quickly. We want to get it right. So just letting the public know, you know, we'd initially thought that this could be done in 2 days, and I see where we're going now. We're not even getting to the meat of things. So just letting people know, we definitely are having one more meeting. We have already put a rope around an additional day, and if we need another day to tie everything up. What we're gonna do, I don't want any pressure from people getting this done fast because we've been waiting for years to get this done. We're gonna get it done as, not perfect, but as good as we possibly can. So recognizing that.
Mike Baker.
That point.
TGC Baker.
Just gonna say, hey, Mike.
Yeah, no problem. I know it's a long day. I think this is a good place to wrap.
Yeah. So I'm really tired right now, and I know that the staff, and again, I work lunch, and I don't know about anybody else, although I appreciate Kate Flanagan giving me some wonderful sun chips. So
Oh, those are good, yeah.
Those are the best. So, and they were shelf stable, and they were awesome.
And not infused.
Not infused.
Shelf stable.
Awesome.
And if I may, Chair, I just want to thank everybody. A long day. Attorney Bruno, you did fabulous. Thank you so much. And DGC, we must be so, because I felt it always fell on you, all of it. And so this must be great feeling for you to have such an incredible colleague here. And you guys put so much work into this. And this little map key was so helpful. Again, I've said it multiple times, but thank you for all of your work to help us work through this.
So gaining consensus, I think that if we need to add additional meetings in November, we will do that. And there are other items that we need to address. So obviously there's a lot going on. There are licensees that are certainly waiting in the queue to either get approved or, reapproved, or renewed. So Executive Director.
Thank you, Madam Chair. Just to note, we had a motion earlier today that we will be having a listening session on November 6th, and we'll get information on that as soon as possible. Just to note that for what's on the screen.
And everything's in person, right?
Yes, there obviously it's hybrid, so there may be, some opportunities, but it will be in person, but obviously people can. I know that there are some folks that have different, because we are just trying to see if we can get this done. It's no promise that this is going to be a Christmas present, but it is our intent that we would like to get this wrapped up certainly before the the end of the year, before the holidays. And there is a process that we have to get this done, then we get it to the Secretary of State's office, but that is our intent to get that done. All right. If there are any comments or questions from my fellow commissioners, and if there are not, I will entertain a motion, Commissioner Stebbins, to adjourn.
So moved.
Will you second that motion?
Second.
Having been moved and seconded, I'll take call the roll. Chair votes aye to adjourn. Commissioner Stebbins?
Aye.
Commissioner Roy?
Aye.
We are adjourned.
All right, folks. My name is Grant Smith Ellis. Thanks very much. We're back October 29th. So we are back next Wednesday to finish this up. And thanks very much for tuning in. If you missed it, we didn't get through the full social consumption drafting. The commission is barreling forward. They worked for 8 long hours today. Events are going to be regulated. They need host community agreements. It was a very interesting day. Unfortunately, no movement on the disproportionate area impact report. That will be taken up at a November 6th public meeting or public comment session, and I'll have more to say about that in the coming days. Until we see each other again, my name's Grant Smith Ellis. God bless you. Thank you for supporting Towel Channel, and if you benefited from today's coverage, help keep Little Towel alive. Also do a small act of service and kindness and try to help our veterans. Everyone needs help right now. God bless, friends. Until next time. And thanks to all 12,000 of you who watched over on the Towel X today. Towel loves you very much.